All right, good morning, everyone. We're going to go on the record now. We will not start the broadcast here for a moment while I make a few All right, good morning, everyone. We're on the record on Fremont County case CR 2221-1623, State of Idaho versus Chad Daybell. I'll note that the attorneys are present. The state is here, represented by the prosecution, the defense, and the defendant. I'll further introduce them in a moment. Is the state ready to proceed this morning?
Yes, Your Honor. Thank you.
Is the defense ready to proceed?
Yes, Your Honor. Thank you.
Thank you. Before we begin with further voir dire examination, let me inquire of the state, is there any objection to the manner in which the jury panel has been recalled and seated today?
No, Your Honor.
Any objection from the defense?
No, Your Honor. Thank you.
Thank you, counsel. Ladies and gentlemen of the jury, then thank you for returning this morning. You've been recalled as prospective jurors in this case now before us. I'll again reintroduce my court staff. My name is Stephen W. Boyce. I'm the district judge of Fremont County, Idaho. I'm in charge of the courtroom in this trial. Court clerk here assisting today is Shannon Holstein. She's taking minutes of the proceedings and will be administering oaths to you this morning as well. The marshals here assisting with courtroom order and helping the jury movement are Steve Holmes, Ken Daish, and James Ravello. Court reporter this morning is Mary Fox, who's taking a stenographic record of everything said during the trial proceedings. And my staff attorney is Courtney Stallings, who's seated to the far right over there at a table. She assists me from time to time with legal research and administrative issues. Each of you, 16 jurors here, have been qualified to serve as a juror of this court, and each of you filled out a questionnaire that's been reviewed now by counsel in the court. And it was determined to recall you for further questioning. The thing we're doing in this trial at this stage is to select a total of 18 jurors, comprising 12 jurors and 6 alternates from among you. At this time, the clerk will now read a roll call of the jury, not referring by name, but referring by your red card number. So I'll have the clerk do that. If you would just hold your number up once your number is called, we'll make sure we all know where you're seated and that this is the proper seating for this group.
Once I call your number, if you can audibly answer that you're present. Juror number 11. Say present. Present. Juror number 27. Present. Juror number 31. Present. Juror number 41. Present. Juror number 48.
Present.
Juror number 56.
Present.
Juror number 67.
Present.
Juror number 121. Juror number 146. Juror number 186.
Present.
Juror number 219.
Present.
Juror number 249. Juror number 296. Juror number 321.
Present.
Juror number 348. Juror 394.
Present.
Thank you.
All right, to assist you in understanding and participating in the jury selection process, I'll now reintroduce you to the parties and their attorneys and briefly summarize what this case is about. When I introduce an individual, please stand and briefly face the jury panel, then take your seat. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state's represented in this trial by Lindsay Blake, Fremont County prosecutor. Rob Wood is the Madison County prosecutor, and special assistant prosecutors Ingrid Beatty and Rocky Wixom. The defendant in this case is Chad Daybell, who's represented by his attorney John Pryor. This case is a criminal matter, which means the defendant is charged by the state of Idaho with the violation of the law. I previously read to you a summary of the charges in the amended indictment, and you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho alleges that Chad Daybell committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception, count 2, first-degree murder, count 3, conspiracy to commit first-degree murder and grand theft by deception, count 4, first-degree murder, count 5, conspiracy to commit first-degree murder, count 6, first-degree murder, count 7, insurance fraud, count 9, insurance fraud. Mr. Daybell has pled not guilty to these charges. Please remember, this is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next discuss your duty as jurors. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. This time, I'll instruct the clerk to administer an oath to the jury panel. The clerk will now swear the entire jury panel for this voir dire examination. If each of you would please stand and raise your right hand.
You solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the Cross Island trial, so help you God.
Thank you. Please be seated. I'll note that each juror took the oath just now. Clerk has impaneled 16 prospective jurors for questioning in small groups today. We've gone through their roll call as well. At this time, I'll ask the state, will the state stipulate that the jurors were properly called and impaneled today?
Yes, Your Honor. Thank you.
Will the defense stipulate as well?
Yes, Your Honor, thank you.
All right, thank you, counsel. Next, I'll inquire of the marshals here. I did require that the jurors complete a jury affirmation that they've not gone back to review or investigate the case since they filled out the questionnaires. Did each juror complete an affirmation?
Yes, Your Honor.
Okay, thank you for following the court's admonishment and completing your affirmation today. In this part of the jury selection process, then you'll be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter of this trial. The object is to obtain 12 trial jurors who will impartially try the issues of this case upon the evidence presented in the courtroom without being influenced by other factors. Please understand this questioning is not for the purpose of prying into your affairs for personal reasons, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your hand. When called upon to speak, please identify yourself by that red card number you have. Because these proceedings are being stenographically recorded by a court reporter, also please speak clearly and give audible answers such as yes or no, rather than, for example, nodding your head. In addition, please wait for the person you are addressing to finish the sentence before speaking, so the court reporter doesn't have to deal with two people speaking at the same time. Importantly, if you have any answer to questions and other questions I'll identify that will either be embarrassing for you to answer publicly or you think are best answered in a more private setting, the court will arrange that. Similarly, if you have an answer that you think could prejudice other prospective jurors, for example, of information you may know about this case, please refrain from discussing that in front of the other jurors, and we will talk to you about that individually as well, outside of the presence of the other jurors. As I mentioned then, if you have knowledge of this case from pretrial media or coverage or publicity, please don't discuss any specific facts of that in front of the other jurors. And there is a special instruction that's been given in this case, which I'll now give to each of you together. And the special instruction is as follows. The defendant, Chad Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the court's special instruction. At this time, I would also instruct the attorneys for both parties to avoid repeating any questions already asked by the court. The attorneys do, however, have the right to direct follow-up questions to a juror regarding a juror's response to the court's previous questions. The jury should be aware that during and following this voir dire examination, one or more of you may be challenged. Each side has challenges, what are called for cause. That means they can ask that a juror be excused for some specific reason. Later, there will also be what are called peremptory challenges, and that means each side can challenge a juror and ask they be excused without giving any reason for the dismissal. If you are excused by either side, please do not feel offended or feel your honesty or integrity has been questioned, because it is not. I'll now begin the court's portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own voir dire inquiries. Those of you who are not called should pay close attention to the questions being asked here, because you may be later called upon to answer those same questions. First question I'll ask you all as a group, when you completed your questionnaire last week, I'm going back to that. Are the answers given by each of you in the jury information forms true and accurate still? Okay, everyone's answered affirmatively. Let's next talk about the issue of the time commitment that may be required in the trial in this case. If you are required to serve as a juror here, it will be for a period of approximately 8 to 10 weeks. Would this time frame create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case? Is there anyone that has a response for that question?
Yes, sir.
Okay. Please raise your red card. Juror number 249, express your concern, please, regarding the timing of the trial.
My work only allows approximately 80 hours paid time. After that, it will be all entirely work for having pay.
Okay. And are we going to have a roving microphone perhaps for jurors? If not, we can get one set up for the next group. Juror number 249, I was able to hear your concern about limited time frame involving work. Have you had an opportunity to discuss if they've got any other policy, if you are in a longer trial such as this case, that may allow for additional time off if you were required to serve?
I did read the policy, but because I just found out about this late last week, that I was selected. I simply went online for our policy, our team member handbook, and read up on it because I was concerned that this was going to be a long time. So I double checked the policy, and that's what it states. 80 hours.
All right. Given the concern at this point, let me pass over first to the state and then the defense. If you have any additional voir dire at this time, specifically on the issue of a potential hardship for juror 249.
And Your Honor, the state actually did have a question regarding a potential hardship with regard to juror 249. It's one that hasn't been talked about, but on the questionnaire, there was an indication that there was a May camping trip planned, but we just didn't have a lot of details. So we had actually planned on inquiring further regarding that hardship.
Okay.
If the court wants to get into that. The state does not have an objection given what he's indicating his work policy is either.
Okay, well, I'll allow you to return to that issue then in your individual voir dire. Juror number 249, I'll let the attorneys come back to you in their portion of voir dire to further question the hardship issue you've raised. Is there anyone else that would also express a concern of hardship if they were required to serve for that time frame?
Yes.
Okay, we've got a few more. Juror numbers 67.
I'm a sole provider in my family. My wife has an autoimmune disorder, and so
Check. It would be difficult for me to do this, and I'd be losing out on a lot of money, and my job also would probably lay me off because I'm an alarm operator and they're already short-staffed. That's what I was told.
When you say that's what you were told, did you discuss the potential of having to serve in this case since you filled out your questionnaire?
Yes.
And could you be a little more specific about your, you don't need to name it, but the occupation and what your employer may have related to you?
The occupation is with alarm codes. I was on the central station, so I just answer a lot of alarms for places all over the country. And what I was told is that they're extremely short-staffed. If I was gone for 10 weeks, they would probably have to let me go because they'd have to have somebody else take my place.
All right, with that particular concern raised, I am going to pass over for additional questioning at this time from both the state and then the defense. Does the state have any further questions for this juror number 67 in regards to the stated hardship?
We don't have any further questions, Your Honor. We would have no objection to this juror being excused based on the hardship expressed today.
All right, from the defense then, Mr. Pryor.
Judge, there'd be no objection to having this juror excused.
All right, well, juror 67, if you are facing loss of employment over this, the court would find that would qualify as an undue hardship that would prevent your service in this case, given the length of the trial. So the court thanks you for your service for coming in this morning. I'll allow you to be excused. Please drop off your copy of your questionnaire with the bailiff on your way. I believe juror 348 raised their card as well. Juror 348, you've heard the questioning about the trial length. What's the issue you would have in relation to that? Let's get the mic to you.
We have two family events that will transpire during this time or directly after, one of which is my daughter's graduation from college. I did note these on the questionnaire in the circumstances with her graduation. That would be at the beginning of May. We were not able to have any kind of graduation celebration for her from high school, as that was 2020. So we were all looking forward to that as something we would all participate in as well. My mother passed away in February, and I am responsible as executor for her estate to prepare documents. I'm working with lawyers on the East Coast, which makes it a challenge as far as the time difference is concerned, as well as planning for her service, which will take place in June. Again, that is taking place on the East Coast. And I am responsible for planning that event as well. So those are the two circumstances as I noted on the questionnaire.
And could you specify again, is it the first weekend of May that the graduation would take place? Is that on weekdays or is that going to be on the weekend?
The graduation takes place on a Friday. That would also involve transportation down on either Wednesday or Thursday as it's out of state.
All right, council, I'm gonna again inquire of you. I know we're skipping ahead. You'll get your own individual voir dire, but on the narrow issue of a hardship expressed with juror 348, does the state have any additional inquiry?
No, Your Honor, we would have no objection to this juror being excused. I do know on the questionnaire, she had indicated the graduation would be the first weekend of May, including Thursday to Sunday.
All right, any voir dire from the defense on the issue?
No, Judge, I was also aware that she had the obligations that required her to travel out of town. Also,
Okay, well, between the combination of that planned graduation and your services as executor of an estate and that both being expressed in your sworn questionnaire, the court does find there's a rationale here for dismissal based on a hardship given the length of the trial and the timing. So juror 348, you can be excused with the thanks of the court. Thank you for providing your service here up to this point, and please drop your questionnaire off on your way out with the bailiff. Were there any other jurors that had an expressed concern over a hardship at this point? Okay, juror number 321.
I have not looked into the policy as far as like the amount of time, but it would be a financial hardship if that length amount of time without me working.
All right, I'm going to note juror 321 that you've expressed a concern over hardship. I'll pass on that at this time and allow for the attorneys to conduct some individual voir dire further on the topic if they so wish. So we'll come back to that. Anyone else have a concern? Juror number 296.
Good morning, Your Honor. I am currently in school on Mondays and Wednesdays, and CWI would conflict for the next 5 weeks. I put on my questionnaire that it's possible that I could take online courses or switch to an online course, but not entirely sure of that policy.
Okay, I will note your concern as well. I'm going to allow for some additional voir dire from the parties before we make a determination on that. Anyone else have a stated concern for the hardship? Okay, thank you. Let me next discuss any previous knowledge you may have of this case. As I mentioned before, if you do know something specific that you've heard in the media or otherwise, please refrain from stating specific facts about that, but we do want to go into that issue. So first, let me see, I guess, by raise of your cards, other than what you were told when you came in to fill out that questionnaire and further advice today, do you know anything about this case, either through your own personal knowledge or by discussions with anyone else or from media information you've received? Is there anyone that knows about the case? Okay, if you'll hold those up for a moment, we'll know. So we've got juror 321. The question generally is just, do you know something about this case other than what you've learned by coming in for the questionnaire last week or today? All right, so on the back row, 321, 296, 219, 249, 146, 121. On the front row, we've got jurors 56, 48, 41, 31, and 27. So the majority of the group here, which is why I give that instruction. What we don't want to do is start seeing what everyone knows about the case. We'll talk to you individually about that. Let me ask some specific questions for you then without getting into those details, but then is there anyone here that believes they already have a state of mind with regard to the charges or some knowledge you already have about the case that would prevent you from being impartial in this case? In other words, has anyone you think already drawn some opinion that maybe the defendant is guilty just based on what you know or what the charges are? All right, we've got a juror number 121 who brought that concern up. In order to further get into that discussion, we'll talk to you individually so we can delve into that. Anyone else that thinks they've already perhaps made their mind up in some way about guilt or innocence in this case? All right, we've also got juror number 48. We will discuss that with you individually as well. For those of you that do know something about the case, the next question is, do you feel you could eliminate or disregard what you've heard or read pertaining to the case and render an impartial verdict based solely on the evidence you hear in court today? All right, the remaining jurors then indicate they would be able to do that, and I'll allow the attorneys to follow up with voir dire on that subject.
Judge, could we approach for all of those?
Certainly. All right. We're back on the record now, continuing for this group. Next issue the court's going to talk about with the prospective jurors is the subject matter of this case. Court has read to you a summary of the charges. Those include charges involving murder, conspiracy, and insurance fraud. Is there anything in particular about those charges for any one of you that would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and to render a fair and impartial verdict? So the question is, would that make it impossible or difficult? If that is the way you feel, please raise your red card. Okay, none of the jurors responded affirmatively to that. I next have some questions that may seem obvious, but they're required by our statutes for me to go through as well. Let's talk about relation or acquaintance to the defendant. Are any of you related by blood or marriage to the defendant, Mr. Daybell? Or do you know him or her from any business or social relationship? If you do, please raise your red card. All right, no one answered affirmatively to that. Let's talk about the relationships you may have with any alleged victim, defendant, or attorneys here. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you or any of the attorneys involved in this case? So raise your red card if one of these lawyers is your landlord, for example. All right, no one has responded affirmatively to that. Are any of you involved in any kind of a legal proceeding, including a civil action against the defendant? No affirmative response. Have any of you ever brought any kind of a criminal complaint against the defendant or been accused of a crime by any of these prosecutors now present today? There's no affirmative response to that. Do any of you have any kind of an attorney-client relationship with any of the attorneys here or with Mr. Pryor or his law firm? Okay, no one responded to that. Do any of you have any kind of a relationship by blood or marriage to any of the lawyers in this case, or do you know the lawyers from any other professional, business, or social relationship? All right, no one indicated they know the attorneys or have any kind of relationship that would be prohibited. This next question is a general question, but let me ask, have any of you ever formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? Okay, no one indicated they've got an opinion. Do any of you have any bias or prejudice either for or against the defendant in this case, Mr. Daybell? No one responded to that. Are there any of you who would be unwilling to follow the court's instructions to you, the jury, as to the law that you must apply in determining this case? No one responded to that. Now, in this case, we will be asking you further questions individually about the section of the questionnaire you filled out relating to the death penalty. So I understand that may come up here. We will talk about that individually, but notwithstanding, I'll ask the group here, do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict in this case? Okay, no one responded affirmatively to that. Are there any of you that, if selected as a juror in this case, would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? All right, no one indicates they would be unwilling or unable to render a fair and impartial verdict. Kind of a catch-all question here. Do any of you have any other reason why you cannot give this case your full undivided attention and render a fair and impartial verdict. Very well, no one responded to that. That concludes the court section of group voir dire for this group. At this time, then, I'll permit the state to conduct its voir dire of the group. After that, the defense. Will that be you, Ms. White?
Your Honor, Mr. Wood will be starting the voir dire process.
All right, Mr. Wood, if you'd like to commence with the state's voir dire, you may do that at this time.
Thank you. And is it all right if I do so from the podium?
It is.
Thank you. Ladies and gentlemen, again, my name is Rob Wood. I represent the people of Madison County, Idaho. And just as a reminder, if I ask you anything today that makes you uncomfortable and you would rather answer it privately, just let us know. We want you to be comfortable, and we need you to give full answers and fully truthful answers. The defendant is entitled to a fair trial, and we only get there. And the state's entitled to a fair trial. We only get there if you're being morally honest with us. And so I'm going to start by asking juror number 321. What do you think of when I say the phrase brutal honesty?
I believe that just means not mincing your words, just no matter what, just tell them the 100% complete truth about how wrong it's.
All right. Does anyone else have a different definition of brutal honesty? But not mincing your words. Can everybody agree that telling the full truth, not mincing your words, is a good definition? Okay, and we need you today to be brutally honest. There's just a quick analogy I like to use. Who, by raise of hand, who here has flown on an airplane? Everybody's flown on an airplane, right? And you get on the airplane and that pilot, you get strapped in, they give you the safety warning, and the pilot tells you when he's going to land that plane approximately and where he's going to do it. How many of you would feel comfortable if the pilot said, I might be able to land this plane? You're all smiling. Would anybody feel comfortable with that pilot? Okay, so ladies and gentlemen, today we need you to land the plane. And what we mean by that is not a specific destination, but that you're completely honest. It's that important. The court asked you about following the law. Does anybody here like and enjoy every rule, law, and regulation you live under? Nobody does, right? Does anybody, just by a raise of hand, can you, not that you need to tell us what it is, but think of a law or a rule that you think is unfair? Everybody, you can think of a law or rule that's unfair, great. Multiple people feel that way. In this courtroom, the court will give you the law that applies in this case. And you may like that, you may not like that law. But for fairness to this defendant and for fairness to the people of Idaho, we all have to agree, follow that law. So even considering that maybe you won't like the law that you get, maybe it doesn't go with your gut. Can this defendant and can the state all rely on you to follow the law as it's given by this court? If you agree, yes, can you hold up your red card? This is important. 121, I saw a little bit of hesitation. Was that accurate, or was that just me? There is some hesitation. Tell us about your hesitation. And thank you for your honesty.
Yeah, I mean, I don't know if you were gonna get into this later, but my hesitation is with the death penalty issue. That's where I hesitate.
Okay, so, and we will talk about that. But thank you for bringing that up, and thank you for being honest. I'm gonna just shift gears really quickly. Does anybody here believe everything they hear on the internet or see on the internet? I'm the only one. So does anybody here believe everything they hear on the news everybody understand that the news is not always accurate. I'm not saying that to offend any reporters who might be here, but we all understand that facts change sometimes, right? And you might hear a story one day, and some of those facts are different the next day. This case has had a massive amount of media attention. And the judge asked you this, but we just want to check again. Is there anyone here who has any concerns of what they've heard before? And we don't want to go into a lot of detail now, we'll get into it later, but what they've heard before is going to cause them to not be able to give this defendant a fair trial. Okay. Some of you talked about hardship, and we're just going to go over that really quick. Juror 249. If I recall, and if I say it incorrectly, just feel free to correct me. You get about 2 weeks of paid juror time. Is that accurate? Okay. Are you, if it's all right, if I ask you the sole provider in your home?
Yes.
Okay. And is it fair to say that you and your family rely on your income?
Yes.
Okay. And have you, I forgot, did you speak with your employer about this specific issue?
I have. I just let my supervisor know that. This could potentially be a long-term commitment. And then when I was thinking about it a little further, I thought I better delve into what our policy says, stated. And that's when I found out that they only account for 80 hours for it. So,
okay.
And after that, you're basically on your own. Either you have to use your vacation, which nobody has 10 weeks of vacation, right? Or unpaid.
Would you see that as an undue hardship for you that would create difficulty for your family?
Yes.
Your Honor, the state would move to excuse Juror 249 for hardship.
I'd like to hear a response from the defense, and if you have any additional voir dire, Mr. Pryor, you can do that as well.
Nothing additional, Judge, you will stipulate.
All right, based on the comments made by Juror 249 as it relates to an employment hardship and financial with the length of this trial, the court will agree that the juror will be stricken for cause based on a hardship that includes his service. So thank you for appearing today and for performing your service as a juror. You can be excused, and please drop your questionnaire with the bailiff.
Juror 296, you had spoken about potential hardship, and I noted in your questionnaire, you said you had school Mondays and Wednesdays, but could do online classes. And you mentioned that, but I guess I'm not quite sure where it stands. Are you able to do online classes to finish that?
I'm not entirely sure, but I know they offer online classes for the classes that I'm currently in. So I'm assuming they could probably move me to the online classes. The only issue that I would have is the testing that I have to take either after hours or via online.
Okay.
The lecture part is in class. Like I can do the lecturing I can do online.
All right. And it's not school 5 days a week, just the 2 days a week?
Just 2.
You mind if I ask how many classes?
2.
2.
Biology class.
All right. And so if, with the court's schedule of getting out at 3:30, do you think that would be something you could make work?
Yes.
And so would it be an undue hardship to be on this jury with your school?
Not that I'm aware.
Okay, thank you. Juror 321, you had mentioned a hardship. Could you? And I apologize, I kind of can't remember exactly what you said a few minutes ago. Can you tell us what that was?
Yeah, I'm just unsure as far as, because I've not spoken with the employer about the length of this trial, I may go. I just know that it would be unpaid time off.
Okay. Are you a sole provider in your home?
Yes,
But so you haven't spoken with them yet. So are you sure that it would be unpaid time off, or do they have some type of juror policy where they pay you while you serve on a jury?
honestly, I'm not aware. They might possibly have a policy, I just don't know about it.
Do you think that's information you could find out in the next couple of days and notify the court if there was a change?
Absolutely.
Okay. Thank you. I also did note in your, I believe it was in your questionnaire that you wanted to see some college games of one of your children. Is that you? Am I confused? Okay. And where are those games?
They're in Oregon City, Oregon.
Okay. And is baseball?
Yes,
Okay. What year is your son?
he's a sophomore.
Okay. And I'm not trying to be insensitive. Being a juror is hard for everyone and inconvenient, but if you weren't able to see some of those games, would you be able to see them next year?
Yes,
And so would it be an undue hardship to miss some of those games?
No.
Thank you. The court spoke with you briefly about the nature of this case. This is a case about murder and conspiracy to commit murder and insurance fraud. Two of the victims in this case, two of the alleged victims in this case are underage children, a 7-year-old and a 16-year-old. And the other alleged victim is a mother. There will be some autopsy photographs in this case, and they are hard to look at. There's no way around that. But does anybody here think that seeing those would automatically sway them one way or the other, or that they'd be able to objectively weigh those, still weigh that evidence against all the other evidence? I'm sorry, did you raise your hand?
No.
Okay. So this is important. If you guys can raise your cards, if your answer is yes, would you be able to still weigh all the evidence properly, even if it's difficult to look at those pictures? So juror 48. Oh, okay. Thinking. Or what are you thinking? Do you think you'll be able to do that?
I just want to make sure I understand the question. If I could see the photos and not be swayed one way or another, continue to weigh the totality of the evidence. That's
Yes.
yeah.
And then I just have a couple more questions, Your Honor. I know Ms. Blake has a couple of questions. Juror 294. In your questionnaire, you said that you marked a box saying that you think a person, excuse me, who doesn't testify is probably guilty.
Yes.
So do you understand that the state has the burden of proof?
I do. I was just being honest, like just from my gut. Yes.
Yeah. And we want you to be honest.
Yeah.
And we appreciate that. There's nothing wrong with that. So you will get an instruction, and you'll be told by this court that the defendant doesn't have to say anything. The defendant doesn't have to prove anything. It's 100% on the state. And so is that feeling you have, is that something you could follow the rule and the law the court gives you and set that feeling aside and not hold it against the defendant if he doesn't?
Yes.
I'll just correct the record there for a moment. That's juror 394.
Oh, I said 294. I
Yes,
apologize.
that's fine.
394. Thank you.
Can I take this moment to mention hardship?
Please do.
Okay.
Yeah.
It's not necessarily hardship. There's a family vacation, family reunion, scheduled for week 10, June 6th through 10th, but travel would be needed on either side to Arkansas. It's not a hardship, but I thought I'd just mention that. I'm not losing work. I didn't anticipate checking on my jury duty leave for work, so that's an open question in my mind as to if I can take the whole time, that's acceptable, or if it actually is a restricted amount of time like other people in this group I should know by today.
Okay, and if that does create a hardship, will you let the court know?
Yes. I will.
Juror 41. You had marked something similar on your questionnaire that you want the defendant to testify. And I'm just going to ask the same thing. Do you understand that only the state has the burden of proof in this case? And that it's the state's job to prove something. The defendant doesn't have to prove anything. Okay. And so even though you have that feeling, is that something you can set aside and follow the law and the rules that the court gives you and not hold that against the defendant? Okay. Your Honor, at this time I know Ms. Blake has a few questions, so I turn this time over to her.
Very well.
Good morning, ladies and gentlemen. Thanks for being back with us today. I know you were all here last week, and this is a bit of a process, so we appreciate you hanging in there with us. And I will try to be fairly brief because I know you've already had a lot of questions today. So the judge has already started to give you some instructions, and as you go through this process, he will give you more instructions. So I like to talk to you a little bit about, I have a son, and usually in the mornings, if I ask him what he wants to eat, he tells me cheesy eggs. And there's a very specific recipe that I have to use. So it's the eggs and the milk, and he likes quite a bit of cheese, and then some salt and pepper. But if I try to modify that recipe, he doesn't always like it. So I don't know, have any of you had that experience where whether you're cooking or doing something else for a kid or a family member, they like things just done a certain way? Would all of you agree? And turning to juror 27, can you give me an example of something like that?
Yes, I have 4 kids, and they are very opinionated of how I cook and prepare their toast and their sandwiches and how I cut it. And so, yeah.
You can relate.
Really, yeah.
And so even if you think there's a better way to do it, do you sometimes just follow what your kids are asking for?
Well, in relation to food, yes. If it's something that's going to injure them, no.
Yes, I'll keep it with the food example. So if it's food, they want the crust cut off, something like that, you'll do it because that's what they're asking you to do.
Yes, I mean, unless there's a nutritional opinion I have, but if it's something simple, sure.
And in the back there, juror 186, I think I also saw you nod. Can you give us an example of something like that?
Same thing as you guys. I have 4 kids as well, and they like their food a certain way, especially when they're little. Anything to get them to eat.
And if you know a better way to do it, or maybe you would add something because it gives it better flavor, do you sometimes follow what your kids want?
I try to give them, sneak something in there that maybe I think will taste better. Try to change their mind. Food. They're little.
And so with this court, because I'm like a kid, we're going to get instructions from the judge. And if the judge gives you instructions, they may say these are the specific elements of a crime. And sometimes it's easy to look at that and say, well, that doesn't make a lot of sense. Or if you added this, it would make it a little bit better. Would everyone here agree that regardless of what you may think with the rule and instruction given by the judge, that you could absolutely follow what he outlines? Would everyone agree that you would hold the state to the burden of the specific elements outlined by the judge? So even if you might say, this would make it a little more nutritional this time, or hey, I might sneak a new flavor in, everyone could refrain from doing that if it was an instruction from the court. Does anyone have concerns with doing that? Thank you. And as I talk about, the judge is going to give you instructions, and some of those instructions are going to be regarding the burden of proof being on the state, and then they will also be the elements. With regard to charges of conspiracy and first-degree murder and conspiracy to commit first-degree murder, one of the elements is not going to be that the state has to prove the cause of death. meaning the state is not going to be required to prove exactly what caused the death of a person. Our element would be to prove that it was a homicide. Does anyone have concerns if you were to be presented evidence that someone was killed, but the state did not provide the specific cause? No concerns. So if the state put on evidence that it was a homicide, but not the exact cause of that homicide, that wouldn't cause anyone concern. Because again, you'll have instructions from the judge. 394, I see your card. If you're given an instruction though, that says that that's not a requirement, would you be able to follow that instruction, or would it be difficult for you?
I think it would be difficult, just based on my question.
So in this case, you are going to hear from quite a few witnesses. And some of the witnesses may have different religious views than you have. Does anyone have concerns that it would be difficult for you to listen to or give proper weight to someone's testimony based on them holding different religious views? Would anyone have problems if someone held different views in general, again, just with being able to weigh their testimony? And you're also going to be given some instructions, actually back that up. So if you were sitting in here today and the window wasn't there, or they put the blinds down and you couldn't see outside, but when you came inside, everything was dry, everything was clear. And then as you enter the building, you see the sky starting to get a little bit dark. It's starting to turn gray. You come in here, they close the blinds, you can't see outside, and you go outside and there's water on your car, and there's water on the pavement, water on the grass, everything's wet. What would you be able to determine what had happened? I see some nods. Juror 296, what would you determine had happened? And would you determine that even if it had quit raining by the time you got outside? So there would be enough there without you actually personally, physically observing the rain. And 321, I saw you nodding as well. Similar? And so would everyone agree, you may hear the term circumstantial evidence. Even if you don't see something happen, there could still be other evidence to support that. And would everyone be willing to weigh that evidence? Because again, as jurors, part of your job is going to be to weigh all the evidence and give it the weight you feel that it's due as you're listening to all the testimony of the evidence come in. Anyone have concerns about their ability to do that? I can have just a moment. The state has no additional questions, Your Honor.
All right, that will conclude the state's portion of voir dire for the group. Mr. Pryor, you may do so on behalf of your client now.
Morning, ladies and gentlemen. My name is John Pryor, and I'm representing Mr. Daybell. I want to ask a question of folks. Before we start, I really want to talk to you about the fact that there's no wrong answer. What's more important than anything else is that you tell the truth.
Mr. Pryor, apologies. Could you into the microphone a little more? We're barely getting your signal. Thank
And I'll
you.
turn it on. Does that help too?
That helps a lot.
At my age, Judge, technology is a challenging job, and I apologize. Can all of you folks hear me now? So I'll reiterate, the fact is that as jurors, your job is to judge the evidence. Your job is to make a determination and apply the facts to what the judge gives you as the law. But before we get there, what we have to do is go through this painstaking process of talking to you folks about some personal things and some private things, some of your thoughts and processes. And part of that is to, before we get there, is we really want to talk about just being honest and truthful about your position. There is no wrong position. If there are some people here who say Mr. Daybell is absolutely innocent, that's your position. If people feel that Mr. Daybell is absolutely guilty, that's your position. If you really haven't made up your mind, that's your position. But it's your position and it's your own individual position. And what's important is that you apply the facts not as you see the group and go along with the group, but that you basically tell the truth and you speak your mind. This is your opportunity to say how you feel and to be honest about how you feel. Is there anybody who really doesn't understand that? Perfect. I must have been pretty clear and you can hear me now. That's wonderful. Before we get started, this is an unusual question I ask. And I ask this because I've had the opportunity to sit in that box a handful of times and over the number of years that I've been an adult. And this happened to me many, many years ago. I was 21 years old and in college, and the lawyer was involved in a criminal case. And he asked an unusual question. As soon as he got up there, he asked an unusual question. He said, "Is there anybody who just doesn't want to be here today?" And a number of us were hedging and moving and everything else. And I thought, yeah, I don't want to be here. I don't really want to. Well, why don't you want to be here? Because I just don't want to be here. I just have so many other things in my life, and I have so many other distractions, and I have so many other processes. And I was a college student, naive and wide-eyed, and I said, I understand the obligation to be a juror. I understand that it's something that we have to do as our civic duty, but I just don't feel like I can give the attention to this thing that I really think it deserves. And surprisingly enough, the lawyer said, well, thank you for being so brutally honest, and the judge let me go on my way. Now, I don't want to give all of you an opportunity to raise your hand when I ask this question, and please don't, if you really think you can give the attention. But is there any of you folks who quite honestly, you just don't want to be here today? And please be truthful with that question. You're all very excited to be here. And you're all very anxious to get involved in this. Okay, number 394, go ahead, sir.
Yeah, I definitely want to do my civic duty. I feel like that's the proper thing to do, and I'm thankful for everything that you guys do. I'm a year and a half, about a year and a half into a new job, building a team. We have one person, I'm a team lead, I have one person under me. We're trying to hire another person. So I question whether my success in my job will be as good as it could be if I was there versus being out for potentially 10 months. And of course, I don't want to think deeply about a murder case, just the content. But again, I want to do my civic duty, so that's kind of where my.
And I appreciate that. Your job's important. You're a data engineer, if I remember right. I'm going off of memory.
Yes.
My memory serves me that that's what you do as a data engineer. Is that right?
I am a data engineer.
I said data, it's data.
Yeah.
Back and forth.
Yeah. And my wife's a part-time biller, about 10 hours a week. So I'm the primary.
Do you have children?
Yes, we have 3.
I remember that as well. I just wanted you to tell me that. Okay. And do you really think this could potentially affect your occupation?
I don't know. I need to talk to my manager today and see realistically how this would impact either my future growth or the paid time off policy for jury duty.
Well, the one thing that caught my attention was that as a data engineer and having been married, and she's going to kill me for announcing this to the world, I guess, my ex-wife was an engineer. And it was, everybody's smiling about that. I understand that when you're working on projects, that a lot of time those projects are particular to the individual engineer. Is that your position as well?
Yeah, we basically serve all areas of the business, whether it's product or finance or customer success. So they're long, they can be very short requests, but usually they run multiple weeks.
Okay, okay. Is there anybody else who would like to, provide me information about whether they just don't want to be here? And frankly, folks, there is no wrong answer. I can assure you that the story I told you about speaking up and saying I didn't want to be there, absolutely true. And then it was just one of these situations where I just felt like I couldn't provide the necessary attention. And that was going to be a 2 or 3 day trial. What we're dealing with in this case, folks, is a 10-week trial. And it's going to take a lot of time and it's going to take a lot of effort. And I want to make sure that all of you are going to be able to do that. That's a significant request from all of you. And all of us, the 4 prosecuting attorneys, the judge and myself, Mr. Daybell, we're asking you to put that kind of a commitment into this. It's 10 weeks. It's 2.5 months of your life that we're going to be asking you to put forth. Juror number 27, you're shaking your head. Do you have any concerns or questions about that? Or thoughts, please?
No. I'm shaking my head in agreement that it is a big commitment, but feel if this is what you feel I should do, then that's just my duty to it.
And I guess I'd be clear on that. I welcome everybody's thoughts on that. And I don't want anyone to think that, well, you're doing this because it's what you feel I want you to do. In your own mind, and I can't evaluate what each of your life situations are. I'm given a very small description of facts, the questionnaire that was filled out, and the difficult situations that I have to determine. And sort of the 4 prosecuting attorneys who are working on this case, we have to determine with that small window of information what kind of impact this is going to have on you. That's very important. And I do spend time on this. I spend a lot of time on this. And I do that because the consequences are significant here. You've all read or heard the allegations against Mr. Daybell. And I just want to make sure that all of you are going to be able to put that time commitment in and spend the time to work on this significant project. And much like our friend 394, it's a significant project. So again, is there anybody who's having any hesitation? Please speak up. Please speak up now, because the time to change your mind later will become difficult. So I ask again, is there anyone who's having any concerns or hesitation? 121, please tell me what your thoughts are.
I mean, I feel kind of similar to what he said, where like I do recognize that it's, my duty, and but I just think like I've just been thinking a lot about just how a lot of the troubling aspects of it, and that's the reason why honestly I was like didn't want to be here today. Would be the troubling aspects.
And is it your position you would just rather not be part of this? And please be honest about that.
Yeah.
Okay. Do you think that your views and your thoughts on that would create some sort of concern in how you look at the evidence?
Yeah.
Would you be more inclined to rush through this because you want to get this done?
Yeah.
Would you be able to take the time to look at the facts and look at them, in an impartial manner?
Yeah.
Okay. All right. Thank you. And I appreciate your honesty. I really do. Please. And I'm going to forget juror number 121, I think. No, 146. I'm sorry.
I was just going to say,
Would you, officer, would you please do it? I have a loud voice, but not everybody's gifted with such a projected voice as I am.
I hate my voice on the microphone. I think
every one of us probably would be lying if we said we were like so excited to be here and wanted to. But I feel like it's just jumping out of my chest, like if any of us are supposed to be here, we will be here.
Okay.
I'm not particularly excited to be here. I have 5 little kids, but it is what it is, and if we're supposed to be here, we'll get picked and chosen, and
Well,
I don't know why I'm, but that's just how I feel about it.
and that's one of the things that I looked at when I saw your profile. You had 5 children.
I have 5 kids and I run a daycare.
Run a daycare center. And then I'm gonna use my cheat sheet a little bit, but, in addition to that, I guess I didn't have to, just popped in my head for some reason, but your husband is involved in landscaping.
Yep, we have a landscaping business too.
So do you help in that landscaping business?
No,
No.
I mean, like, you know, paying invoices and things like that I do, but not.
So you do paperwork in your free time.
I'm the free
When you're,
secretary.
when you raise the, and I'll get to you in a minute, I just saw the reaction. That was wonderful. Juror number 186, I just saw the reaction. I'll get to you. In your free time, when you're not dealing with your 5 kids and gathering them up and taking those family responsibilities, you're then taking on the obligation of running a daycare. And how many kids do you have in that daycare?
3 to 4.
Okay. And then, like you said, in your free time, when you're done taking care of the kids and taking care of the daycare, you then do the paperwork.
Yeah, when it's needed.
It almost sounds like this would be a vacation.
If I'm being totally honest, when the judge said at the beginning you could be sequestered, I was like, oh, it's gonna be a spa for me. I think it would be.
Well, I think it was your questionnaire. I read that you made some comment in the questionnaire saying, LOL or something like that. That was yours.
Probably being a smart ass, but a sequestered would not be like the worst thing for me.
Okay, and thank you for your honesty. And then juror number 186, you smiled and you had some thoughts. Please talk to me about
Oh, I was just smiling at her comment of being the free secretary.
that. Okay, and tell me about that, how that applies to you.
I just thought it was funny the way she worded it.
Oh,
Had nothing to do with me.
Okay, okay. Okay, is there anybody else, and I know I've spent a lot of time on this, and it is important, and the idea is to get you folks to be, I understand, at least the camera's on me right now, from what I understand. And it's not on you, so you have this wonderful opportunity to speak your mind and tell me what your thoughts are on this, whether or not any of you, for the last time, do you really have any reservations or anything you would like to comment about participating in this process? Anyone? No one? Okay, thank you. I'm going to move on to a little bit of a different subject. And one of the things I need to talk to you folks about is that Mr. Daybell's here today because he's pled not guilty to the charges. And I'm going to ask you questions that may concern whether he's guilty or not. And I don't want you to read from my questions that I believe Mr. Daybell's guilty or anybody else believes Mr. Daybell's guilty. The fact is, we still have to delve into these questions and talk about these things because it's important that we try to get, in this very little time that we're going to spend together, get an idea of what your thoughts are, what you folks are thinking, how do you feel about a variety of things. So please don't read into my questions or assume I'm asking you something because I believe one way or the other. Once again, all I'm trying to do is to just get an idea of the person you are. Right now, I'm speaking and it's being broadcast everywhere and people are getting an impression. I don't know if I want to read some of the impressions they're going to talk about me or say about me, but they're getting an impression. And by the same token, I'm going to ask you questions to also get an impression, get an idea what you think about. And that's what's important. It's important that I do that because it's the way we are able to determine whether we think you're a good fit, whether the prosecutor thinks you're a good fit. And that's part of the overall process of doing this jury voir dire. Juror number 56, you were nodding your head. Is there something you would like to offer in regards to that?
No, just agreeing
You're
with the
agreeing with
process.
me. Well, thank you. I appreciate that. I'm going to go into a couple of different areas, and please don't, again, don't read into this one way or the other. Just again, I think what we're trying to do is be able to build a relationship between myself and all of you folks so we can be open and honest and free about what our thoughts are without worrying about what people might think. Because quite frankly, I don't care what any of these people think. I could care less, and that may hurt some of their feelings. But I do want to know what you folks think. It's important. And the state wants to know what you folks think. And it's important. Because all of us agree that in the end, the state's entitled to a fair and unbiased jury. Would everybody agree with that? You could raise your things, not your hands, just your numbers. I'm sorry, folks. I just want to thank you. Thank you. And would all of you agree that Mr. Daybell is entitled to a fair, unbiased jury? Okay, thank you. And on that note, I'd like to start out by asking you folks, is there anybody right now who thinks that Mr. Daybell is guilty or is probably guilty? Okay. Okay. And that's juror number 48, was it not? Now, juror number 48, is that going to impact your ability to make a determination as to, in the end, whether or not Mr. Daybell is guilty, going into this process with the idea that you believe or possibly believe that Mr. Daybell is guilty? No. Okay. You're going to be able to be unbiased?
Yes.
Okay. And let's talk about that, because that leads into the next area that I'd like to talk to you folks a little bit about bias. Is there anybody who doesn't understand what the word bias means? No hands. Okay. What about the words impartial? Does everybody know what the words impartial means? Yes? No?
Kinda.
Okay. Okay. Juror number 41. When you say kind of, what is your 30? I'm sorry, you're right. 11, 21, 31. 41's next.
No, I'm not sure what impartial is. The first one you said was
Bias.
bias.
Okay.
So I'm trying to think in my mind the difference between the two.
Okay.
So bias.
What are your thoughts on that? What do you think impartial is?
Depending on what I see, if I trust in that,
Okay.
or I don't trust in what I see.
Okay.
Is that kind of what I'm
Okay.
looking for?
All right. Okay. Okay. Juror number 219. Thank you. What are your thoughts on when you hear the words impartial?
That I would be neutral until basically there's sufficient information to make up my mind one way or the other.
Okay. Okay, is there anybody who disagrees with that? You must be a teacher or something, because that's a great explanation.
No, sir.
Okay. Is there anybody who disagrees with that you must remain neutral? Does everybody agree with that? You must remain neutral? Okay, thank you. So we're going to go back to this issue of bias or influence. And you're going to hear from a lot of witnesses. Does everybody agree that there are witnesses that can be influenced and sort of coerced into saying things that are not necessarily true or false? Everybody, would you raise your hands to see if that's something everybody agrees with, or if you don't agree with it? Or your cards, either way. I didn't see at the very back there. Looks like 296. Okay, I'm sorry, I missed it. I'm sorry. Does being influenced or coerced, do you think that just applies to citizens? Anybody think that it just applies to citizens? Raise your hand if you think it just applies to citizens. Okay. What about law enforcement? Anybody agrees that law enforcement could be swayed? Maybe they could be influenced to go and testify a certain way to to support one side or the other? Anyone? No one thinks that's possible?
Can you restate it? I thought you.
Just law enforcement. Do you think the issue of being biased or being influenced, do you think that just applies to ordinary citizens? Does anybody believe that it could also apply to people who are in law enforcement? Now, I don't want to pick you out, and please forgive me, number 27, but my recollection when I read the profiles, and this was last week, is that your father's a police officer. Retired police officer, that's what I remember. Okay. Is that concept something that, just the fact that I bring it up, is that somehow offending you or causing you concern that I would bring a statement up like that?
No, I absolutely believe there are good cops and bad cops.
Okay. And in that instance, when we're talking about officers, that police officers are no different than every ordinary citizens, right?
Correct.
And they're susceptible to the same influences and the same manipulations that other people are susceptible to, right?
Yes, correct.
And when you're talking about a criminal case, and you're talking about a law enforcement officer, what do you see as their role in that case?
The same as all of us, seeking the truth and believing the truth without a bias.
Okay. What if they have an agenda in advance of the investigation of cases? Would that cause you concern?
If the police officer has an agenda, yes, that would have a bias then.
Okay. And as far as a role in a case, would you agree with me that a police officer's role in a case is to investigate the facts and report the facts?
Absolutely.
Is there anybody who disagrees with that? Nobody disagrees with that? What about a police officer or an agency that decides to aid in supporting one side or the other and pushing their own agenda? Is that problematic for anybody? Raise your hand if you think that's problematic. Or raise your cards. I'm sorry, Judge, I guess we're on cards. So nobody disagrees with that. So when you hear evidence of that, is there anybody who causes pause for concern as to how they evaluate the bias of that particular police officer? In other words, if you hear that a police officer has an agenda, that he's pursuing a situation where they're trying to develop the fact that someone is guilty rather than investigating the case. In other words, they found their target. Okay, and I don't want to get into.
May we approach?
Yes.
So I've been talking to you folks a little bit about bias.
Mr. Pryor, I apologize for the interruption. We did have a note here. We're having a request. These jurors have actually been here for quite some time. request for a restroom break. We're going to permit that at this time, so we'll take about a 15-20-minute recess in time for the jurors to use restrooms if they need. We'll come back on the record once that mid-morning break is concluded. Please rise for the jurors.
All right, wait. Back closer.
You can leave them there on the chairs, yeah.
All right, great.
Here, now go back, Your Honor. Thank you. Please be seated. Okay, we're back on the record. Mr. Pryor, you can continue with your voir dire examination. You may.
Before I get into a different topic, do any of you folks know each other? Nobody knows each other? Yeah. And again, remind me, in terms of media viewing, how many of you have seen anything on whether it's the internet, TV, anything like that? Raise your cards if you've seen anything. Okay, thank you. One of the instructions that the court's going to give you is that it talks about what a conspiracy is. And the state talked a little bit about that. The prosecuting attorney, I think, but please forgive me, I believe it was Ms. Blake, talked to you folks a little bit about that. And one of the things in order to have a conspiracy per the court's instructions, and this is what the judge is going to give you as rules, okay, is that there needs to be an agreement. There needs to be an agreement. Is there anybody who doesn't understand what an agreement is? Okay. Juror number 219. Sorry. How do you define what an agreement is?
Hard to define without using the word agreement. Basically, you're understanding the same thing. An individual that you are working with.
Juror number 11, we haven't picked on you, and I apologize if we picked on you. Okay, that's okay. But what do you think an agreement is? How would you define an agreement?
I would define an agreement as two or more parties formally agreeing to something or seeing like one another and formally, planning something together.
Is there anybody who disagrees with that? How about hands of showing me anybody who agrees? Hands or cards, whatever you feel. So if I understand it, 394, did you put your card up or hand up? I'm sorry. Okay, so you think that there needs to be a formal arrangement. How is that arrangement set out? Is it in words to each other saying, we agree that this is what we're going to do? Is that how that you reach a formal agreement?
I think it varies based on the situation. I think it can be formal, it can be verbal, non-verbal, just depends on the situation.
Okay, but there has to be some, I don't want to use fancy words, and I tend to speak very simply. It has to be some kind of a statement or something that says, yeah, we're all in on this, right? Juror number 27, what are your thoughts on that? I'm the one who struggles with technology.
Yes, I would agree with that. I think based on what you're coming to agreement of, there might be different protocol.
Okay.
But I believe your word is your word, regardless of what that protocol is.
Okay.
So if you're coming to an agreement, then you are agreement, that's your word, that's your contract, essentially.
And we're gonna work our way down to juror number 31, and she's smiling. She looks like she's ready to let me know her opinion, so I'll give you this chance.
No. It's a nervous smile.
Oh, I'm sorry. If you're too nervous, we can
No,
pass the
I
mic
can
on.
do it.
In fact, folks, if it gets to the point where you're too nervous and you just don't want to say anything, this is like a game. Just pass it on to the next person. You know.
No, I'm okay, it's this
Okay.
thing that I don't. An agreement, I think too as verbal, but sometimes it's a written agreement.
Okay.
Not necessarily, I agree to that or agree because even though you say it, doesn't mean it's for sure.
Right.
Or if it's written down, a signature or something that I feel like you can't get out of that agreement now.
So if people are just talking about topics, that doesn't necessarily mean it's an agreement, does it?
No.
There has to be some, and I'm going to use a fancy word because I'm surprised to you, I went to law school. And the one thing they do to us is they try to put fancy words in our mouth. So I'm going to use this fancy word, then I'm going to ask you to maybe explain it in what I think are simpler words. They say you have to manifest a desire to agree. Would that be fair?
Yes.
Okay.
Yes.
Pass it on to our friend number 41. What do you think? An agreement. What constitutes an agreement? Would you turn that on? I'm sorry. Aside from that being technologically advanced, I can't hear very well either.
So. But well, everything they've all said that you agree with is between people and.
Okay. So you generally agree that there at least has to be some sort of arrangement or understanding between all of the parties that this is what you're doing. Does it have to be really clear? Or can it be, well, I'm not sure.
We approach.
Well, in the interest of time this way, because their objection the state has.
Your Honor, the state's position would be he's misstating the law and what the, at least the IFG would be. In this case, of course, we don't have the specific instruction from this court, but I think he's confusing the elements of this particular crime.
At this point, Mr. Pryor, I am concerned that we're delving into court instruction here and outside the scope of what Rule 24B permits on juror qualification. And so I would ask that we move on from definitions of what an agreement may be in the case. The jury will be instructed on that issue.
And Judge, can I respond to that objection just so we have a clear record?
Yes.
Okay. Judge, the state took some time to talk to the jurors about, speaking honestly and straightforward and all of that. And I think, quite frankly, I'm allowed to go into at least what their understanding is. These folks are going to be providing jury instructions. And those jury instructions, at least from my perspective, I can ask them how they would understand and interpret that. So I'm, all due respect to the court, I disagree.
All right, well, I stand by the ruling. The instructions will clearly delineate the elements of any crimes charged in the case the evidence may show. And I think this is going beyond the scope of proper voir dire. So if we move on to another topic, Mr. Pryor.
Is there anyone here who can promise me that they will review the entire evidence before they make a decision? Please raise your cards up. Is there anybody here who thinks that they just need to look at the prosecutor's evidence, and if they've already figured out what they feel on that, that they don't, it's really not necessary to listen to my evidence? Anybody agree with that? Okay, all right. Judge, I think that's all I might have at this point. I think that's all I have. Thank you, Your Honor. Folks, thank you very much for your time.
All right, thank you, Mr. Pryor. We'll move on at this point. We are going to have some individual questioning of jurors. I did want to return back around with a question or two of my own, going back to juror 296. We talked a little bit about hardship. You've raised a couple of different things. I'm sorry, juror 394. Apologies. There's you've got an important trip planned the very first week of June, is that correct? All right, you've also made some concerns about your work situation. On the June trip, I guess on each of those points, number one, I don't know that we'll have an opportunity to go back and, for example, check with employers, find out what that answer is. We'll kind of need to know today whether you're in or out potentially as a juror. So we really need to go on the information we've got now. The second point I guess I'd make is if this case is going longer than anticipated and we're getting up to June, do you believe that would become a severe distraction for you if you started thinking you were not going to be able to attend this vacation, or do you think you could possibly set that aside?
Yeah, I wouldn't consider vacation hardship. I would really focus on the case. So.
Okay, I just wanted to be clear on that. So I appreciate your response on that. With that in mind, then, at this point, we are going to conduct some individual voir dire, and we've got a process. You're the first group we're doing this with, so we've thought it through, but the process will be to have jurors remain one at a time. And so you'll cycle in and out of the room while we have one juror remain for this individual section of our questioning. At this point, then, we'll go ahead and start with probably the lowest numbers starting first. So Juror 27 will remain for some more individual voir dire. The additional remaining jury in the panel will be excused for a moment while I talk to them, and we'll go in that order.
All right, please. Your Honor, number 11.
I apologize. It's 11. I saw the empty seat there and thought one had been excused. Thank you. Thank you. Please be seated. All right, juror number 11, we do have, I believe, a response in here. You've got some knowledge of this case previously. I don't know that you raised any concern as it relates to a possible hardship. So at this time, I just asked for counsel, beginning with the state and then the defense, to make any inquiries you think are necessary in order to go into the issue of potential bias from pretrial exposure. Who's going to be doing that for the state?
I will be on this particular juror with juror number 11.
Okay, thank you. So Ms. Blake, if you'd like to confine the response or your voir dire to that topic of potential bias, and then I'll allow the defense, and then we'll move on to questions on death penalty responses after that, and I'll have my own question.
And Your Honor, in regards to juror number 11, the state's only real questions are going to be regarding hardship. We just wanted to clarify a few things. And I will indicate there was no hardship listed, just with some of the responses. We just wanted to verify a few things.
Okay, you can go ahead and inquire on whatever topics then, Ms. Blake.
Thank you, Your Honor. Juror number 11, it's my understanding you have a brand new baby, 3 months old.
Yes, I do.
And then you also work. And I know that you indicated no hardship. I just wanted to clarify with you, do you work nights?
Work early mornings.
Okay, so coming here by 8, to get started at 8:30 or maybe even sometimes a little before 8, would that create any kind of a hardship for you?
Not immediately though.
And when you say not immediately, just so I'm clear with you, and I apologize to put you on the spot here, in not immediately, would you be good for a full 10 weeks or for the expected duration of the trial?
Yes, I can mix it.
And do you think your employer will work with you on that?
I have talked with my employer about it, and the transition will be a little difficult, but we could work out a compromise.
And it sounds like they're willing to work with you then from your conversations?
Correct.
And then with that 3-month-old at home, do you have any concerns if you were to be sequestered for a period of time?
It would be difficult being away from family, especially with a young child at home like that, but if it is required as it is my civic duty, I would be able to make it work.
I just wanted to verify that with you because I know sometimes people don't mark a hardship down because they try to compare themselves to other people's situations. So I just wanted to make sure that that was going to work for you. And then just to clarify with you, my notes from the questionnaire that you filled out was that you really didn't have any prior knowledge of this case. Is that correct?
Correct. I just heard about it in rumor.
That's all the questions that the state has. Thank you.
All right, Mr. Pryor, you can inquire on voir dire. I note there was a bit of a mention of some pre-case knowledge as well as those hardship issues. If you'd like to inquire on those two topics, then we'll move on to questions as it relates to the death penalty.
My notes say that you used some media. Did you hear about this by way of media or not?
I came across it just looking through the news, but I never delved any deeper than glancing at it.
Okay, and please forgive me, I don't mean to delve into your personal affairs. Would it be a financial hardship for you to support your family being off for 10 weeks?
It would be difficult. I'm still communicating with my employer about their policies with jury pay, but if it was unpaid, yes, it would be a financial hardship.
And that's really what I want to get into, is that, we all have an obligation to members of the jury and serve.
Mr. Pryor.
And I'm sorry. Is that better? No. We all have an obligation to serve, but if it gets to the point where you feel like this is going to be a terrible financial hardship and you're going to have to struggle financially, at that point, this is not supposed to be something that imposes a significant burden on you. And what I'm understanding is that if your employer, I know your employer, I know you work, we don't need to get into that, but if that employer doesn't pay you for more than a week, this is going to be a significant financial burden on you, isn't it?
Yes, it would.
And it's going to be difficult for you to make your expenses and your needs to provide for your family.
Correct.
So we're sort of banking on the fact that if your employer doesn't give us the right answer, you're going to be in a different situation. Do you agree with that?
Yeah, I would agree. It does bank on what my employer does say.
Okay, and at this point, I don't need you to be noble. None of us should be noble. I feel like if someone had asked me to take 10 weeks away, yeah, I think I could do it. But if it's going to be a situation where you're going to have to, after 10 weeks, you're going to have to play catch up and you're going to have collectors and things like that, that's not being noble. I mean, I think at this point, if you really feel that this is going to be a financial hardship, if your employer doesn't give you the correct answer, I consider that a hardship. Would you agree with that?
I would agree.
Judge, I'm going to vote for cause. I think this young man is being honorable, but the reality is that he doesn't know what his employer is going to say. And quite frankly, it's going to be a financial hardship. And now's the time to resolve this rather than waiting until we get into the next round.
Response from the state on the challenge for cause?
Your Honor, with that additional explanation and information, the state has no objection.
All right, well, turn number 11, the court will agree with counsel agreeing as well. Your attitude is very much appreciated by the court and your willingness to serve. Congratulations on your new family. I hope things continue to go well for you at work. And at this point, just given the length of this trial and your situation, it is a concern that you may face an undue financial hardship. So you will be excused and the court will support the strike for cause on a hardship basis for juror number 11. So that will conclude your jury service today. Thank you for coming up. All right, and Mr. Bailiff, if you bring in juror number 27 next.
Yeah, sure.
All right, thank you for returning here to courtroom juror 27. We're going to conduct an additional individual voir dire with you concerning issues of either bias or hardship, both of which were mentioned in the questionnaire. Although the hardship was checked as a no, and you potentially have a vacation starting June 15th, it looks like. The question of prior case knowledge is something I think we need to explore a little more outside the presence of other jurors. So I'll begin again with the state. If you'd like to conduct any additional voir dire as it relates to pretrial publicity or bias, you can do that, and then I'll allow the defense.
And just to start, juror 27, have you ever lived in Florida? Okay.
No.
And so this may seem like a strange question, but just to double check, have you ever been charged with a crime in Florida?
No, I have not.
Okay. Okay. In your questionnaire, you mentioned that you've seen some headlines.
Correct.
But you didn't really read it. If I read this accurately, you just looked at the headlines and didn't really research the case.
No, I never clicked on the headlines to read any details. Just
Okay.
saw headlines.
So you knew that something was going on, but you didn't know the details.
Correct.
Sometimes headlines can be, for lack of a better word, loaded with a lot of information, maybe designed to make you want to read it. Was there anything in those headlines that may have biased you towards this defendant?
No, sir. Don't think I could make a judgment based on a media headline.
Okay. And so, whatever you did see in those headlines, you can commit to this court and to this defendant and to people of Idaho that you can set aside whatever you saw in those headlines and give this defendant a blank slate for this trial.
Yeah, absolutely.
Your Honor, I don't have any other questions on media exposure. If the court wants us to go into that penalty section at all right now, or
I'll do an inquiry on that starting and then allow you questions as well. I guess the only question I had while we've got you here is the vacation starting June 15th. We're scheduled to be done at that time, but if this were running long, would that start causing you some great concern if you were potentially going to miss that?
No, there is a vacation on the 24th that would cause me concern, but the one on the 15th is flexible. It could be moved.
Okay, that's the only question I had on that. Mr. Pryor, if you'd like to inquire as it relates to bias, you can do that, and then we'll move on to questions regarding the death penalty.
And ma'am, the concern that it's much like a number of the other folks, there are 4 kids at home. And forgive me, I can't remember the ages of those kids. Are those younger kids?
My children, my oldest is 12, and then I have 10, and then I have twins who are 8.
Okay, and are you the one primarily responsible for taking care of those kids?
You could say that my husband works from home, so he is around always.
So there is some flexibility there.
There is some flexibility, yes. I homeschool my kids part-time and they go to a program part-time, but my husband's always home and he's very involved in the homeschool process.
So he could take over at least for 10 weeks. The homeschool. I saw that in the profile. I couldn't remember exactly what the age of the children were. But I saw that there was a homeschool issue. I don't recall seeing your husband take that over. That's something you folks can work through.
Yeah, I mean, it would take some logistics and compromise, but it's definitely doable.
Okay. All right, now, Judge, I don't think I have anything else. Thank you.
All right, thank you. So juror number 27, the next topic we're going to discuss as it relates to capital punishment, which is a factor in this case. The first question I guess I'll begin with is, do you recall answering, and you do have a copy of the questionnaire there, but these questions on part 5 of our questionnaire called attitudes regarding the death penalty. Do you remember answering those questions?
Yes, I do.
And to your best recollection, are all of your answers in the questionnaire still true and accurate about how you feel about that today?
Yes.
Okay. So in this case, juror number 27, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. In this case, looking through your questionnaire, you've indicated that you are in support of the death penalty. Is that still accurate?
Sure.
I'm going to read another statement to you now. Remember, any penalty you consider should be done as if it is absolute and will be carried out in this case. Your conscientious, religious, or other objections to the death penalty are not grounds for you to be excused as a juror. Do you understand that?
I understand.
Okay. And based on your responses, would you be in favor of the death penalty in every case where a murder has been committed, or would you follow any instructions given by the court as to whether or not it should be applied?
Follow the directions of the court.
Okay, so you're not saying you believe it should be imposed or you would vote for it in any case?
Do not believe that is the result of any case, correct?
All right, having considered then the responses in the questionnaire here, the court is going to pass over voir dire for any additional questioning from the state at this time, and then I'll allow the defense to voir dire on that issue.
Your Honor, the state doesn't have any further questions.
All right, Mr. Pryor, any questions?
Judge, would the court prefer that I be up at the podium, or are we okay for me to sit here?
You're fine to remain seated as long as you talk into the mic.
Thank you, Your Honor. Ma'am, there's no wrong answer when it comes to people's feelings about that. Everybody has an opinion, and everybody's entitled to their opinion. You can agree with that. You're not.
I agree.
Okay. One of the areas that caused me to look at your particular profile, and nothing more, but in your case, you have 4 relatively young children. If you were to hear testimony that related to the death of young children, would that cause you to react in a way that would say, there are children involved here, it has to be the death.
No, honestly, age doesn't, the death of anybody is sad. I don't believe that I would be affected just because of age.
Okay, and on the same token, if someone's immediately convicted of a charge such like this, is that an automatic for you for the death penalty?
No, not me personally, no.
Do you start at the death penalty and say, well, I'll look at other things, but it's been a murder, so we're starting at the death penalty and then we're going to work backwards?
No.
Okay. Judge, I have nothing else. Thank you, Your Honor. Thank you.
All right, I just have a final question then for your 27. So as we get into that section of the case, are you committed that you would hold the government to its proof in this case if that was the instruction you were provided?
Right.
All right, thank you. Juror number 27, you can go ahead and return to the jury room there with the bailiff, and we will next have juror number 31 brought. All right, juror number 31 is now seated. The court's going to take just a moment to briefly review again the questionnaire. All right, the court has determined an individual voir dire to be appropriate for this juror number 31. This particular juror has some knowledge of the case, which we'll discuss with you here individually. I'll allow questioning on that. There's also a potential personal knowledge of one of the participants in the trial, being my staff attorney. And then in terms of hardship, there was nothing there. So I guess let's start with questioning in terms of any potential bias. And after that, we'll move on to questions as it relates to the death penalty and her responses in the questionnaire. So just as an outset, you do have a copy of your questionnaire there with you. Are all of the questions that you answered and your responses, including on the section of your attitudes regarding the death penalty, are those answers still true and accurate to the best of your knowledge here today?
Yes, sir.
Okay. Well, with that in mind, I'll allow the state to inquire first as it relates to any possible bias, then the defense, then we can move on to questions related to the death penalty. Ms. Blake and Mr. Wood.
It's me, Your Honor. It's Beatty.
Ms. Beatty, sorry.
Thank you.
Go ahead.
Good morning. I want to talk to you briefly about some of the media exposure in this case. You mentioned in your questionnaire that you had seen this case on the news.
Yes.
Yes. And you also mentioned at one point, there was a question on page 19. Has any of your possible exposure to news reporting caused you to form an opinion about the defendant's guilt or innocence? And you had written that you weren't sure. I believe you wrote, I don't know. Can you kind of talk to me a little bit about that?
Because what I have seen and when this all started, I saw, I was there. But until I actually see the evidence and hear more of the background of why I didn't, that's when I feel like I will know more than just what I've seen on TV.
Okay, well, that kind of leads into my next question. Because you had also mentioned that you were hoping that you got to hear the correct story from them both. And so during this trial, you're going to be instructed by the judge that the state, the prosecution, has the burden of proof, and the defendant does not actually have to testify at all. That's the state's burden of proof.
Right.
And so is that something that would trouble you?
No.
Okay. And would you be able to set aside what you've heard in this case on the media and just let the defendant start with this clean slate presumption of innocence and wait until you've heard the evidence to make a decision?
Yes.
Okay, thank you. And then just briefly, in the hardship portion, there was a question about being sequestered, and you mentioned that you have concerns. Is that something you'd be comfortable talking a little bit about or elaborating on?
What one was that?
I believe it was on page 21, and it was a question about being sequestered. And you had written, the question was, would any potential sequestration pose an unmanageable hardship for you? And your answer had been, maybe away from home overnight, I do have concerns.
Okay, so yeah, I didn't know, a long time away from home is just a long time from home.
Sure.
My husband's on disability, but, we're just so used to doing everything together 24/7, where I just thought, gosh, weeks after weeks after weeks not seeing him, that'd be hard, but I mean, I would do it. That was just kind of my.
And does your husband have a disability that requires you to care physically?
No,
okay.
no.
I don't believe I have any other questions at this time, Your Honor.
All right, thank you, Ms. Beatty. Mr. Pryor?
Yeah, I only have a couple of questions. Thank you.
Mm-hmm.
I only have a couple of questions. I wouldn't be able to do without. I saw on your questionnaire, and I'm talking page 7, the bottom of page 7. Let me know when you're ready.
Okay.
Under part 4, number 1, question A. Oh my gosh, that's a mouthful. It says, do you feel that a defendant should be required to testify? You are yes. Could you elaborate on that a little bit just for me, just so I understand?
Answering this in last week, and then listening to the different things that they really don't need to testify, that I feel like if I heard him testify, I don't know if it'd make change my mind whether he's guilty or not guilty. I'm aware that he probably won't say anything that I learned today. So it probably would not matter at this point.
But when you marked it,
Yeah, I marked it yes.
it should be required. What I'm concerned about is not what you're hearing today. It's just that when the case is submitted to you and it's all over with, are you going to be able to look beyond that opinion of yours and say, well, I originally said, I think he ought to testify because I really want to hear what he has to say. But I guess that you can understand that could be a concern.
Right.
And that's a legitimate concern. Would you agree with that?
Yes.
Yeah, so I guess I'm just sort of wondering if you'd be able to look beyond that and say, okay, I don't need him to testify. I can evaluate the evidence as it's presented to me without hearing from him. Would that be fair to say?
That's fair.
Okay, thank you.
Yeah.
And then lastly, under B, right underneath that one, you said, question was, do you feel that a defendant who does not testify is probably guilty or has something to hide? And you marked yes. So I understand you said you could look beyond that. I guess my concern is that do you still believe that if he doesn't testify, or that if any defendant doesn't testify, maybe they're hiding something or they must be guilty?
I should have put no, because reading that now, no.
Okay, and I understand the stress of being in these situations. you know, you're trying to get this done and you've got a million things on your mind and maybe you just, are you suggesting you just overlooked it? Or you
I probably didn't read it correctly,
okay,
so.
okay. So, and then finally, again, and I don't want to get on too much into your husband's disability. Would it be fair to say that he's the, you're his emotional support in terms of being home with him, and that there would be some sort of loss of emotional support for you not to be with him for what could amount 10 weeks, almost every day of the week, exception of Saturday and Sunday? Is that going to be a hardship? I guess I really want you to be focused on this case. I really want you to take the time to read everything and be clear about what you're reviewing. And what I'm really concerned about when I hear about family members who have to struggle with disabilities, it's a terrible thing to have to deal with. I just want to make sure that you're going to be able to focus and you're not going to be overly concerned about your husband, and because this is going to be a 10-week job for you.
Right.
And it's a significant job.
Right.
We're
I
here
understand that.
We're here on a very serious situation. I guess I want to make sure that you're going to be okay, because ultimately, it really needs to be whether or not you're okay. It doesn't need to be whether I'm okay or these 4 prosecutors over here are okay. It really comes down to whether you're going to be okay. I just want to make sure that you're okay.
I'm okay. Yeah.
Judge, that's all I have. Thank you.
Okay. At this point then, Juror 31, I'd like to just turn to the topic raised in part 5 of this questionnaire, and it's titled Attitudes Regarding the Death Penalty. I'll walk through a couple of your answers with you here. You did say that do you support or oppose the death penalty? You said oppose. And then, do you feel your views on the death penalty would prevent or substantially impair your ability to view the facts impartially? You said no. And the next question, would your views on the death penalty prevent or substantially impair your ability to return a guilty verdict of first-degree murder, even if the state had proven its case beyond a reasonable doubt? You also said no. So in this case, it may well be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. So looking at your responses there, I'll first let you know that any penalty you consider should be done as if it is absolute and will be carried out in this case. Your conscientious, religious, or other objections to the death penalty are not grounds for you to be excused as a juror. Do you understand that statement?
Right, yes, I do.
Okay. So going back to your answer then, having thought about it, although you may be opposed to the death penalty, you've also indicated it would not prevent you from either rendering a verdict if the state proved its case beyond a reasonable doubt. Do you still feel that way?
Yes.
All right. And you've also said it would not substantially impair your ability to view the facts impartially. Do you still stand by that answer?
Yes.
Okay, so even if you have a personal view opposed to the death penalty, do you believe you would be able to set aside your own view here and follow the law and instructions given to you by the court in this case if you were instructed that you had to consider that penalty?
Yes, sir.
Okay, that will conclude the court's line of questioning as it relates to her responses on the death penalty topic. The state may inquire on that issue at this time. All right, does the defense have any questions for the juror on that?
No, Your Honor, I appreciate your inquiry.
Okay, that will conclude then the individual voir dire of juror number 31. You can return to the jury room there, and we'll have the bailiff next bring in juror number 41. All right, juror number 4-1 has returned for individual for Dyer with the court and counsel. There's a couple of topics I'd like to begin with. Topic of hardship, which the juror mentioned of potential vacation plans May 30th, and also then some information about the case, so potentially bias based on pretrial publicity. If the state would like to inquire on those topics at this time, we'll move forward there and then see if we need to get into additional topics after that.
Before I hear you, okay?
Yes.
Right now. I just want to call your attention. Do you have your question? So I might just direct you to your question. I'm sorry. I've lost my voice. I'll try to stay closer. So ma'am, I'm just going to direct you to your question here to kind of help us in this process. I might invite you to turn to page 20 of your questionnaire. Question you had.
Yes.
We've noticed a potential hardship in the planned vacation that starts on May 30th. Could you just explain a little bit about that?
Yeah. So June 1st.
Okay, I'm sorry, we can't. Do you have the microphone with you? Apologies. We've got to pick it up on the record so we can go back later and read what you said. Thank you. Yes, if you'd explain again about your trip, please.
So, yes, we checked the June 1st.
Yeah, that's a week-long trip.
We come out, we check it on the 1st.
So with respect to that trip that you noted as a potential hardship, if you were selected to be a juror on this case, do you feel like the potential to miss that trip after your jury service goes into that planned time, is that going to be a problem for you, or is this a trip that you can rearrange or reschedule?
Yeah, it's very painful. Whoever your own family has taken the time off vacation with us. So yes,
Okay. And you've actually paid out expenses for this trip already? Yes. Negative too personal, so a large sum of money you have to pay for it. Excuse me. I next want to call your attention to the section of your questionnaire. I think you'll find it on page 7. It deals with your knowledge of the law. Whenever you're there.
Yes.
So I would just like to ask you some questions about your answers that you given on page 7. I'm actually going to go down to the bottom of the page under part 4, question E. And in that section, you were asked a question: do you believe that a person on trial who does not take the witness stand and deny the crime is probably guilty? And I believe you answered yes. Is that right?
I'm sorry, I can't hear.
Yes, on the question. Sorry.
Could you explain a little bit more about what you meant by your answer? Maybe I can just ask it a different way. Why do you think someone is necessarily guilty just because they don't want to take the stand?
I really don't know. We talked about that earlier.
I'm sorry, I can't hear you. I'm unable.
Okay. If you could just talk, I'm sorry, and I know it's difficult. And if you need a water.
No, it's one.
Okay, just speak right into the mic, but on your response, let me just Briefly, council, let me switch over and let Mr. Pryor maybe ask a couple of follow-up questions on these responses, on the general attitudes and knowledge of the law and her belief that maybe somebody ought to be testifying in order to explain their innocence. So, Mr. Pryor, if you'd like to question her on that topic, I think we could maybe cut to the chase here on this.
Do I understand Mr. Wixom's not judge? Or
Yeah, so she's indicated she feels a defendant should be required to testify, is probably guilty if they don't testify, and if they don't take the witness stand, is probably guilty also. And just to confirm, and again, it's fine, everybody absolutely has the right to their opinions, and that is the way you feel as you sit here today, is that correct?
Well, you talked to us about that earlier when we first came. What you said about that, and I'm thinking of
Well, and I guess the question is, do you still hold that belief that really you think someone should be required to testify in order for you to consider their innocence?
Oh, okay. No.
All right, well, I kind of broke things up here. Mr. Wixom, did you have anything further? And then I'll allow Mr. Pryor some additional word. I just want to vet out that particular issue.
Thank you, Judge. Ma'am, while we're in this topic area, there were just a couple more questions that I'd like to ask in this section. Please bear with me. It's really maybe different questions getting at the same thing, but if you were instructed by the judge that a defendant does not, under our Constitution, have to take the stand and testify, and he can invoke his right to remain silent, are you committed today that if the defendant chose to do that, that you wouldn't hold that against him?
Yes.
I'd like to go ahead and draw your attention down to page 8, please. And I'm going to call your attention to question number 2. And I believe it would be C. On that question, you want to ask, do you feel that the burden of proof should be greater than proof beyond a reasonable doubt, such as proof beyond any possible doubt or proof to an absolute certainty? And frankly, I think you've got both boxes checked. Which box did you intend to check? Fair enough. You can be. You take a moment, certainly.
Yes, it should be proved. That's right.
No.
I mean, it just as easy with the warrant.
Is that your understanding?
Yes.
Okay. And in your mind, would that be something different than proof to an absolute certainty? So if the judge gives you an instruction, understanding it can be a difficult concept. If the judge gives you instruction as to what reasonable doubt is, and inherent in that instruction, there may be some room to not absolutely know someone's guilty, but beyond any doubt that you reasonably believe is true. If he gives you that kind of an instruction, is that something that you need to follow?
Yes.
So just one last follow up on that. So you don't require absolute unequivocal proof before you can consider whether or not someone is guilty of a crime. That's fair. And you understand that question?
Yes, yes.
Do you have any other questions about? Ma'am, I know that there were some health related matters in your question here. Can you just tell the court now, are there any health conditions that you have that you think will impact your ability to serve on the jury?
Not really, no. I have bronchiectasis, but it's not. I'm sorry, couldn't hear that. I'm sorry, bronchiectasis, but it's just coughing, clearing the throat. It's fine. You can go for that. No, breathing, it's just fun, but other than that, it's nothing. It's nothing that would stop me from being here.
That wouldn't interfere with your day-to-day service on the jury?
No.
Is that something that's fairly treatable? Do you take treatment for it?
It's chronic, so it's just one of those things.
Okay.
I get a little bit.
Sorry to hear that.
No, it's fine.
Your Honor, at this time, we would just ask that the court consider striking the jury for cause based upon her hardship with her trip. She's indicated she already has this trip. It'd be the 9th or 10th week of the trial that she's paid, which I heard was a not a fair chunk of money towards the trip. And so we wouldn't want her to miss her trip, lose her money, or be stuck sitting on the jury resenting the fact that she lost her trip. And so we're asking that the court consider striking the cause based on that.
All right, Mr. Pryor, before you get into voir dire, then response to the state's motion to strike for cause based on expressed hardship.
Judge, do I have permission not to stand up?
Yeah, you can remain seated to talk into the mic there.
Judge, I agree with this. I agree with the state judge. I think at this point, I don't want her to miss a family vacation, and I think she ought to be afforded that opportunity.
All right, well, the state has made its motion to strike based on cause. So juror number 4-1, court's considered your responses. I will permit you to be excused based on a hardship, given that you've already paid for this planned trip, which is very likely to overlap with our trial schedule. So we very much appreciate you coming in for your service today. Please drop your questionnaire off with the bailiff, and we will move on to our next juror. Thank you. I believe juror 4-8 will come in next. All right, juror number 48, welcome back to the courtroom. We're going to conduct some additional individual voir dire with you at this time. I'm going to have some questions related to your questionnaire responses, and I'll start there, noting that we are in the process of obtaining jurors who are impartial without any knowledge of the case, which would impact your ability to be fair and fully consider only the evidence here presented at trial. So in response to your questionnaire on page 15, the question was, well, you indicated you followed the cases in the media. There's a question, has that caused you to already form an opinion regarding the guilt or innocence of Chad Daybell in this case? Your answer was yes. If he didn't participate, then he did nothing to prevent what happened. And so I guess beginning there, I'd just like to inquire, do you believe you've already formed some type of opinion potentially regarding the guilt of the defendant here?
Yes.
And would your opinion be different than presumed innocent at this point?
Presumed is the word where I get hung up.
And I guess what I'm wondering is, would you think that you're going to require some evidence to maybe overcome the opinion you've already made?
Yes.
And is the opinion you've made one that you believe the defendant may be or is guilty?
You're asking if that's my opinion?
Yes.
Yes.
Okay.
Yes, that's my opinion.
All right. Briefly then, I think there's a bias here very concerning, but if the state would like to ask any follow-up questions, I'll begin there and then see if the defense wishes to as well.
Thank you, Your Honor. I do have a few follow-up questions.
Okay.
Juror 48, you filled out this questionnaire last week, is that right?
Yes.
And I know there's a lot of questions on it. It's a lengthy questionnaire. And some of the questions you may have noticed kind of restate or ask for some of the same information. I noticed when you filled this out, you indicated that you have served on a jury before.
Yes.
And do you recall that experience?
Yes.
And it was a little bit different because it was a civil case.
Correct.
Do you feel that you were able to carry out your duties in that, on that
Yes.
jury? And on this questionnaire, I also noticed there's a section, and you might recall it, and I think they gave you your questionnaire, and I believe it's page 11. It had a 1 to 5 rating system. And 1 was strongly agree, 2 was agree. And there's quite a few of them, but I noticed on there that when it said I would review all the evidence before I make a decision in this case, you'd indicated a 2 for agree. And I would listen to all the evidence before I make a decision. You also had done a 2 for agree. Would that still be accurate today, that you feel you would listen and review all the evidence before making a final decision?
Yes. I should state, I'm naturally very curious and analytical to a fault. Sorry.
No, that is fair, and I appreciate that information. And then we've gotten down to the section that the judge was going over with you on the media. And you did indicate that you have seen some media on this, and you've talked to some people from out of state. But I also noted when the question came up of, do you have any knowledge of Chad Daybell that would keep you from acting impartially? You'd indicated no. On knowledge of, do you have any knowledge of Chad Daybell that would cause you to give either greater or lesser weight to any statement? You'd also indicated no. Would those still be accurate today?
Still accurate.
And then I think where the judge had talked about was there was a question if you'd formed an opinion of guilt or innocence, and your response was yes, if he didn't participate, then he did nothing to prevent what happened. But then it went on to ask you, would you be able to put out of your mind what you have read or heard and act impartial? And you indicated that you could put it out of your mind. And I know the judge just asked you today if you've got this presumption of guilt, but we also had talked about earlier in voir dire the recipe and being given instructions. If you were given an instruction to put out of your mind anything you'd heard before and only weigh the evidence and information presented in this trial, in this case, do you feel that you would be able to do that?
Yes, I could.
Your Honor, given that, the state would ask to have him remain on.
Okay. Let me ask the defense at this point, voir dire, Mr. Pryor, on the issue of bias.
And so again, I think when I spoke to all of you, I told you there's no right or wrong. We're all absolutely entitled. You would agree, right?
Agreed.
And as an analytical person, based on the information you have at the present time, you're going into this situation with some concerns about this case, correct?
I wouldn't use the word concern. Sorry.
No, that's okay. What word would you use?
Did you turn on your microphone, Mr. Pryor?
I did, Judge. You know, again, technologically inept.
Yeah, no, you know, as I stated, I read every day. I do have an opinion. I did try to be as honest as, and to the point as I can be. So I'm not concerned. Just neutral is the best word, other than I do have an opinion.
Okay. And as part of that opinion, the questionnaire, and I'm looking at page 19, and it's about the middle of the questionnaire. And it says under item D, has any of your possible exposure to news reporting, dramatized depictions, or other publicity around the case form an opinion about Chad Daybell's guilt or innocence? And you said yes. And then you responded, I believe that Chad Daybell is a weak character.
Yes.
So when the judge inquired of you that whether or not you formed an opinion, and the prosecutor touched on this a little bit, you answered the judge's questions, and I have absolute belief you're being completely honest that at this point, Judge, I have the belief that not only is he a weak character, but I tend to believe that he may be guilty, but I'll go and I'll review all the evidence before I make that final determination. Is that fair?
Fair.
And is it fair to say that before you make that final determination, right now, you're saying, listen, I'm leaning towards the fact that I probably believe that he's guilty, but before, again, I make that final determination, I'm going to give both sides a chance, but at this point, he's a weak character, and I think he's probably guilty. Would that be a fair statement?
Almost.
Okay, please clarify that for me then.
Well, I would have to hear the instructions from the court
Okay.
to define guilt and the charges.
Okay, but at this point, your position is the weak character and guilty, but I'm going to listen to the instructions and I'm going to look at all the evidence. Would that be fair?
Yes.
Thank you, Judge. I have nothing else. I'm going to move from pause, Judge.
All right, consider the strike for cause request made by the defense as to juror number 48, juror number 48. This is precisely the reason we have this individual section of questioning, so we can discuss this, frankly, with you without the other jurors' presence there. The court, having considered the responses here and concerned there's been a improper shifting of the burden that's afforded to the defendant on a presumption of innocence based on pretrial publicity in this case, with this particular juror, for that reason, I am going to grant the motion to strike. So juror number 48, that will conclude your jury service, and we appreciate you coming in today and taking your time as well as last week. You can be excused with the thanks of the court. Please leave your questionnaire with the bailiff, and we'll have our next juror brought in for questioning. All right, I believe next up will be juror 56. All right, thank you for returning. This is juror number 56. At this time, we're going to conduct individual voir dire, beginning with the issue of potential bias. There wasn't really expressed anything in here relating to hardship, so let's start there. Let me just ask juror number 56, you've been provided a copy of the questionnaire you completed last week. To your best of your recollection, are all of your responses in there still accurate and true today?
Yes.
Okay. I'll let the state inquire first as it relates to any potential bias here, then we'll move on to the defense. Just going for the state this time.
I will, Your Honor.
All right, Mr. Wood.
Thank you, Juror 56. Thank you for being here. I noticed on page 7 of your questionnaire, you have a bachelor's degree in religion.
Yes.
So this case does have some religious elements involved. Are you, if the defendant has religious beliefs different than you, is that going to sway your opinion in any way?
No.
You can commit to that you're not going to judge him based on religious beliefs.
Yeah. I'm sorry, I can commit to that.
It looked like in your questionnaire, you have some news from, I think you say Idaho News apps and CNN. How much news have you seen in regards to this case?
That's hard to quantify. I have seen like articles here and there from the case. I don't watch the news, and I don't get on news apps regularly. So I recall seeing something about it pretty early on. I recall seeing something about the arrest in Hawaii. I recall seeing something about the search for the children's bodies. But I make it a point to avoid the news, and so it's not something that I do on a regular basis. And I certainly I don't follow any cases intentionally.
And so it's fair to say, in this case, you have not actively followed the news in the case.
Correct.
I did want to speak with you about one of your responses on page 19. It's in response to question 10F. And the question is, have you formed any personal opinions whatsoever based on information from any source of Chad Daybell's guilt or innocence of anything? And you said, I do recall a sense of, quote, he probably did it, unquote. Tell us about that. How deep of a conviction is that?
It's certainly not a deep conviction. That was my brutal honesty. I do recall that. I don't recall what it was that brought that sense. I think that was just probably happened and then moved on. That's certainly something that I can actively set aside, practicing neutrality.
So, yeah, I did notice in 10E, when it asks if you're able to put what you do know about the case out of your mind and render an impartial verdict based solely upon the evidence in the courtroom, you said yes, and you say, I believe so. So we talked earlier about landing that point. Like, can you commit completely that you will set aside anything you've known about this case and render that impartial verdict?
Yes, I believe I can. I believe it would be a daily practice of, bringing yourself to kind of recommitting that every day to keeping your focus on the evidence before you. And I think that bias is something that is easy to say you don't have, but it's like rarely the case that somebody doesn't have some sort of bias. And so I see it professionally as well as something that I intentionally practice on a daily basis is maintaining neutrality.
Okay. And you do understand that this defendant doesn't have to prove anything to you, correct? Correct. And that it's completely the burden of the state to prove his guilt. Correct. Okay. No further questions, Your Honor.
All right. On that topic, then, Mr. Pryor.
Yes. And ma'am, you mentioned your occupation. Going off memory a little bit, but it's forensic interviewer, if I remember.
That's correct.
Is that what it is? And you work with a program of young children and issues and you interview them to make assessments.
That's correct.
And
Well, can I clarify that?
oh, absolutely.
Partially.
Please.
It's correct that I interview young children. However, it's not my job to form an assessment of any sort. I simply report what was disclosed to me
In more of a law enforcement capacity. It's not necessarily law enforcement, but in terms of what law enforcement should be doing, rather than taking a position, you're just reporting facts. Would that be fair?
right and for medical purposes.
And obviously, one of the concerns that came up to me, flagged this a little bit. And again, I think I spoke to you folks before and said there's no wrong answer, there's no right answer. There isn't. We're just all trying to, and it's a horrible thing to have to go through this. But one of the concerns I have is that two of the victims are children. And when I read your profile, I assumed that you would suggest, you seem very analytical, and when I realized you're a forensic interviewer, I realized, oh, that's why it's very analytical. One of the concerns I have is that I'm not always able to discipline myself to stay focused on the task at hand. And when you say it's going to be a struggle, or it's going to have to be something I'm going to have to work on every day to not allow that bias to creep in, what that's kind of telling me, and then if I'm being honest with myself, I agree with you, it's a struggle. And when you have bias, or you feel like you've already made a decision, it can be difficult when you're going into a matter saying, listen, yes, I believe this is what happened here. I believe this is what's going on. And that's really what you said, if we're being fair, correct?
Sorry.
That's okay.
What part were you saying that
Well,
I
about
said?
forming an opinion, he probably did it. You formed the opinion, and you said, yes, I have formed an opinion. That's fair, correct?
I wouldn't call that forming an opinion. It was a kind of a fleeting thought at the time that I recall having when I first saw the news. But it's not something that I've formulated. It's not something I've pondered or thought about or followed.
And that's why we're talking about this, because I want to make sure that at the present time, you haven't formed an opinion about whether there's guilt or innocence here, correct?
No, I certainly have not. It's extremely important to me personally and in my profession to remain neutral until you do have evidence before you. So when I say that it's a daily practice, it's not because it's a struggle, it's because it's a proactive practice of neutrality. So it's because neutrality is so important that I come to it every day and, before every interview, and consider, the potentials on both sides.
And I really appreciate you taking the time to explain that, because it sort of explains your answers. Gives me the opportunity to hear it from you when you're saying, listen, this is really what I mean by this, because you can imagine you get a piece of paper, blanks that you're crossing off. I imagine you've been through the same thing and say, wait a minute, this doesn't really explain how I feel about it. Here today, I think I have a better understanding. I want to thank you and appreciate you taking the time to educate me. Judge, that's all I have. Thank you.
All right, thank you. The next issue I'll get into with juror number 56 here then is going to be on the section of your questionnaire you filled out on page 12 called the attitudes regarding the death penalty. Juror 56, do you recall filling out those responses in the questionnaire?
I do.
Okay, and are those still true and accurate to the best of your knowledge?
They are.
All right, I did want to just take a look at a couple of responses again. We're just trying to ascertain for sure your opinions here. On a question, do you support or oppose the death penalty? You check the box support. I notice on the general attitudes part, which gave you some multiple choice, pick the one you like best. D, you said you were generally opposed to the death penalty. So in answering that question, would you say you support or oppose, or is it a more complicated answer than that for
I
you?
do think it's more complicated. I kind of noticed that this, on number 6, that the answers were sort of organized in a spectrum. And I just felt that the one above, I generally favor the death penalty, was not accurate. That gave me the sense of, oh, in a lot of cases, I would favor the death penalty, and that's certainly not the case. And that's why I chose D over C.
All right, well, I am going to advise you that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. So with that in mind, if you are generally opposed to it, going back to your response part D, and again, this is somebody else's statement, not yours, but you agreed with this, as you mentioned on the spectrum answer. I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. So do you still think that best represents your position on the death penalty?
I think it does. I guess the way I'm reading it, I should just clarify, when I was thinking, I generally favor the death penalty. I was thinking about that broadly in a lot of different cases. If I were to think about it more narrowly, just because I'm not well versed in the law around the death penalty. I don't know when it's even a possibility in a case. I assume that it's only on the table in more extreme cases. So I think that's why I wasn't sure how to answer. If the death penalty were on the table in a great variety of cases, then I would continue to be opposed to it in general. But if it's used sparingly and for more extreme crimes, then I would be in support.
Okay. The question I will have then is this: if I were to instruct you in this case that you are to consider the death penalty, will you be able to follow my instructions and consider the penalty of death?
Sure.
All right, so are you representing here that you would be able to set aside your own views and follow that law and instruction if it were provided to you in this case?
Yes.
Okay, that will conclude the court's voir dire portion of that for this juror. I'll allow the state any follow-up questions.
Thank you, Your Honor. The state doesn't have any follow-up questions.
All right, from the defense.
And ma'am, you mentioned use sparingly. Could you clarify that a little bit? What do you mean by use sparingly?
I think I wrote in my in the previous questions that I don't know data on it, but I'm aware that Idaho hasn't executed an inmate in a very long time. And so I would consider that pretty sparingly used.
Okay, and when you made the comment that extreme cases, does that mean that in a situation where, nothing I say isn't to imply that Mr. Daybell's guilty, right? We're talking about this because we have to. But if the death penalty is one of the options in a murder case like this, does that mean if you find Mr. Daybell guilty, does that immediately mean you go to the death penalty and that will be your vote? Does that mean how you support it, or is it different?
No, I just meant that I certainly, those are two very separate decisions. I just meant in extreme cases such as in regard to the crime itself. Obviously, I wouldn't support the death penalty for a burglary case.
Right. But does it mean that your vote would automatically be the death penalty if someone was convicted of murder?
No, those are very different decisions to me.
Right. And when you say extreme cases, you've heard the name Jeffrey Dahmer.
I have.
A serial killer. That's an extreme case, right?
I would, when I say extreme, I'm referring to murder.
Okay, so murder in general is an extreme case.
Yes.
And again, and that is your vote on it?
No, let me clarify.
Okay.
Murder happens in so many different ways and so many different, circumstances that I'm not saying that in all murder cases, I think the death penalty would be appropriate.
Okay.
But I am saying that I would support it being considered.
That's where I was trying to get you at, is I was trying to clarify your position a little bit. And again, I want to repeat, there's no right or wrong answer. I'm just trying to understand. And again, in this context, you've clarified a number of your positions. You said, well, this is why I clarified that. And that's why we do this. The court is kind enough to allow us to go through this because we're trying to clarify it. If I understand your position, and please correct me, is that just because there's a murder doesn't automatically mean it's going to be the death penalty. If there's a murder, I'm going to look at the facts. I'm going to look at whatever evidence and make a determination based on what the court tells me are my options in that case. Would that be fair?
Yes.
So, and please forgive me, I'm not trying to put words in your mouth. That sounds like a very neutral position. Would it be fair that you're very neutral on the death penalty?
I think so. I think that's why I struggled in picking between C and D on number 6.
Okay, and that's what I was trying to clarify. I was just trying to understand it, and I appreciate that you're going through this. I really do, and thank you for all of your answers. Judge, that's all I have. Thank you, Your Honor.
All right, thank you. Juror 5-6 then, that concludes the voir dire portion individually. We'll go ahead and I'll have the bailiff escort you back to the jury room, and we will call up our next juror for individual questioning, juror number 121. Some point, council will talk about scheduling, but I do want to get through this group of individual voir dire with the next, and then we'll discuss where we stand, because we've got another group cleaned up to come in here in 15 minutes, and I presume everybody probably needs some lunch. All right, thank you for returning juror number 121. This is time we're going to conduct some individual voir dire examination, beginning with the issue of bias. We've also got a request you had on here regarding a potential hardship, but let's start with the questions of bias. I'll have a few questions, and then I'll allow the state and the defense. In particular, it appears you've been exposed to some pretrial publicity on this case. You may have some opinion at this point regarding the guilt or innocence of the defendant, in this case, Mr. Daybell. So just to begin, are the responses you put in your questionnaire still true and accurate?
Yes.
Okay. I'd note you answered one question about whether you formed an opinion, and you said, quote, it seemed like he was guilty from that info. And then on another page, you also said, I did think that he was guilty. I'd like to just go into those topics with you if I could. Is that still the way you feel today?
Yes.
Okay, as you sit here today, we instruct every juror in every case that a defendant is presumed innocent and only to be tried on the facts of the case. Am I correct in understanding that you, based on information you already know, maybe do not believe the defendant is innocent as he sits here today?
Well, I don't know. I feel like more what I was saying on the questionnaire was that obviously I never thought that I would be on this jury, so I was more, reading an article and then just being like, oh dang. But I feel like through our conversation today, I do understand that you have to be impartial. I don't know if that makes sense.
Okay. I'll allow the state to conduct some more dire on that issue of bias then, and then we'll allow the defense as well. So who will be doing this one for the state?
That would be me, Your Honor.
Okay, Ms. Beatty, go ahead.
Thank you. Hi. So you had mentioned in your questionnaire that you had read articles that detailed the alleged crimes in this case. And you were aware of when the bodies of the two children were found, and that at some time you learned about Chad Daybell as well. And as the judge mentioned, you concluded from reading those articles that he seemed guilty at the time. And I think you also indicated on your questionnaire that you think that you could set that aside.
I think so, yeah.
Are you sure?
Yes, I think that I understand the responsibility.
Okay. Do you think that you would be able to, because our system requires that all of our jurors go into this trial believing that the defendant, as he sits here today, is innocent until we, the prosecutors, meet our burden of proof. Can you commit to setting that aside, or are you kind of on the fence like, oh, I'll try, or I'll do my best? Are you able to get some certainty that you can set that aside?
I feel like it's hard because I think I could if it was given the situation where I had to do this. I do think that I could be fair.
Okay. I also just want to ask you briefly about one other thing that you referenced on your questionnaire, which was a golf tournament that you're helping plan for work.
Yeah.
And that was on May 3rd.
Yes.
Is that something that somebody else at your work could take over those responsibilities for you, or that you would be able to do after court on that schedule outlined in the questionnaire where we recess at 3:30 every day?
Yeah, I'm like the fundraising person for my job. So it's not like I have a department. So like I would be the one planning this. I think I could do the planning, but it would be very difficult the day of to not have me there. That being said, I think that I could probably rearrange to find someone.
And when you say the day of, is that on a weekend or is that on a weekday?
It's on a Friday.
Yeah. Okay. All right. I don't have any other questions at this time. Thank you.
All right. On the topics then of bias or hardship, Mr. Pryor, you can inquire.
It's afternoon now, isn't it? You're the marketing director, is that right? Significant job. What caused me some hesitation, and again, there's no wrong answer. I think I spoke to you folks about that earlier. There's no wrong answer. I'm sorry. Can you hear me now? I'm sorry. There's no wrong answer. I'm a little concerned about you being distracted. When a week before May 3rd, a week after May 3rd, on May 3rd, which is a Friday, and that your focus is going to be other things, and you could understand the magnitude. You put that on your questionnaire because it's a significant event. And would you agree with me that this would be a hardship for you to have to be here and go through this process? And you may not be able to push that out of your head. It might be problematic. Is that a fair statement?
Yes.
So in your mind, it's going to be a hardship for you to serve, knowing these activities that you're primarily responsible for.
Yes.
And this isn't I'm very familiar with your organization. I won't get into that, but it's not like heavily staffed.
No, I'm the only person that does my job. So I would have to be like looking after work stuff.
Right, and that's going to be a distraction in itself. Is that fair?
Sure, yeah.
And then again, there is no wrong answer. Everybody has a right to the opinion. I have an opinion. These 4 prosecutors apparently have an opinion. And you have an opinion. And when you said, I did think he was guilty, it's going to be a task for you to say, listen, you know where I'm going. It's going to be a task for you to say, I've got to look beyond that. And I've got to remind myself regularly that he's not guilty, and try to make a concerted effort in your own mind to look at the evidence impartially and without bias. It's not going to be just, you're not starting the slate with that. You're starting the slate with a mindset that, listen, unfortunately, I think he's guilty. And then I have to talk about this. We We have to talk about this because it's part of the process. I don't think Mr. Daybell's guilty, and Mr. Daybell's here saying he's not. But in your mind, you're gonna have to make an effort to look beyond your personal feelings and focus on trying to be unbiased, trying to be impartial. Would that be fair?
Yes.
Okay, all right. Judge, I'm gonna move for cause. And again, this is nothing personal or anything else. I just think that she has a hardship that she's gonna need to focus on, and that her opinion, although it's important, it just doesn't fit in this particular situation.
Response from the state on the request to strike.
Your Honor, we have no objection to excusing this juror.
All right, juror number 121, mainly on an issue of, I think, some preconceived bias here. And again, nothing personal. We all are entitled to follow the news and think what we think about it. But in this particular case, it would be best to have jurors without that exposure if possible, which is why we brought so many people through here as well. I am going to grant the motion for striking juror 121 for cause. That concludes your service. Thank you for coming in, and please leave your questionnaire with the bailiff. We'll next talk to juror 146. All right, you're juror 146, correct?
Yes.
Okay, thank you. All right, in this case, on juror 146, looking at the questionnaire, there was some indication of case knowledge there. So I think you need to explore whether there's any preconceived bias in the case by this juror. I don't see any listing of a hardship, so if the state would like to inquire on bias, we can start there.
You can hear me okay?
Yes.
Ma'am, I just have a few questions for you today, so I know my voice. I understood what the court just said, that the use of the state any hardships. I did have one quick question, because you did note that no, it wouldn't be a hardship to be on the jury, but you put in a sentence. I do have 5 kids. What did you mean by that?
I mean, I have 5 kids. I think I was more referring to the sequestering card if that ever had happened, that I would just like to be able to check on my kids. You know, at the end of the day, that's something that happens.
Okay, so your kids are of sufficient age that you could potentially serve for 10 weeks. It wouldn't be a
Excuse me. Oh, try not to talk at the same time as each other so we get a clear record.
Thank you, ma'am. And then I noticed, I believe in your questionnaire, you want to ask if you had information about the case. I think you noticed maybe some information from Facebook. Am I recalling that correctly?
Yeah, just seeing things on Facebook over the last couple of years.
Without getting into all the details of what you've learned about the case, how much information would you say gauge that you have? A little bit of information? Do you feel like you know a bit? How much information do you feel like you've collected?
I don't know very much. Just in passing, it's not like I've researched her.
So there would be no reason to think that whatever you've learned would impact your ability to be impartial, to listen to the evidence in the case.
Absolutely.
And then one last question on this topic. If I recall correctly from your questionnaire, you work as a daycare worker. Do you own the daycare? And you don't feel like there's anything about your day-to-day work with the children, understanding that there are allegations of children who were killed here, that's not going to do anything to cause you to be impartial?
No.
I'm sorry, less partial?
No.
You know, on these kinds of questions, I don't have any other questions for you later though.
All right, thank you, Mr. Wixom. Mr. Pryor.
And Mr. Wixom brought that up. It still always amazes me that someone can have 5 children and maintain even any kind of sane household. And then we know that in your situation, you have an entire scale of children. My recollection is it's a 4-year-old, a 7-year-old, a 13-year-old, a 16-year-old, and the last one's a 17-year-old. 2 kids in high school, 1 in middle school, 1 in grade school, and 1 getting ready to start school. And then you are you're working at daycare as well, and your husband's a landscaper. Please forgive me. I don't even know how you can stay awake, let alone anything else. That seems like an awful lot to me.
It is a lot, but it's what I do.
And what the concern is that I'm worried that you may not be able to focus, you may not be able to spend the time, and that you're going to be worried about your children, and I'd be worried about my children too if I was in that situation.
If I was worried about my children, I wouldn't be here right now, and I would have said in the beginning, it's not something I'm comfortable doing.
Okay, and that's why we're talking about this. I don't want to, there's no wrong answer. I just want to make sure how, because you when I saw what you go through, I'm frankly, I'm amazed that you're able to do all of that. One of the concerns, and Mr. Wixom brought this up, is that you said that every night, if you had to be sequestered, you would need to be able to get on your phone and talk to your children to make sure that they're okay every night.
Not necessarily talk to them, just, hey, everyone's home, everyone's good, hey, love you, bye.
So it would be a situation where you just need to have some confirmation. And let's say you were sequestered for 2 weeks or 3 weeks. Is that going to cause a hardship?
I don't think so.
Okay, so you would be able to focus on this. Yeah. Okay, and ma'am, I thank you. I appreciate the answers. And please understand, I have to ask this because I want to make sure that you're going to be able to focus on this. And this, I think, was a legitimate question. I feel it was.
Yeah, I think so too.
Okay, thank you, ma'am. I appreciate your answers.
All right, the next topic the court is going to address then here, Juror 146. There was a section in your questionnaire, I'm sure you recall it, called Attitudes Regarding the Death Penalty. Do you remember working through that portion of the questionnaire and answering?
Yes.
Are the answers that you provided in that questionnaire still true and accurate today?
Yes.
All right, one thing I noted, well, I'll pass on that. It looks like you vacillated a little bit on do you support or oppose the death penalty. You said support, and then you also kind of checked opposed and said depends on the crime. So there was another response you had, and it was one that was on a list of choices, but it said, I generally favor the death penalty, but I would face a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel today?
It is.
Okay, the court does need to advise you that it may be necessary for you to make a determination in this case in regard to the imposition of the death penalty or some other penalty. So with that comment you just made, and you've indicated you would in fact follow the instructions provided by this court if that were required in this case. Is that correct?
That is correct.
Do you feel like you would always be in favor of the death penalty in every case where a murder was committed?
Yeah.
All right, so regardless of your current personal beliefs on the topic, is it correct for me to say that with your views on the death penalty, you would be willing to follow the court's instructions in this case, even if it involved an instruction that you consider that as a possible penalty here?
Yes.
All right, that concludes the court's line of questioning on that section. Was the state going to inquire?
I do just have a couple of questions.
Okay.
Do you have your question now with you?
I do, yeah.
It might be helpful. I might invite you to page 12, the questionnaire. I just to call your attention to the answer that you wrote down for paragraph 1, question A. How do you feel about the death penalty? You made a couple of comments explaining it, and I understood what you just explained to the judge. In the comments, you said that you feel like it's fair when it's appropriate, but there could be other ways to punish the offender. Could you just explain a little bit more about what you were trying to convey there?
I was trying to convey that maybe if whoever was being accused of the crime had a mental instability or a mental problem, that they would benefit from being in a psychiatric hospital instead of being put to death or just put in jail for the rest of their lives.
Okay. So, is it still fair to say that you'd be willing to listen to whatever instructions the court gave you, consider whatever facts were put in front of you, and simply apply the law to the facts and if those kinds of issues were to ever come up in the case? And that if under the facts given law, if some other alternative like that was an option, you follow what the judge tells you would be the options for deciding what to do with the death penalty.
I would follow the law.
I don't think I have more questions.
Judge, I don't have any questions. Thank you.
Okay, thanks for coming in and answering additional questions in this section. I'll have you return to the jury room with the bailiff, please, and then we will next call it Juror 186. All right, juror number 186, thank you for returning for additional individual voir dire. In reviewing the questionnaire, I don't really believe we had issues of bias to further discuss in this. Did the state have any voir dire related to bias on this juror or hardship?
No, Your Honor. Thank you.
From the defense?
No, Judge.
Okay. So, juror number 186, there is one additional topic then the court will cover with you, and that's regarding responses you had on section 5 of this questionnaire, which is entitled Attitudes Regarding the Death Penalty. And that's on page 12. Do you recall thinking about those questions and answering those last week?
Yes,
And is that still the way you feel about that topic?
yes,
All right, I am going to advise you that it may be necessary for you to make a determination in this case in regard to the imposition of the death penalty or some other penalty. So you've indicated in here that generally you would support the death penalty. Is that still the way you feel today?
that I support the death penalty.
Yes.
Yes,
All right, on page 13 out of a list of choices, you circled C, which reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Do you still feel that way about this topic?
yes,
Okay. Finally, then, the question I would have is, do you believe that you would be in favor of the death penalty in every case where a murder has been committed?
if they're guilty, yes,
Okay, if you were not instructed and it was a case that didn't include that, would you follow the law?
yes,
All right, so going back to that part C, if that were something you had to consider in this case, would you commit to following any instructions the court gave you on that topic?
absolutely,
And if that included a potential that the death penalty was not to be imposed, would you consider that as well?
absolutely.
All right, that will conclude the court's line of questioning on that topic. Anything from the state?
No questions from the state, Your Honor.
All right, Mr. Pryor, any questions for juror 186?
Just briefly, Judge. And again, sir, I think I heard earlier saying there's no wrong answer. Everybody has a right to opinion. I guess I got the impression that I don't know why I got that from your questionnaire, that if there was a murder and someone was convicted, you would automatically go to death.
No, I was, not that they're being tried for murder and it's a death penalty, yes, I support it.
Okay.
Yes, is what I mean by that.
Okay. So this is in no way to imply that Mr. Daybell's guilty of anything.
Correct.
We have to ask these questions.
Correct.
I can appreciate that, right?
Yep.
If in fact there was a guilty verdict, are you predisposed based on your position to say, listen, I am predisposed, or I believe that if there is a murder, that it needs to be the death penalty, but I would be open to considering other options. But my initial instinct is if there is a murder here, it has to be the death penalty unless you convince me otherwise, or that I see something that gives me pause not to impose the death penalty. Would that be fair, sir?
Yes.
Okay. So in other words, at this point, your position is, and again, I want to reiterate, nobody's answer is wrong.
Correct.
I mean, we run the gamut on this jury pool. I'm just trying to clarify, and you can appreciate that, right?
Yeah.
Okay. So your position is simply that if a person has been, so I sit on the jury, if a person is found guilty of murder, my default position right off the bat is that I'm going to impose the death penalty. Unless somebody gives me a reason not to impose the death penalty.
I guess if they're being charged for murder and death penalty is, if the state's seeking death penalty, then that's what we're going for, right?
Right. And that's what you're gonna do.
So I'm going to take all the facts of the case into consideration before I decide anything.
Okay. But before you decide anything, you're initially gonna say, listen, I'm in favor of the death penalty, I'm gonna vote for the death penalty, but you've got to show me something, either the prosecuting attorney or the defense attorney's got to show me something to not change my mind about imposition of the death penalty. Is that correct?
Yes.
Judge, in all respect to you, sir, I'm going to move for cause.
Response from the state?
Your Honor, may I ask some questions in aid of the prosecution?
You may.
Thank you, Your Honor. Juror 186, I think on your questionnaire you marked C, that you would potentially impose death, but you would consider other punishments.
Correct.
Is that still correct today?
Yes.
And we talked before about the recipe and following the court's instructions. Are you committed to following instructions given by the court?
Absolutely.
And would you weigh all evidence before making any decision as to guilt or any penalty?
Yes.
So your default really wouldn't be always to go to death. Would that be correct?
Correct.
Your default would be to follow the court's instruction and weigh the evidence.
Yes.
You'd be willing to impose death, but not default to that.
Yes.
Your Honor, I would object to the motion to strike for cause.
All right, the court's considered the responses here and the motion to strike. The issue the court's looking at is whether or not there's been presented an opinion that, in this case, this juror's views on the death penalty would prevent or substantially impair his ability as a juror to perform his duty in accordance with the court's instructions and the oath. I do find that he's answered that he would follow the court's instructions such that the motion to strike is overruled. And so juror number 186, that will conclude this section of the individual voir dire, and I'll have you return to the jury room and we'll call up our next juror.
Thank you.
This will be juror number 219. All right, welcome back, juror number 219. This is the individual voir dire of this juror. The court's reviewed the questionnaire. There is some indication potentially of some pretrial publicity, knowledge or information of the case. And there is not any indication of a hardship concern. So if the state would like to inquire on bias, we can begin there and then I'll hear from the defense.
Thank you, Your Honor. Juror 219, in your questionnaire, it did say on page 18, you've seen brief television coverage.
That's correct.
Is this coverage that you sought out or that you just happened to see while you were watching TV?
The latter.
And have you intentionally followed this case in any way?
No, I have not.
And I noticed you didn't say you read about it online. Is that accurate?
That's correct.
Based on the amount of coverage you did see, you claim that you have not formed any opinion about the defendant's guilt or innocence, correct?
That's correct.
And that's still true today?
That's correct.
Your Honor, the state has no further questions about bias.
All right, Mr. Pryor.
Judge, I don't think I have a question.
All right, thank you. The topic then the court will discuss next, juror number 219. In your questionnaire, there was a section in there, part 5, it was on page 12 where we started, that it was regarding your attitudes about the death penalty. Do you remember reading through those questions and answering those questions?
Yes, I do.
Okay, and the responses you made to those questions, are those still true and accurate today?
Yes, they are.
All right, well, the court will advise you here that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. So with that in mind, you answered that when asked if you support or oppose the death penalty, you indicated you support it. Is that correct?
That's correct.
And the next question I would look at was when you were given a range of choices to select from that best describe your feelings about it. You answered one that was 6C, which says, quote, I generally favor the death penalty, but I would face a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel today?
That's correct.
Okay, and then finally, let me just inquire then, would you be in favor of the imposition of the death penalty as a punishment in every case where a murder has been committed?
I believe that I would, I think the cases are individual and the decision to impose the death penalty would depend on the individual case.
Okay, so if in this particular case, certain instructions were given, either that you had to consider it or were not to consider it, would you follow those instructions regardless?
Yes, sir.
Okay, so despite any personal view you may have, you would commit to following the court's instructions as they would relate to that portion of this case if that were to occur?
Yes.
All right, that will conclude the court's voir dire on that topic with juror 219, the voir dire from the state.
Not at this time, Your Honor.
From the defense.
Yes, juror number 219.
Microphone, please, Mr. Pryor. Thank you.
Juror number 219. When I had all of you folks there, I talked about there's no right or wrong answer. I'm repeating that to almost every other juror that comes in. And there is no right or wrong answer. It's everybody's individual personal beliefs, right?
Yes.
And when the judge asked you in every murder case, would you impose the death penalty? Your answer was no. Every case is individual and different.
That's correct.
Is there a line on the types of cases where you say, you know, there is no situation? I mean, for example, if we were in a war and there was a mass genocide and the soldiers decided to wipe a number of Americans out, that's obviously a very extreme case. Would you agree?
I would agree that that's an extreme case. I believe what you're trying to get at is, you know, there's black and white and there's a whole lot of gray.
Okay, that's really what I'm trying to get at. And there, when you're talking about the death penalty, whether to or not to impose it, it's that gray area there, correct?
Yes.
And when you look at your questionnaire, you marked number C. Did you contemplate possibly marking number D when you were going to mark that?
I'm sorry, could you read that for me?
Well, under number C on page 13, do you have your questionnaire with you?
Yes, I do.
Okay, and you circled number C. Remember that?
I'm getting there.
That's okay. We're fine.
And your question is whether I considered,
Did you consider C or D, or were you a pretty strong B?
I would say pretty strong C.
Okay. And again, is there a line that's drawn in terms of what is an automatic that prompts you to say, you know what, there's no discussion here, it's going to be the death penalty? Before you make a decision, is there a line in the sand that says, these are the cases that I absolutely have to impose the death
I don't have that line in mind.
penalty? Okay. Are there cases that involve children that potentially cause you to want to impose the death
As I said before, there's a whole lot of gray.
penalty? Okay. And I appreciate it. Again, there's no right or wrong answer. Based on your questionnaire, I was just trying to clarify where your position was. Okay.
Yes.
And thank you for your time. I appreciate it. Judge, I have nothing else. Thank you.
All right, thank you. Juror 219, that'll conclude the individual voir dire. You'll return to the jury room, please, with the bailiff, and we will next bring in juror 321.
Judge, I have 296. I'm sorry.
All right, thank you. I was out of order there. It is 296. All right, welcome back for individual voir dire, juror number 296. I'll just allow the state to proceed, and then the defense. There was some knowledge this juror had of this case potentially from media coverage, and she did address some concerns about school classes, but I think those have been talked through. However, if you wish to inquire again, you may. So with the state is going to conduct this voir dire.
That would be me, Your Honor.
Okay, go ahead.
Thank you. Hi. So I want to just briefly follow back up on your class schedule. You had indicated on your questionnaire that you have a Monday, Wednesday class and that you would be able to take those classes online. So you're sure that you'd be able to do that? Or
I am not sure, but I believe I would because they are classes that are off, so.
they're hybrid?
Yeah.
Okay. What would happen if you were to learn that you weren't able to take those classes online? Would there be other accommodations that you could make for your schooling, or?
I believe I could withdraw from it.
Okay. And would that cause you a hardship to have to withdraw from that course?
No.
Okay, thank you so much. I want to talk briefly about media exposure in this case. So on your questionnaire, you had mentioned that you had seen the news, you'd seen some stuff on social media, Instagram, as well as some podcasts. Which podcast did you listen to?
I don't think it was a podcast. I think it was YouTube, but I've watched a couple different, like Annie Elise. That's the only one that comes to mind that I watched, but I haven't watched or seen any of that probably in like a year or so, maybe even longer. I actually kind of forgot what's going on.
Okay. You had indicated that you have not formed an opinion on Mr. Daybell's guilt. Is that correct?
Yes.
Okay. You did mention one thing, which is that you realize something to the effect that you understand that there could be more to this than what's in the media.
Yes.
And you had indicated that you were unaware of Chad and his representatives or representations and views.
Correct.
So one thing that you're going to be instructed during this trial is that the state has the entire burden of proof, and Mr. Daybell doesn't have to testify at all. Is that something that would bother you?
No.
Okay. Are you comfortable with the fact that Mr. Daybell is entitled to a presumption of innocence until the state meets its burden of proof?
Yes.
Okay. And would you be able to set aside what you have heard and read about in the media and start this case with a clean slate and listen to the evidence as it's presented and follow the court's instructions?
Yes, I believe so.
Thank you so much, ma'am. I have no further questions.
All right, thank you. Ms. Beatty, Mr. Pryor.
And I noticed when you marked on the questionnaire.
Microphone, Mr. Pryor, thank you.
It's a hard lesson, I think. And I want to turn you to page 12 of your questionnaire, if you would.
Okay.
Are you there?
Yes.
And in the middle of the page, it has a comment that says, how do you feel about the death penalty? Do you see that?
Mm-hmm.
And then would you mind reading your response?
I'm neither for or against the death penalty.
Okay, is that what your position is?
Yes.
Okay, so when you marked on your questionnaire that you favor the death penalty, with an explanation, you're, and I don't want to put words in, again, there's no right or wrong answer. We know that, right? There's no right or wrong.
Yes.
Are you neutral on the death penalty, or are you really in favor of the death penalty? Could you clarify for me?
I would say I'm neutral. I think it's a circumstantial situation, and
okay.
I can't say that I fully believe in the death penalty, but I also don't not believe in the death penalty.
Okay, so.
And Mr. Pryor, on this point, the court's going to go through a litany on the death penalty part of the questionnaire in a moment. If we could set that aside, and I don't know if you have any questions about bias or hardship before we move on to that topic.
Okay, and I apologize, Judge, I'm jumping the gun. I don't have anything in terms of the bias, Judge.
Okay, thank you. So back to the topic then that Mr. Pryor was just addressing with you. You did complete and fill out a section of your questionnaire called attitudes regarding the death penalty. Do you recall that?
Yes.
And are the answers you listed in there still true and accurate today?
Yes.
All right, I am going to advise you that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And that's why we are delving into these questions at this time. You did make that explanation just now on the record. So you are what you call neutral on that. This part C, you answered again on page 13. You had a list of choices about it and what you thought best represented how you feel. You said, I generally favor the death penalty, but would base a decision to impose it on the facts, law, and instructions in the case. Is that still what you think is your view of the death penalty today?
For these statements, yes.
Okay. If you were required to consider that, do you believe that the death penalty should be, would you be in favor of it in every case where a murder has been committed? Okay, so would you be willing to follow any instructions the court gave you in this case, including if that were an instruction that involved considering the death penalty as a punishment or another punishment?
Yes.
Okay, so would you be able to set aside any views you have on the issue and follow the court's instructions, whether it was to consider that or not, the death penalty?
Yes.
All right, that concludes the court's voir dire questioning of this juror on that topic. Does the state have any questions on that?
No, thank you, Your Honor.
All right, and Ms. Pryor, you can return to your questioning on that as well.
And Judge, I think she answered my questions. Appreciate it. Thank you very much for your time.
Okay, that'll conclude your individual voir dire. You can be excused back to the jury room and should be getting you more information shortly, and then we will have our next juror return here for individual 321.
May I inquire whether we're retrieving juror 321?
Yes.
Judge, on this one, I intend to ask questions of the stating on the record all questions. Commissioner. The questions related to AA's responses on page 9, 7, and 8. And they're of a personal nature. I didn't know if these were of such a personal nature or want to give you more privacy than we're doing now, or if I'm open to ask these questions.
Why don't you?
We're getting too quiet.
Sorry.
All right, welcome back, juror number 321. This is the time for some individual voir dire questioning of this juror. Juror number 321, I'll note we are, these proceedings, you're not being shown that you would have your responses heard on a broadcast of this. There are some personal topics brought up in the questionnaire, and the prosecutor was questioning whether or not you would prefer to discuss those not in public, and I can stop the broadcast and excuse the public for that section. Generally, do you have a copy of your questionnaire there?
Yes, I do.
All right, the things you discussed on pages 7, 8, and 9, I think particularly on page 9, is that something you're comfortable discussing here in an open forum, or would you prefer to talk about that more in a private setting?
Is it page 9, Your Honor?
Yes.
We got prefer to do it privately.
Okay. Let's go ahead and do that then. I'm considering we have 2 left here, maybe going on to 394. If we don't think that'll come up, and then having 321 brought back in to conclude, we could excuse the public and stop the broadcast to conclude this group. Any objection to changing the order like that?
No objection.
No objection.
Okay, juror 321, you wouldn't have got to leave any sooner anyway. We're going to swap you with juror 394 quickly, and then we'll have you right back in here, hopefully in 5 minutes or so. Thank you. Three nine four.
Judge, I am. Excuse me, I am 348. I miss. That's correct. That's correct. That's correct.
All right, juror 394, thank you for returning for individual voir dire. We've had a few topics come up during the group voir dire, including possibly some bias or hardship issues. And I'll just let the state inquire on either of those topics, and then we'll move on to the next topic if we're still going. So who's going to be conducting that for the state?
I will be, Your Honor.
Okay, go ahead, Ms. Blake.
I'm looking at your questionnaire. I think they gave you a copy of it. It's just for your benefit as well. I am on page 14, and it is question 2. It asks, what have you heard or what do you know about the defendant, Chad Daybell? And your response was you overheard some people in the jury summons room mention the case, but no details were given. And before today, you hadn't heard about the defendant. Is that accurate?
Yeah. Really no information is given. Just we're wondering what the
And that's the first time you'd heard of it?
Actually, yes. Yeah.
And then you did indicate that you possibly know a witness, but you're not even sure if it's, sure you're just said the name sounds
Just the
familiar.
name sounds familiar, but there's really nothing there.
So nothing about possibly knowing him that would cause you any concern?
No.
And then I know we've already gone over this with you, so I just want to double check. In the questionnaire on page 20 on the trial length, you had indicated that you have a vacation scheduled from Saturday, June 1st through Sunday, June 16th, and that you believed that would be week number 10. I think we talked a little bit today, and you indicated it's because it would include travel to and from. Is that correct?
Yeah, it's actually June 6th through 10th, but we need a couple days before and after to get out to Arkansas.
To get to and from?
Yeah.
And you were also asked before, so I just want to verify that this is accurate and that I heard you correctly, that if you were selected to sit on the jury, you would be able to do that and make the arrangements, and you felt you could do that and not be distracted by this, by the trip if you were late getting there or if you missed part of it.
Yeah, I mean, if we had to miss it, we would just cancel if we got into it, so that'd be fun.
Do you feel that if you were to run into that, because we're not sure how long the trial will go, but with that being a possibility, if you were to run into that, do you think you would be distracted or potentially hold it against the state or the defendant as you were trying to finish out the trial?
No, I feel like this is important, so.
Thank you for your answers. I have no further questions, Your Honor.
Thank you, Ms. Blake. Mr. Pryor.
I don't need to get into significant detail, but as far as this vacation in Arkansas, again, how long of a vacation is it?
I have 2 weeks off of work, but the actual time we have to be in Arkansas is about 6 days.
And when you say you have to be in Arkansas, is that something that's a family gathering or a personal gathering?
It's a family reunion.
Okay, yeah, a significant event.
Yeah, it's significant, but I've never done anything like this and I feel like that's important as well.
Okay. Is it going to cause a distraction to you to miss this significant family event?
No.
Would you rather not go to it and to do this instead?
No.
You'd rather go to it?
I'd rather go to it, yeah, for sure.
Okay.
But I also know that I know we miss it as well,
right.
So.
For the most part, you're being noble and you're saying, listen, I have to put aside my personal hardship to attend it or to participate in this process, right?
Correct.
But your preference would be to go to Arkansas.
Absolutely.
And has that trip been paid for? Has there been money expended?
Yes, there's a down payment on an Airbnb, but that can be canceled.
And you could be refunded that money?
Yeah, by a certain date.
Okay, is that date passed or is it still?
It's still out there.
Okay. Judge, I have nothing else.
All right, thank you, counsel. The next topic we'll address here with Juror 394 relates to questions you answered as to your attitudes regarding the death penalty. Do you recall that section of the questionnaire?
I do.
And to the best of your recollection, are those true and accurate answers in your questionnaire?
Yes.
All right, so the court will advise you that it may be necessary for you to make a determination in this case in regard to the imposition of the death penalty or some other penalty. So with that in mind, you indicated first that you do support the death penalty. Is that still the way you feel today?
Yes.
And when you were given a choice of selections to describe how you felt about it, you circled on page 13, part C, which I understand are not necessarily your words, but what you said most accurately represents your feelings. You said, quote, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still an accurate representation of how you feel about that topic?
Yes.
Okay, one more question then. Would you always be in favor of the death penalty in every case where a murder has been committed?
No.
Okay, so you would agree.
Well, let me
go ahead.
Try that. I mean, I would be in favor if it was the defendant was guilty of the crime. I was thinking in some case where there's some kind of defense.
Okay, so if you were given instructions as to when and if you would consider it, you would follow those instructions regardless of your views. Okay, and again, to be clear, then you're not saying you would think it's appropriate in every case regardless of instructions, only in cases where you were instructed to consider it?
Can you rephrase that?
So you wouldn't presume that it should always be the penalty in any murder case. You would follow directions or instructions as to this particular case.
Yes.
All right, well, that will conclude the court section of voir dire on that topic. Does the state have any questions about that?
No questions on that topic, Your Honor. Thank you.
Mr. Pryor, any questions for this juror?
Sir, and again, everybody's answer is correct. Everybody's entitled to their view. We can appreciate that, right?
Yes.
Okay. So when initially I heard you say that if there was a murder involved and there isn't a self-defense issue, or there isn't an insanity or something like that, you would be inclined to vote for the death penalty. Would that be fair?
Yes.
So aside from any kind of a defense, a legal defense, if it was a murder and a murder was convicted, and you were given two choices, murder has been proven, and this is not to imply Mr. Daybell's guilt or innocence today. I have to ask these questions. You can appreciate that, right?
Yeah, for sure.
Okay, thank you. What I'm trying to suggest is that if there was a murder and there had been a conviction, and the jury had decided that there was a murder and there was a conviction and there was no defense issue of any kind, and the court gave you an instruction of life or the death penalty, you would be inclined to say, I'm going to vote for the death penalty. Would that be fair?
Yes.
So before you go into the jury box and decide what the fate would it be fair that your initial position and your start position is, listen, putting everything aside with a murder conviction, and I'm required to go back in a separate hearing and consider this, my starting spot is the death penalty unless you tell me otherwise. Provide me some other reason why I should not impose the death penalty. Would that be fair, sir?
My opinion is that it's a just penalty for murder.
Okay.
So based on that, that would be my starting position.
Okay, so you would start with the position that I'm going to impose the death penalty, and that's it. And I saw that in your questionnaire. And again, everybody has the right to a position. There's no wrong answers here. But your starting position is the death penalty is a just penalty. The court's going to give me the option of life in prison or the death penalty. But because I personally believe that the death penalty is a just punishment for someone who commits murder, my starting position is the death penalty, and then I will then consider whether or not I'm going to impose life in prison. That what I said fair?
After rethinking it as you're giving your explanation there, I guess I'm not set on death penalty. If the court is suggesting either,
right?
I'm not going to necessarily push for death penalty. I'm very open to it. But if there's compelling reasons not, then life in prison is an option as well.
Okay, but I guess I got the impression, I don't want to drag this issue on. I got the impression that initially you said, listen, my starting position is going to be the death penalty. But if there are other explanations or there's other evidence that I hear, I would consider changing my position on the death penalty if I were to hear evidence to give me a reason to do that. Would that be fair?
That's correct.
And sir, thank you very much. And please forgive me. I'm trying to just clarify everybody's position. You can appreciate this complicated issue. Yes. And Judge, I'm going to move pause on this issue.
All right, response from the state.
Your Honor, I'm going to ask some questions to rehabilitate.
Go ahead.
Thank you, Your Honor. You recall when we were in the group setting and we talked about a recipe and following the court instructions that will be given to the jury? Do you feel that once you're given court instructions that you would be able to follow those and that you would in fact follow them?
Yes.
And so recognizing right now you haven't been given all the court instructions regarding imposition of your finding of guilt and or the imposition of the death penalty. Once you were given those instructions, would you follow them?
Yes.
And so when we talk about your willingness to impose the death penalty if you felt that was appropriate,
Yes.
would you base that on all of the evidence that's presented in the trial in this matter in both a penalty, or excuse me, in both the guilt and penalty phase?
Yes.
And do you feel that you would keep an open mind and accurately follow the court's instructions in making that decision in determining any penalty if it came to that point? Your Honor, with that information, I'm going to object to the motion to strike.
Very well. The court's considered that. Let me just inquire one last time then of this potential juror. Would you be willing to follow the court's instructions on this issue, regardless of any personal view you have, or do you believe your personal view would somehow prevent you from or impair your ability to follow those instructions?
I'd be able to follow those instructions.
All right, the court has considered the responses given by this juror. The court's going to overrule the motion to strike based on responses to that topic. And juror number 394, you'll return to the jury room here briefly and further instructions.
One other comment.
Yes.
I did check with my employer and there's no hardship by being at that one. So there's a question before.
Okay, well, thank you for checking into that, volunteering that additional information. We'll note that for the note of counsel. And then we'll return with juror number 321. Start off and see where we're at. All right, counsel, with this juror, if there's any other topics we could hit first before we close the broadcast and excuse the public, take those up.
Judge, I would want to delve a little bit more into the hardship.
Okay. Does the state have any questioning on hardship or bias?
Just a couple of questions, but yes, we do.
Okay, juror 321, thank you for returning again. We'll have counsel go into questions relating to potential hardship or bias. After that, we'll talk about the other matters off the record here, the privacy of this juror. Mr. Whitson.
Thank you, Your Honor. Sir, as I recall, during the group selection process, it came out that you would experience some unpaid time if you're selected to be on the jury. Is that correct?
That's correct.
And you, at that point, or at least as of this morning, have not been able to determine how much unpaid time. Is that right?
That's correct. I've since messaged my HR.
And I think you said that you were the sole provider for your family.
Yes, like my wife and I are currently separated, so she's working, but I'm head of my own household, but still contribute with everything that's going on there.
So two households, two incomes, is that how that works?
Correct, yes.
Okay. So then as you sit there today, just on that factor alone, do you feel like with the information that you have as you sit there, that serving on this jury for 10 weeks would in fact be a hardship for you?
It would definitely be somewhat of a hardship. I can let my wife figure out more information from HR to determine how much of a hardship that could be.
So are you leaving it open that if perhaps HR will confirm how much they may pay, and if it was enough that you could still potentially serve without it being a hardship? Is that what you're saying?
Yes, that's true.
And I guess to clarify, as I've mentioned to other jurors, juror 321, we need to make a decision essentially now on this issue. We don't necessarily have the luxury of finding out, and I understand it would be a difficult task, but if the answer comes back that it's more of a financial hardship than less based on your HR policy, if that were to occur, how would that impact your ability to pay attention and be engaged in this trial and not be concerned about that the whole time?
If I'm a part of this trial, it's not gonna affect it at all. 100%.
Okay, well, thank you so much for that response. Apologies for the interruptions, Mr. Woodson. If you have further questions, go on.
Thank you, Your Honor. And then I did just one more thing that had been with you this morning. In your questionnaire, the one thing you did note about hardship was you have several midweek trips planned to go to Oregon to watch your son play ball, right? Do you feel like with the question that occurred in the explanation, are you satisfied now that that won't be a hardship, or are you still concerned that potentially missing his games or some of them will be a hardship?
Like I was explaining before, there's always going to be other times to do it. So I wouldn't consider it hard. I guess it's kind of relevant to like my situation. You know, it'd be a hardship because I'd love to see my son play, but in terms of being a real hardship on like my life, no, I can't call it a hardship.
Okay. Thank you for that. No, I don't have any more questions on these topics right now.
All right, Mr. Pryor.
And sir, I'm going to start with the baseball. How many children do you have?
I have 3.
How long have you been watching your son play baseball?
Since I coached him when he was 6 or 7.
And at this point, I'm somewhat familiar with college sports. And it's a unique opportunity for a young man to play baseball at the college level, isn't it?
It is.
It's not that every member of a high school baseball team gets to play at a college level. It's a unique opportunity.
Yes.
We don't know whether your son's going to play next year for sure. We think he is, right?
Yes.
And this is an opportunity. When I talk about hardship with you, I don't want to talk about just that your life's going to end, or it's going to be it's going to be a terrible struggle, and that you're not going to be able to overcome this. That's not necessarily the entire definition of hardship in my mind. It's also emotional. It's also understanding that you raised a child from a very young age and you are his coach. And that this is a very unique opportunity. And some of these folks are talking about family reunions and their mother's birthdays and events where people have to spend time and important events in people's lives. And I can see obviously that this is having an impact on you because you truly want to watch your son play baseball. Is that fair?
That's fair.
And you want to be there, and in terms of it may not be the end of your life. It may not cause you financial ruin, but you raised this child and you coached this child. And you probably taught this child how to hit a baseball. Is that fair?
Yes.
I don't know what position he plays. I don't know all the facts. But this is an important event. Do you agree with me? To watch your son and go out there and watch him play?
Yes, it's important.
And it's something that you really want to do.
As much as I can. Obviously, I'd have to travel there too.
But you've already committed that you're going to. This isn't just a necessary, well, if I can, I'll get over there. This is a situation where when you came in to sign up for jury duty, you said, and you're nodding your head, I have committed myself. I really want to see my son play baseball. And this is going to be an emotional hardship on me if I'm not permitted to watch my son play baseball. It may not ruin me financially. It may not cause me, to lose my life or some other tremendous situation. But if this is a significant event in my life, my son's life, would you agree with that?
Yes.
Or in the interest of time, I would just check that this topic has been covered. quite extensively at this point. We've got consistent answers from the juror already.
Well, Judge, I have a right to revisit this and talk about this hardship here. This gentleman, I think I should be allowed to elaborate. This is a hardship.
Well, I understand that, and I know the juror understands the situation and has thought about it. So, Mr. Pryor, let's just get to the point of whether or not this is going to rise to the level of a hardship where you would be unable to serve.
And the point is you would be able to serve, but in your mind, this is going to be an emotional hardship to have to serve, right?
Can you break down that question for me, please?
This is going to be an emotional hardship for you to serve.
I'm not sure how to answer that because I deal with stuff all the time and I get through it. So to me, hardship sounds, I understand what you're saying. I'm allowed to answer like this. I don't understand. I know what a hardship is. Yes, it's going to affect me emotionally because I want to be there, but it's not like a hardship.
Okay. Thank you for your honesty, sir.
All right, at this point then, there are some additional topics the court's going to address. The jurors requested privacy, which the court will grant. So we're going to stop the live stream of the proceedings, and I'm going to have the public excused from the courtroom. Further inquiry on voir dire with this particular juror. So if everybody would allow for that for a moment, we'll go ahead and take just a quick break to clear the courtroom and stop the proceeding, and then we'll continue right on with this juror. All right, we are back on the record on this case. Just so I match up and make sure I'm clear with the jurors who are still here, please raise your red cards. All right, thank you. All right, we've concluded voir dire of this particular group of jurors. These are jurors that would, in the court's mind, be passing on to peremptory strike section of the trial. Let me inquire now, having confirmed who's returned here and on to the voir dire. Does the state pass this group for cause?
Yes, Your Honor.
Does the defense pass this group for cause?
Yes, Your Honor.
All right, thank you. Ladies and gentlemen of the jury here, then, you have been passed for cause. We'll continue to question additional small groups until we reach the necessary number of jurors we need to exercise peremptory challenges. You'll be instructed to contact the jury commissioner, Randy Rutland, and he will give you further instructions on when you are going to be required to return. While you're waiting for that, and in that interim, if anything comes up you need to report to the court, you can do that. And in addition, please take every precaution to follow the admonition given before to not now go and research the case, look into the case, try to find out about the case. Don't talk about the facts or details of this case with anyone other than, of course, you can talk to friends, family, employers, etc., about the possibility of your service in this case as jurors and make those arrangements. But otherwise, the court will be requiring you to submit an affirmation under oath when you return that you have not gone and done any kind of additional investigation into the case, which could bias or taint you and cause us to lose the work we've done today. So we very much appreciate your service up to this point. You'll receive further instructions on when you will return for that next stage of the proceedings. And with that in mind, that will conclude our voir dire of this particular group. Before they're excused to report back at another time, anything further from the state?
No, Your Honor, thank you.
From the defense?
No, Your Honor. Thank you.
Okay, thank you. All please rise for the jury.
If you come back this way, you want.
All right, a little later than noon, but we're going to take a lunch break at this time. We'll go off the record. We've got another group lined up. I'd like to very quickly meet with council just to discuss scheduling on our proposals to get restarted. And we'll just do that here in the back hall briefly.
The state had previously asked to be heard regarding 2 objections that came up during the last panel. The state wanted to be heard prior to bringing in the next group, anticipating that we may hear the same things. The 2 issues are that Mr. Pryor, counsel for defense, mentioned multiple times the 4 prosecutors. I do think that that is objectionable. I think it's outside the scope of the purpose of voir dire. I think it's also pandering to the jury essentially and serves no purpose as far as the voir dire process itself goes. So we would ask that he be prohibited from repeatedly referring to the 4 prosecutors and then himself as a lone defense counsel. In addition, the other objection dealt with, I think it only happened one time that I can think of, but Mr. Pryor made the comment that he believed his client was not guilty. Again, I think that's inappropriate to comment on that, to comment on what his personal beliefs are with regard to that, and also would be outside of the scope of voir dire and serve no purpose for the voir dire proceedings.
Okay, thank you, Ms. Blake. 2 different motions there. Mr. Pryor, if you'd like to respond first to the state's objection and you referring to the 4 prosecutors.
Judge, if you have some suggested language for me in terms of how I'm supposed to refer to them, I'll be glad to take that language, but I don't see the prejudice in referring to 4 prosecutors on the other side of the table. If the court feels that's prejudicial, then you know, if you want to tell me exactly how I'm supposed to refer to those folks, I'll be glad to do that, but I see that's a little, I feel like the prosecutor's picking on an issue and they feel there's prejudice there, then the judge instruct me how you want me to address those folks. And as far as the other issue is concerned, Judge, I'll temper my response and ensure that I advise them in a less than definitive manner in terms of the other issue.
All right, well, in terms of the first motion, I'm not going to prohibit some mention or reference to 4 prosecutors. That's who's at the table. The jurors are going to see that anyway. If it is being referred to unnecessarily or in a way that's irrelevant to the procedures or selecting jurors in the voir dire process, then the court will consider that under advisement, but I'm not going to prohibit a reference to what they're already seeing. It was said, it was repeatedly made, perhaps in a way to try to garner sympathy. It looks like it's rising to that level. I'll reconsider it. You may either re-raise the objection, Ms. Blake, or I may speak up and advise counsel that we would consider that to refrain from that reference, but in general terms, it's not going to be prohibited. In terms of the statement that was probably what would be framed as vouching, then Mr. Pryor would be correct that that's an improper kind of statement to vouch for your client personally or make a unqualified statement such as that. You've indicated you'll refrain from that, so the state would grant the objection on that and instruct that there not be further references where you are vouching for the innocence of your client. So that'll be the court's ruling on both motions. Ms. Blake, do you have any questions on that court ruling?
No, Your Honor, thank you.
Thank you. Any questions from the defense?
No, judges, it's permissible for me not to rise, but if the court preferred that I rise.
It's fine if you don't, Mr. Pryor. That probably helps with the audio, actually, if you just go into the microphone remaining seated, so I have no objection to you.
I want to make sure I'm not being disrespectful.
All right, no taken. One more thing we'll put on the record before we get started with the next group. One of the jurors mistakenly noted a number that's not their number on the questionnaire, and we wanted to advise you of that. So on the seating chart, we've got juror 841. And actually let's see, so 465 is the questionnaire, that's the number on the questionnaire, is that correct? You've got a questionnaire with the juror number 465. That is actually going to be red card juror number 841. So when they're in here, they should have a red card 841 that corresponds to the questionnaire with 465.
That may I make a point of inquiry, was the 465 on the file, the questionnaire, is that the number on the questionnaire, or are they actually an 841?
That is the number on the questionnaire. So the questionnaire reads 465, however, that is actually juror 841. You're welcome. All right, counsel, took a while on that last group. To the extent we can make it any more efficient or move more quickly, I do intend to get through this group today. They've been waiting since this afternoon. So we will proceed first with the court's board dial, then on to counsel. If everyone's ready, then we'll go ahead and have this next group of 16 brought in for board dial. So instruct the marshals to have the jurors brought in, please. Sure. Thank you.
All right, please.
Campbell, here you are. All right, thank you. Please be seated. All right, ladies and gentlemen, thank you for returning. Apologies for the delay this afternoon. I'm going to first, if we would do this, just to give counsel in the court an opportunity to confirm your seating arrangement that it corresponds with our chart. If you don't mind, if each of you would please just hold your red card up for a moment and give us a moment to review our charts, then we'll move on from there. All right, thank you. First, counsel, I will remind you, please only refer to jurors by their red card numbers, not by name. As I mentioned previously, we are here to select a total of 12 jurors plus 6 alternates for trial. So we're going to have a total number of 50 prospective jurors to get to peremptory challenges. The court's going to conduct its own voir dire, and I'll request the counsel not repeat questions the court's already asked. We are now broadcasting the proceedings. We are on the record on KCR 2221-1623, State of Idaho versus Chad Daybell. I'll note Mr. Daybell is present, as well as his attorney, Mr. Pryor. The state's here represented by Mr. Wood, Ms. Blake, Ms. Beatty, and Mr. Wixom. First question I'll ask of counsel, beginning with the state, is there any objection to the manner in which the jury panel has been recalled and seated today?
No, Your Honor, thank you.
Any objection from the defense?
No, Your Honor, thank you.
Thank you. Ladies and gentlemen, thank you for returning this afternoon. You've been recalled as prospective jurors in this case. I'm Stephen W. Boyce, the District Judge of Fremont County, Idaho, and I'm in charge of the courtroom in this trial. My court clerk to the right is Shannon Holstein, who is keeping minutes of this proceeding and will also be administering oaths to you as jurors. We've got our courtroom marshals here, Mr. Holmes, Beige, and Ravello, who will work with keeping order in the courtroom, as well as helping you as jurors move about. The court reporter, Mary Fox, is seated down to my left, and she's keeping a stenographic record of everything said in these proceedings. And my staff attorney, Courtney Stallings, is seated to the far right against the wall, and she assists me with legal research and administrative issues that come up throughout the day. Each one of you is qualified to serve as a juror of this court, and you filled out a questionnaire that we have now reviewed. We are going to go through this process in an effort to select 18 jurors, which will comprise 12 trial jurors and 6 alternates. The clerk at this time now, using the red card number, will please make a roll call of the jurors.
Please answer audibly when I list your number. Juror 440. Here. Juror 465.
Here.
Juror 496.
Here.
Juror 505. Here. Juror 526.
Here.
Juror 536. Here. Juror 539. Here. Juror 544.
Here.
Juror 591.
Here.
Juror 617.
Here.
Juror 631.
Here.
Juror 641.
Here.
Juror 647.
Here.
Juror 653.
Here.
Juror 686.
Here.
Juror 740.
Here.
All right, thank you. For jurors that did not appear, the court will indicate an admonishment that they may be subject to fines or jail time under Idaho Code 7610 and Idaho Code 22085. So for those of you who did appear today in this group of 16, thank you for returning. To assist you in understanding and participating in this jury selection process, again, I'll reintroduce you to the parties and the lawyers and summarize briefly what the case is about. When I introduce an individual, please stand and briefly face the jury panel, then take your seat. The case has been brought by the state of Idaho, sometimes referred to as the prosecution. State's represented at this trial by Fremont County Prosecutor Lindsay Blake, Madison County Prosecutor Rob Wood, Specially Appointed Prosecutor Edith Beatty, and Deputy Prosecutor Rocky Wixom. The defendant is Chad Daybell, and he's represented by his attorney, John Pryor. This case is a criminal matter, which means the defendant has been charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges contained in the amended indictment when you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho has alleged that he committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. Count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember this is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I'll later give you to those facts. In this way, you'll decide the case. In applying the court's instructions to the controlling law, you must follow those instructions regardless of your opinion of what the law is, what the law should be, or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including by use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Don't form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I am going to request that our clerk administer an oath to the entire jury panel. Ladies and gentlemen, if you please stand and raise your right hands, I'll have the clerk administer this oath.
You solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial. So help you God.
All right, thank you. Please be seated. Our record will reflect that all jurors were placed under oath. The clerk has now impaneled 16 prospective jurors for questioning in small group today. Will the state stipulate the jurors have been properly called and impaneled?
Yes, Your Honor.
Will the defense stipulate?
Yes, Your Honor.
Thank you. These jurors were sent home last week after completing the questionnaire and then provided an affirmation that they have not gone and researched or looked into the case between now and then, nor discussed it with anyone. Let me inquire next of our bailiffs. Do we know if a juror affirmation has been completed by this group?
Yes, Your Honor, and confirm.
Okay. Thank you for following the court's admonishment of not looking into the case during that intervening time period. In this part of the jury selection, then you're going to be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to origins of the common law, and in French it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand the questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your red card number. When you're called upon to speak, identify yourself with that number. And since we're making a stenographic recording of the proceedings, please make audible verbal responses and try to avoid speaking at the same time as anyone else talking to you. That way, our court reporter is able to keep a clear record. If any answer to a question would be embarrassing or uncomfortable for you to answer publicly, and I will note this proceeding is being live streamed, then please let me know, and we're able to discuss those issues with you in a more private setting outside of the public purview. Similarly, if your answer to any question may prejudice other prospective jurors, please let me know, and we'll also discuss that issue outside of the presence of your fellow jurors. Additionally, many of you may have knowledge of this case from pretrial media coverage and publicity. Please do not discuss any specific facts or details of this case in front of the other jurors in this pool. We can discuss those matters with you individually as needed. I'll now read to you a special instruction in this case, which is as follows. The defendant, Chad Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the court's special instruction. At this time, I would instruct the attorneys for both parties to avoid repeating any questions already asked. The attorneys do have the right, however, to direct follow-up questions to a juror regarding responses they've made to previous questions. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, which means they can ask a juror to be excused for some specific reason. In addition, each side has a certain number of what are called peremptory challenges, meaning they can ask a juror to be excused without giving a reason for that dismissal. If you are excused by either side, please do not feel offended or feel that your honesty or integrity has been questioned, because it has not. At this time, then, the court will begin with its portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own inquiries. When when other jurors are being asked certain questions, please pay attention because you may later be called upon to answer those same questions. The first question I'll ask then relates to your jury questionnaires, which you filled out. Let me just ask the group here, are the answers given by each of you on the jury information form still true and accurate? If you would say yes, please raise your red card. Okay, everyone responded affirmatively. To the best of your knowledge, are those answers in your questionnaires also still accurate and true at this time? If yes, raise your card. Everyone said yes. Next question the court will get to is the time commitment that may be required if you are serving on this case. As you were told last week, it would be for a period of approximately 8 to 10 weeks. Would that time of service create a serious hardship upon you or your family or your business or profession or occupation so as to prevent you from rendering service as a fair and impartial juror in this case? If you think that applies to you, please raise your red card. Okay, we've got 2 jurors, 3 jurors, 641, 544, and 496. Let me take those up individually with you. So starting with juror number 496. You mentioned in your questionnaire you are out of town for work both in April and May. Could you explain a little further about those circumstances?
Yes, I have a training going on to essentially it's related to work, though I'm traveling to Arizona.
All right, would you be able to have anyone else cover, or would you be able to reschedule those commitments?
Could be rescheduled, but they're committed to prior to this case. I've committed to them prior.
What would be the impact on you if you were required to serve as a juror in this case and missed? And to be clear, these are 2 separate trips, both planned. Is that correct? If you miss both of them, where would that leave you?
I would need a reschedule, which would be I take this trips reschedule.
All right, I think it would be appropriate at this point for me to allow counsel to step in and ask additional questions as it relates to the hardship expressed, beginning with the state.
Your Honor, the state also had noted those planned trips and had intended to inquire of those today. Given that additional information and the expenses associated with that, the state would make a motion to excuse this juror for cause for hardship.
Judge, I'll step in.
All right, thank you, Mr. Pryor. Ms. Blake, the court's considered the information provided today, including what you filled out in the questionnaire and your responses. Juror 496, the court will find that you may be excused for cause for purposes of the hardship you would endure if you were required to serve here. So you can be excused. Thank you for reporting. That concludes your jury service. Please drop off your questionnaire with the bailiff as you exit. And then in a moment, we'll take up our next juror that had a concern. All right, let's next talk to juror number 544. We didn't have a whole lot of detail in your questionnaire. It said you had a wedding in Atlanta. And can you explain to the court more about when that would be?
That would be April 18th to the 20th.
And can you indicate whose wedding that would be?
It is my nephew.
Have you made any prearranged purchases for that trip at this point?
Yes, I have. I actually have purchased the airline ticket before I had gotten the summons.
They're willing to move the wedding out a couple of months for you, do you think?
Kind of hard to do.
All right, I'm gonna ask the state at this point if they have any questions about the purported hardship here for this juror.
Your Honor, the state also had a note on this one, and we did note there was a wedding in Atlanta. We just were unclear on the dates of that. With that additional information regarding the dates and the purchased airfare, the state would make a motion to excuse this juror for a cause for a hardship.
All right, response from the defense. Judge. All right, well, juror 544, as I mentioned last year, he will be excused based on your request to not serve at this time for a hardship that would occur if you remain. Thank you for coming in, completing the questionnaires, returning today, and your jury service is completed and you can be excused. Please drop your questionnaire off to the marshal on your way.
Thank you.
We'll next talk to juror number 641. We've got a vacation in May to visit some elderly grandparents, it looks like. Juror 641, can you provide a little more detail about that?
My vacation is scheduled for May 18th. I'll be there until the end of the month. I've already scheduled time off work, which will be very hard to move. And the expense of that would total out to about $272 for the plane ticket, which I purchased in advance, and then a train ticket to visit a family friend who was recently diagnosed.
And that's incorporated in the same trip?
Yes, yeah.
All right, as to juror 641, does the state have any additional questions?
Your Honor, we also had a note here to follow up regarding that vacation in May. Again, just not a lot of information. In addition, I'd note there was an indication that there was some concern about interruption of school and work. I think given all of that, the state would make a motion to excuse juror 641 for cause for a hardship.
All right, response from the defense? Okay, juror 641, you are excused based on your request of a hardship. The court determines that you won't be required to serve for this case. Thank you for reporting, for completing your questionnaire and returning today. Please drop that questionnaire off with the bailiff as you exit. For those jurors remaining, did anyone else have a concern about the length this trial may take? All right, and understandably, it's a difficult circumstance for all of us, anyone, and we do have one more now, 539. All right, your number 539, give me a moment. All right, can you please explain a little more about your family situation that you believe indicates a hardship here?
I have 2 vacations planned that are each 1 week long. One is May, I think 18th to 24th, 25th, and I'm also the primary caretaker for a 2-year-old.
The May, well, both, and when is the second vacation plan?
June 1st through 7th.
All right, are either or both of those already pre-purchased or just planned?
The first one is already purchased.
And can you provide a little more detail about your commitment to childcare with the 2-year-old?
Yeah, I'm a stay-at-home mom, so I take care of him all day long. So I'd have to find alternate childcare for him during the hours that take place. And that's pretty hard to secure childcare around here, like this minute. There's lots of waiting lists.
In this case, there's a potential of being sequestered for some time, meaning you would be away from the 2-year-old for perhaps a week or even longer. What would occur if you were required to be sequestered?
That would, I mean, that'd be really hard for him, and I'm not sure what I would do with that. My husband works that. So he has weird hours.
And do you believe that would become a significant distraction for you if you were concerned about that while being sequestered?
Yeah, he has trouble around, so.
All right, let me ask the state if there's any follow-up on these requests for excuse for hardship.
Similarly, Your Honor, the state had already made notes of those 2 planned trips. Again, we didn't have details if they had been already purchased or not. And we did have the note regarding her young child and that she was a stay-at-home mom to follow up on. Given that additional information provided by her today, the state would make a motion to excuse juror number 539 for cause for hardship.
All right, Mr. Pryor.
Judge, I have stipulation for being
Okay, juror 539, court's considered the stipulation of the parties as well as your request, which you did request for in your questionnaire. Based on those reasons already stated on the record, you may be excused. Thank you for coming in and serving and filling out your questionnaire. You can drop the copy off with the bailiff on your way out. All right, unless there's any other concerns from the jury pool, we'll move on to another subject at this time. And again, thank you for your willingness to commit that amount of time in serving on this case if you're called. The next issue we're going to discuss is pretrial publicity or your knowledge of this case. The court would note there has been extensive news coverage of the case and other in a lot of different, published in a lot of different forums. The instruction I read previously and what I want is to not go into any discussion of any facts or details you know about the case at this stage, because we'll talk to you individually about that so other jurors don't hear what you already know. But with that in mind, if you do have some prior knowledge of this case, and by knowledge I mean not just heard of the case, but know about it in any detail, would you please raise your red card at this time? Yes.
You say in detail, beyond what's been on TV, like the news and stuff.
Well, we'll probably talk to you about that individually. I know it's a generic term that might mean different things to different people. Some people have followed this a lot. Some people have just heard it in passing. Some haven't heard anything about it at all. So have you actively followed it at all? Okay, but you have heard about the case somewhat. Okay, we will ask you some further questions about that individually. Anyone else who has any knowledge of the case or? Okay, 505 and 740, 591. Okay, for you to listed your or raise your card up there on that, we are going to ask you some specific questions individually. The next topic I'll move on to relates to the subject matter of this case. Would the subject matter of this case, which involves charges filed by the state of murder, conspiracy, and insurance fraud, would that subject matter make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? All right, no jurors answered yes to that. I'll next ask some questions that may seem obvious, and we've reviewed your questionnaires, but they're required under Idaho law for me to make sure there's no improper or appearance of improper relationship or connection to this case. So Are any of you related by blood or marriage to the defendant, or do you know him from any kind of business or social relationship? No affirmative answers. Do any of you have any kind of a relationship such as guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger between you and any of the attorneys in this case? Are any of you, and I'll know no affirmative response there, are any of you a party in any civil action against the defendant, Mr. Daybell? No one answered affirmatively. Have any of you ever brought a criminal complaint against the defendant or been accused of some crime by any of the prosecutors that are present here, including Ms. Blake, Mr. Wood, Ms. Beatty, or Mr. Wixom? No one answered affirmatively to that. Do any of you here have any kind of an attorney-client relationship or business dealing with Mr. Pryor or his law firm? No one answered affirmatively to that. Are any of you related by blood or marriage to any of the lawyers, or do any of you know any of the lawyers from any professional, business, or social relationship? All right, no one indicates they know any of the lawyers. This next question, you could just answer yes or no. If the answer is yes, we'll talk to you about this individually, but have any of you formed or expressed an unqualified opinion that the defendant is guilty or is not guilty of the offenses in this case? All right, we've got one card, number 591. We responded to that. We'll ask you more about what opinion you may have individually. Anyone else already formed some type of an opinion in reference to the defendant's guilt or innocence? Do any of you have any particular bias or prejudice either for or against Mr. Daybell as you sit here? Are there any of you who would be unwilling to follow my instructions to you as the jury as to the law that you must apply in determining this case? All right, no one said yes. Do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict? Okay, no one answered affirmatively to that. And then, are there any of you that, if selected as a juror in this case, would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the laws instructed by the court? No one answered affirmatively to that. A final kind of catch-all question here. Do any of you have any other reason why you cannot give this case your undivided attention and render a fair and impartial verdict? All right, we have one juror raised their card, juror 465. Is that something you wish to discuss here? Do you think that's more appropriate individually?
Here is fine.
Okay, what would be a reason you believe you couldn't give the case your undivided attention?
I work nights and usually wake up around 12. Yeah.
And I'll just tell you that with our schedule, even though it doesn't look like much in my experience, this will be, it would be very difficult, if not impossible, for somebody to maintain a night shift and do trial in the day. I don't see that as feasible. So is that something you were considering when it got to the hardship question?
Yes.
Okay, so you were under the thought maybe you could work in the evenings, do this in the day?
It's more of if when's the usual start time? Or
8:30.
that'd be like waking up at 3 at night.
And I guess the question is, would you be able to not do your job while this case is going for 10 weeks? Because I kind of think that is what it's going to take for you to have the mental capacity to do this.
I'd be falling asleep during.
Okay. Let's go back to that question then on employment for juror number. I'm sorry, could you hold your card up again? 465. I'm going to let the state inquire at this point if you read about employment and a potential hardship here.
Your Honor, given the information provided by juror 465, the state would make a motion to excuse him for a cause based on a hardship.
Response from the defense, Mr. All right, and just to be clear, you are employed at that job full-time and that's your sole source of income?
Yes, sir.
Okay, and if you were required to essentially quit your job for the 10-week time period, would that result in a financial hardship for you?
No, sir. It's capability of saying what you're not in trial.
Okay, and I guess there's been a stipulation, I just want to be clear on that. I guess what I'm saying is likely you wouldn't be able to work during that time frame. So if you weren't working, in other words, if you had to quit that job to do this trial, where would that leave you?
Pretty bad.
Okay. All right. Well, I've considered the responses also, the non-opposition motion from both parties. And I would find that with that in mind, juror 465, I think it would be a hardship for you to be required to serve in this case given the time frame in your employment situation. So for that reason, juror 465 will be excused based on a hardship. Thank you for serving and filling out your questionnaire. You can drop that questionnaire off at the bailiff as you exit. All right, I'm almost concluded with my section of voir dire, but I'll go back and just re-ask that same question since we went through that with that juror, having listened to that. Do any other jurors here have a concern that they would not be able to give this case their undivided attention and render a fair and impartial verdict? All right, that will conclude the court section of voir dire for this panel. I'll turn this over now for the state. If you'd like to conduct your voir dire inquiry, who will be doing that? I will. All right, Mr. Wood.
Ladies and gentlemen, again, my name is Rob Wood. I represent Madison County, Idaho. Thank you for being here. And just as a reminder, when the judge said, if I ask you a question and you feel like you'd rather answer it private, just let us know. We want you to be comfortable. And there's no wrong answers here. How you feel is how you feel. And we need to know that so that this defendant and so that the state can have a fair trial. And so, juror 505, when I say brutal honesty, what does that mean to you?
Just being very direct.
Telling it like it is. Will you all commit that you'll be brutally honest in your responses with us? You'll tell us how you actually feel. Juror 647, do I see some hesitation? Yeah, you kind of tilted your head and looked at me like maybe not.
Oh, no, I have 4 kids.
Okay, so you can be
Tell us
honest.
kids straight.
I shouldn't say honest, you can be forthright with this, right? Okay. There were a couple of jurors that did list a hardship. This mic is feeding back. But you didn't raise your hands when we were talking about it earlier. So if it's all right, I'm just gonna ask a couple of you about that. Juror 686. And I apologize, you're not one of the ones I was talking about. Juror 631. You're a medical technician, correct? And on your questionnaire, it said it may be a hardship for you that equipment at a specific hospital may not be maintained. Is that accurate?
Possibly. I was the only technician trained on this specific equipment that's hospital. But I've already spoken with them and they're calling the manufacturer.
Okay, so you've taken care of that so that if you get there, someone else can.
Yep.
Perfect, thank you. Juror 653. Thank you. You had mentioned on your questionnaire it could be a financial hardship for you to take time to be on this jury. Is that still accurate? Okay, so you've been able to take care of that. Perfect, thank you. Just want to talk to you really quick. As the court mentioned, we're going to get into what you've seen on the media individually later. But just really quick, does anybody here believe everything they read online? Nobody believes everything they read online. So we're all aware that sometimes there's information out there that's not true. Do you all agree with that? And what about news on the TV? Does anybody here believe everything they hear on the news? And to be clear, I'm not saying that in any way to diminish the news, just sometimes facts change, right? And we might think one thing one day and then we learn another fact another day. Has everybody seen that in their lives? Okay. And so this is so important. Can you all commit to this court, to the state, to this defendant, that what you have seen, that you'll put that aside and you'll only rely on what you learn in this court? The court talked briefly about the nature of this case and asked if the nature of this case would preclude anyone from feeling like they could serve on this jury. And just to get into to follow up on that, this is a case that involves the deaths of two minor children and a mother. And there's going to be some evidence, some autopsy photos that is absolutely difficult to look at. Is there anybody here who feels like looking at that type of material will render them unable to render an impartial verdict, that it would sway them one way or another? 591, thank you for being honest. Tell me how you feel about that.
I may get emotional if I do, but I'm a retired school teacher and I've spent my whole life trying to keep kids safe. And that, and really everybody's safe, but beyond that, I have a very vivid imagination, or I'm a very visual person. It's really more correct. So no matter what you say, I picture it already. So I'm already living in movies, so because of that, I don't watch anything violent. I don't watch action movies or anything because they stay with me and create a lot of anxiety. So, and people say, well, stop picturing it. Well, it's there. It just happens, and it has my whole life. It does cause me. I've already lost about a week of sleep over this.
Well, and I noticed you mentioned that in your questionnaire, you said the vivid kind of reliving of these things. Is that a fair characterization? Yes. I don't want to put words in your mouth.
I have dreams that loop, and I had counseling and things like that, and I can get a hold of them, but when it comes to violence, it's just, that's like I don't want to say it's a character flaw because it doesn't feel like a flaw to me. It feels like it's a warning. And I'm also very intuitive, which I'm not saying that I would be able to intuit everything, but I don't know, it's like I have a different sense about me and it's causes a lot of anxiety.
Okay, and I noticed you mentioned that as well in your questionnaire. So where this comes down, does this, are you concerned that this vivid looping of information, of graphic information and anxiety, do you feel like that would make it difficult for you to render an impartial verdict?
I do.
Okay, thank you so much for your honesty. I appreciate that. Judge, at this time, I would ask that Juror 591 be excused for cause.
Response from the defense.
Judge, can I just?
Yes, you may.
Ma'am, I'm John Pryor. I'm representing Mr. Daybell today, and I want to make it clear I am required to ask you questions, and I don't want you to believe that any of these questions suggest that Mr. Daybell is guilty or anything like that. But if they're just questions we have to ask, would that be okay with you? There are going to be very graphic pictures here, and they're going to be disturbing to everybody. And they're going to be very, very emotional. And one of the concerns we have is that when you look at those pictures, will you immediately assign those pictures to Mr. Daybell and assume that he's guilty because of the nature and the graphic nature of those pictures? Or will you be able to look at those pictures and say, it's evidence?
I can maybe keep it to evidence, but what my concern is how I'm going to continue to function during.
And this is going to cause you some emotional distress.
Yes.
With your association with children, having someone who's worked very hard to protect children your entire life, I would imagine. If you see those, it would be very difficult. Even if the court instructed you that, you were supposed to look at these and not judge them or be inflamed or overwhelmed by those, you're supposed to look at them for what they are and continue to look at all the evidence. That's going to be a difficult task for you. Do you say that's the case? Judge, I'll stipulate.
All right. Juror 591, just, I guess, a final bit of inquiry from me. I guess what I'm hearing is you think you may get upset to the point where you're not able to pull things back together and think clearly after that? Okay. And
I wish it wasn't true, but I mean, it is, so.
Sure. Different people react different ways. That's why we go through this process. Thank you for your candor to the court in these questionings. I do agree that for this juror with this particular trial, she should be excused based on that nature of the evidence that will be presented here. And so for juror 591, the court is going to grant the motion to strike for cause. And we appreciate your taking the time to fill out your questionnaire and return today. Your jury service is concluded with the thanks of the court. You can drop your questionnaire with the bailiff.
Thank you, I appreciate it.
You're welcome. You can continue, Mr. Wood.
Thank you, Your Honor. Ladies and gentlemen, I wanted to speak to you just really briefly about the law. The court asked earlier if everyone would be willing to follow the instructions as given by this court. I believe everybody answered affirmatively, correct? Anybody here have a law or a rule they don't like? People are either grinning or holding up there. We all probably have something, some rule or law we don't like. But it's important for both sides to receive a fair trial. that we can all agree on what the law is in this courtroom, and that it is what the court gives to us. Is there anybody who feels like there may be some type of situation where they would just go with their gut rather than what the court gives? Sorry. Juror 505. Well, and I ask because you mentioned briefly something about that in your questionnaire. And I'm not calling you out for it, and there's no wrong answer. You can answer that however you want.
Comes from my background as a mom, if there has to be something wrong, I wouldn't do that.
Sure.
I don't know what the instruction.
Okay.
That's why.
Okay, that clarifies that. So, that you can commit to what the judge gives you as the law. You will follow that law for this case.
Yes.
Okay, thank you. Thank you for that clarification. Your Honor, I'm going to turn my remaining time over to Ms. Blake.
All right.
Thank you, ladies and gentlemen. Thanks for being here this afternoon. I know it's getting later afternoon and you were all here last week, so we appreciate you hanging in there with us for this process. As you've already heard a couple times, we all take this very serious. We want to ensure that we select a jury that can be fair and impartial to both the state and the defendant, Chad Daybell. So that's why we go through this process. So I don't know about all of you, but I have a 2-year-old that when he wakes up in the morning, if I ask him, what do you want for breakfast? It's usually cheesy eggs. And there's a very specific recipe that I'm supposed to use to make his cheesy eggs. It's eggs, milk, cheese, salt and pepper, and usually, some extra cheese in there. He doesn't like me to vary that recipe. So I saw some people kind of smile and nod along. Do any of you have that experience either with children or someone else that you work with, and whether it's a recipe they like you to make a certain way or something they like done a certain way? Can everyone relate to that? And Juror 686, I see you shaking your head. What's your experience with that?
I've had several siblings and dated several people that had children, and it's very much the same. The kid wants, peanut butter and jelly a certain way, you make it that way without, any variation.
And in your experience, were you usually willing to go along with how they wanted it made?
Most of the time, yeah.
And were there times that you thought, man, if they just add this, or if they just do it this way, it'd probably be a lot better?
Yeah.
And Juror 740, did you shake your head yes as well? And what's your experience with that?
Just at work and processes, people are set in their ways.
And are there times when you go along with what their ways are if it's their call to make?
Yes.
And so I know I use kids as the example, but as you're here today, and Mr. Wood touched on it a little bit already, but the judge is going to give you some jury instructions. And he's going to give you verdict forms that outline what the elements are of each count. And sometimes it's easy to say, well, it would make more sense if it was this, or why don't they add this, or why don't they take this away? But could all of you commit that this is the recipe, this is the instruction that you would have to follow? Does anyone have concerns with that? Does anyone have concerns that if you thought some part of it didn't make sense, that you'd have a hard time following that? I don't see anyone shaking their head yes on that. Does anyone here have concerns? You're going to hear from a lot of witnesses in this case. Does anyone have concerns if you hear from someone that holds different religious views than you do, whether or not you would be able to give their testimony the appropriate weight and credibility you think it was due? Does that cause anyone concerns? And so I'm someone that, while it would be smart and easy to just check the weather app in the morning, I don't. And so I'm the person that leaves home without an umbrella and then there's a rainstorm, or I dress in shorts and there's a snowstorm. So I don't know, have any of you if you had gone to work or if you showed up today and as you got here, the sky was starting to turn a little overcast, it's turning a little gray, and you came in here and all the windows get shut and the blinds are shut while you're in here. And you go outside and you notice water on your car, you notice water all over the pavement, water on the grass, water everywhere. Would you be able to determine what had happened? And juror 653, I see you nodding and saying, yeah. And what would you determine had happened? And juror 647, would you be able to determine?
Technically, I would assume it would be, but I didn't know.
But if everything was wet all around.
Yes.
And so even though you didn't see the rain, you didn't actually see the rain clouds, you would be able to pull all of that information together to reach a conclusion. And so you may hear the term circumstantial evidence. So you may see different types of evidence in this case. Does anyone have concerns if you're only showing certain types of evidence in weighing that and giving it the weight it's due? Would anyone have concerns if you weren't shown a specific type of evidence that you thought you should see? So does anyone here watch CSI? No, we don't have the CSI people. Oh, I see maybe a nod. Is that your 526?
I've seen it in the past.
Or the criminal minds? So if you weren't showing a certain type of evidence that they might show in a TV drama or something you've watched, would that cause you concern with weighing the evidence that you are shown? You feel that you could take whatever evidence is given you and give it the weight it's due and draw that conclusion? And the judge in this case, actually, let me back up. The judge has read off the charges in this case. So we have some counts of conspiracy to commit murder, and we have some charges of first-degree murder. Would anyone, if you're given the instruction, so we talked about that recipe, if you're given an instruction from the judge, and one of the elements is not that we have to show what the cause of death was. So the state has the burden, but if one of the elements is not to actually show what caused the death, so instead that we had to show or prove that the defendant engaged in conduct that caused the death, but we didn't have to prove the actual cause of death. Does that cause anyone concerns? Would you be able to hold the state to the burden of showing, of meeting that element that a murder had occurred, but not add an additional element that isn't in the instruction? Anyone have concerns with that? And you heard the judge give an instruction earlier today regarding conspiracy, and that is conspiracy are a couple of the charges here that you're going to be looking at today. Does anyone here have concerns? Because you, if you hear evidence regarding actions of other co-conspirators, does anyone have concerns in following the court's instruction that the conspiracy would be an agreement between certain parties to commit a criminal offense, and then one of those parties doing an act in furtherance of it? Knowing that, would anyone have concerns holding one person accountable for the actions of another co-conspirator? So if the state met the burden that all the parties had formed an agreement and only one person did an act in furtherance, if you're given an instruction that says just one person has to do that act, does anyone have concerns if holding one of the other parties accountable that didn't do that act in furtherance? So, and again, the court will be the one to give you the final instructions, but if you're given an instruction that with a conspiracy, it requires 2 or more persons to enter into some form of an agreement to commit a criminal act, and then that one of those persons commits some kind of an overt act in furtherance of the conspiracy. If person A didn't commit that overt act, but they were part of the agreement, would you have a hard time holding them accountable, even though it was person B that committed that overt act? And thank you for telling me you didn't understand. I should have said that. If anyone ever has any questions, please let me know. So with that additional explanation, would anyone have concerns holding person A accountable along with person B? See people shaking their heads no. I may have just a moment. That's all the questions the state has right now.
All right, thank you, Ms. Blake. Mr. Pryor, you can conduct voir dire with the group. Thank you.
Good afternoon, ladies and gentlemen. My name is John Pryor. I'm here today representing Mr. Daybell. I want to start off by telling you a little story. And many years ago, when I told it to the other folks before you, I was a juror in a jury trial. And the lawyer in that jury trial asked, is there anybody who just doesn't want to be here? And I smiled, and eventually I put up my hand and said, yeah, I don't want to be here. And it wasn't anything of a significant trial. It was just one of these things that I had so much going on as a student, a lot of other obligations that I just didn't feel like I could focus or do the job that was necessary. So I'm going to submit that to all of you. And folks, it's really important. More important than anything else, we just need to be truthful with each other. And there's no wrong or right answer. There really isn't. If you don't want to participate in something, the best thing to do is say, you know, I just don't want to do this. Because like anything else, when I have chores around my house to do, and it's time to take the garbage out, and I don't like taking the garbage out, and I'm going to do everything I can to avoid taking the garbage out. And if it's something that you just don't feel like you want to do, you know, you would generally not put the effort into it that you would put into something that you enjoy doing or something that you feel okay about doing. So again, is there anybody here who, and please be honest, it's really what it's all about. There's no wrong, there's no right answer. It's what answer is in here, and that goes to each of you. I'm not going to judge. These folks are not going to judge, and at this point, the judge isn't going to judge. It's a play on words, I think. So again, is there anybody here who just doesn't want to be here today? And just doesn't want to be involved in this? And please be honest with me. Is there anybody here who believes that because Chad has been charged with this offense, that he's guilty right now? No. Okay. Is there anyone who can affirmatively tell me that they're going to listen to the entire evidence in this case? I mean, all of the evidence. That means after the state of Idaho, these prosecutors put on their case, and after Chad and I have an opportunity to put on our case, that you're going to wait before you make a decision in this case. Can everybody promise me that? And put the cards in. Promise me that, please. Thank you. And I'll try not to get you to exercise this too much, okay? I'll try to be patient with all of you as far as that's concerned. Is there anybody here who feels that they can't sit for long periods of time, that they're going to have a difficulty in sitting through this, whether it's medical issues, whether it's because you tend to twitch, or you tend to not be able to sit for long periods of time, or you don't have the patience? Okay, and then I'm concerned, and again, there's no wrong answer, because same thing, if you watched occasionally, I'm moving around because I don't like to sit. It makes me uncomfortable, particularly in these chairs that the state of Idaho has decided to provide for me. So why don't you elaborate a little bit on the fact about your situation?
Don't want to go into detail, just medical.
Well, if it's something that's private, I don't want to.
Oral medical, it's breaks and things like that.
Okay, is this something that's gonna cause you some pain? Okay, is that discomfort something that's gonna cause you to be distracted and not be able to focus as much as you really should in something as serious as this?
Usually not.
Okay, it's just something you wanted to bring to my attention. Is there any possibility whatsoever that this is gonna be a distraction in any way for you?
Not a distraction for me, maybe for the.
Okay,
Okay.
okay. You're comfortable, do you think you might be able to sit through this?
Yeah.
And if there's any doubt, again, there's no wrong answer. If there's any doubt about that, please let us know. Okay. Is there anybody here who knows me, other than these folks who are in the courtroom behind me, anybody in this courtroom right now from these stands forward? No? Now, Ms. Blake touched on a little bit about the court's instructions. She talked about what conspiracy was and went into some detail about the fact that there has to be an agreement. Then juror 536, who needed a little bit of a clarification. And is there anybody who can't follow the court's instruction? Yes. One of the court's instructions, it's going to be in regards to a conspiracy, is that the prosecuting attorney is going to have to prove that there's an agreement, and that this agreement has to be among the parties who are accused to be in this conspiracy. Okay. Is there anybody here who doesn't understand what an agreement is? Juror number 526, what do you understand an agreement? If you don't know, that's okay. We can pass the.
You've said something and something else agrees.
Okay.
They're in positive affirmation.
Positive
They have the same opinion.
Okay. And juror number 536, you were shaking your head, and I saw that when she said the words, and I want to make sure I say what you said, which was, I think it was positive affirmation. And juror 536, what do you think about
Yeah. Be of the same thought. If they're saying specifically to do a certain act.
Okay.
You can agree on something, not agree to do something.
Okay. And juror, I'm going to reach to the back, and juror number 686. How do you, yes, how do you feel about this idea of agreement? How do you define that?
Two or more parties come to a similar plan, agree on the details of the plan or whatever the idea is, and having trouble defining an agreement, but both parties have a similar thought and have stated that they match each other.
So does it have to be stated?
For an agreement, for direct agreement, yes. For an implied agreement, if everything else around it matches, then yes, but that can be argued either way.
It can be argued either way. So if you don't have the people making a positive affirmation, you have some questions about
Yeah, not entirely sure how to answer that.
And that's okay. And it can be a confusing issue, can it? Okay, and juror number 653, how do you feel about it?
I didn't say there's multiple aspects.
Okay. Okay. And I'm gonna move on to, juror number 647. Is it an agreement if someone is tricked into it or fooled into it?
No, because they weren't given all the information or the proper information.
So in order to have an agreement, everybody needs to know what's going on, know the terms.
Yeah.
Juror number 631, what do you think about what 647 just said?
I agree.
Okay, is that it? Okay. Straight to the point, right? And juror number 617.
I agree too. I think that you don't have all the information and you tricked into it. It's not.
Okay, all right, thank you, thank you. How do you folks? Well, I think I'm gonna pass on that judgment. You know, at this point, I think I'm gonna pass. I appreciate everybody's time. Thank you very much, folks. I really appreciate it.
All right, thank you, counsel. Mr. Wood.
We just asked a couple questions.
In the group setting here,
Yeah, we believe there's something that some law has perhaps been maybe misimplied.
Judge, can we approach, please?
Yeah, we can approach.
Okay, at this time, we've concluded the attorney's voir dire questioning. The court's going to now move on to a phase of individual questioning for jurors on certain topics. And so we will start with our lowest number, 440, I believe. Is that you? And we'll have the other jurors excused to the jury room while we discuss individual topics with the jurors. So if you're not juror 440, please follow the bailiff out to the jury room. We'll call you back in when we get to you.
All right, please.
Thank you. Please be seated. All right, juror number 440, we've got some indication in your questionnaire regarding both topics of potential, what we call bias. Don't take it personally. It's a question of whether or not you formed any type of an opinion based on pretrial coverage, and the other issue of a potential, there was some concern of hardship raised in your questionnaire also that I would permit the attorneys to ask about. So with this juror counsel, if we can begin there, we'll move on to the other topic of the death penalty opinions and views once we get through bias or hardship concerns. If the state's prepared, you can proceed with individual voir dire for juror number 440.
Thank you, Your Honor. Juror number 440, I want to clarify a few things in your questionnaire to see if they're accurate, if they are going to cause any concern, or if they're not. So just starting with the hardship section, looking at your questionnaire, and I think they've given you a copy of it for your benefit if you need it, but I'm just down on page 20. And with trial length, it had indicated that your stepson's high school graduation in Wisconsin is on May 24th. I wasn't sure from that, is that something you're planning on attending?
If I could have purchased that moment, he also is planning on
And graduation from the military, you said he's just going to be joining. So it's not going to be a super quick graduation. Okay, just making sure. So with regard to that, if you were selected to serve on the jury, that wouldn't end up causing you any concern. Knowing that that graduation was going on and you were here, would you be thinking about it? Would it create any concerns for your ability to focus on the case and the matter at hand? Thank you. And then just on the other one, and I think this was in regards to sequestration, you just indicated that you have school-age children that depend on you for care. If you were to be sequestered for any amount of time in this case, would that cause you concern or hardship?
I would say not too much. You're pretty independent when I'm not around. I give you less on that phone. And I have family that lives nearby that.
And so you think if you were to be sequestered, you'd be able to figure out the child care? Thank you. I just wanted to make sure that I wasn't missing anything additional there. So thank you for that. And then just looking with regard to bias, and I'm looking at page 19, there's just the question, it's F actually. If you formed a personal opinion regarding Chad Daybell's guilt or innocence, you'd indicated yes. And then you wrote, I do have an opinion, though it has been based only by what the media has reported, which is not always accurate. What exactly did that mean with regard to your opinion?
I know that media is not going to have all of the facts, and what they do have might not be accurate. So just knowing that, I see the news reports and that has caused me to form an opinion, but I feel like, whatever the facts are presented, that could change how it.
And when you say that could change how you feel about it, would you be willing to share how you feel about it right now?
Based on what I have seen, I would say yes, that needs to.
And knowing that the court, we talked about the recipe and following the court's instructions. Knowing that the court will give you some instructions, do you feel that you would be able to follow a court instruction to set aside anything that you've seen in the media and base any verdict only on what's presented in the courtroom in the trial in this matter? I don't have any further questions, Your Honor. Thank you.
All right, thank you, Ms. White. Mr. Pryor. Yeah.
In terms of communication,
Not really very well.
is that better? Okay. In terms of the trip to Wisconsin, are you driving or are you flying?
We would fly. If my husband knows, he's going to fly. But we haven't made any type of formal.
Okay. And it's a desire, for both of you to go, though.
It's a problem.
Okay. Is it going?
Financially, it might not be easy for all of us to go.
Okay. So there really hasn't been a determination as to whether you're all going or not. But you just have a desire to go. Is it going to cause you any anguish or cause you to lack the ability to focus on this at a time when this graduation is going on and you may be here as a juror in this case? Okay, and thank you for your honesty. I really appreciate it. Judge, if I could just have a moment, please.
Yes. You made a comment that you formed an opinion. And you said, however, the media may not always represent things as they actually are, and that there could be some slant in the way the media reports things. Is that fair?
Yes.
Okay. But at this point, you have an opinion about this case, correct? And may I ask you what that opinion is? Okay. Now, are you going to maintain that opinion and say, well, I think he's guilty, and that's what your opinion is right now, correct? But if you see other evidence that suggests otherwise, you're open to changing your opinion. But at the present time, as you stand before us right now, you believe that Mr. Daybell is guilty, and that's the opinion you're going to go forward with unless evidence is shown to suggest to you something differently. Would that be fair?
Yes.
Okay, Judge, I'm going to move for cause, if I could, please.
All right. Courts considered the responses here. Based on those responses, juror number 440, I am going to sustain the challenge for cause for bias. Again, nothing personal or trying to find jurors that don't have a preconceived notion of guilt or innocence. Just because you do, nothing wrong with that. You followed the news as many people have. And in this particular case, we're attempting to find jurors where the defendant's not improperly working against an assumption or bias someone may have. So for that reason, juror number 440, I am going to excuse and uphold the defense challenge. Thank you very much for filling out your questionnaire, for your honest answers today. Thank you for taking the time to come back in, and please drop your questionnaire off with the bail as you exit. All right, let's next have juror 505 return. All right, juror 505 has returned for individual without questioning. Just briefly reviewing the questionnaire again. You do have some prior connection or knowledge of one of the potential witnesses in this case, Greg Pekian. An additional concern may be some coverage you followed in the news. And so I'll let the state follow up on any additional Godard individuals for this juror.
Thank you, Your Honor. Juror 505, you mentioned you have met Greg Hampikian. What was the nature of your meeting with him?
So I'm an auditor where he works. I audited his P card one time.
Okay. And was there anything about that interaction that would cause you to give him greater or lesser weight as a witness? So you could take him as a witness with a clean slate and just weight it, whatever he said against all the other evidence. Yep. You mentioned that you had seen, you think, a Dateline.
I saw a special. My wife watches Dateline, so I put that down.
Okay.
Yeah, it was one of the specials.
And I noticed that you thought it was that, but you weren't sure exactly that's what it was. Do you recall when you saw this special?
That was more than a year ago.
Okay. And do you recall that, not that you need to say it all, but the content of that special, what it was about?
No, just the basic, pretty much what's been on the news. I recall.
And was there anything in that special that led you to lean either way as to the potential guilt or innocence of this defendant?
Not really. I don't remember it, to be honest. So, not very special.
Okay, so you remember seeing it, but you don't really recall the content too much. And you feel like you can, whatever you did see, it didn't cause you to form an opinion, correct? And you feel like you could put that out of your mind and render an impartial verdict. I did notice it said in your questionnaire you've had some training in forensic accounting.
Yeah, no, certified audit.
Okay.
I was the ACFE chapter president.
Okay. So that, without going into detail, there will be some evidence in this case that deals with accounting of funds at some level. Having that expertise you have, are you going to, do you think you might be kind of critiquing that accounting either way?
That would be hard for me to turn that off. Right? But, it's another professional's way of thinking. What we do.
Okay. And so would you be able to look at that evidence in a light that it's shown and weigh it against all the other evidence.
Yeah.
Okay, so neither this defendant or the state has to worry that, you'll get hyper-focused on one portion of the case. So, and I always say that because I kind of do that sometimes with, I have nothing else about bias.
All right, thank you, Mr. Wood. Mr. Pryor.
No, nothing, Judge, thank you.
All right, thank you, counsel. The next matter the court will discuss with this juror then will be as it relates to your questionnaire, starting page 12. We have a section in here called attitudes regarding the death penalty. Juror number 505, do you recall reading through those questions and filling out the answers for those questions in that section?
Yes.
And do you still concur with or agree with the answers you provided in the questionnaire?
Again, real quick.
Yeah, go ahead and review them, and that goes on for about 2 pages to the end of 13.
I think, yeah.
Very well. As we mentioned earlier in the proceedings, in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember that any penalty you consider should be considered as if it is absolute and will be carried out in this case. So with that in mind, knowing this is not a hypothetical set of questions, but questions about this case, you've indicated on your questionnaire, I'll note, there's a line that says, do you support or oppose the death penalty? There was not a response or check there. Was that something you intentionally passed over because you thought it was yes or no, or did you just forget to answer it?
I had a tough time answering no. I haven't been.
Okay, so you considered it. You didn't have a yes or no.
No.
Very well. You next indicated you would. It says, do you feel your views on the death penalty would prevent or substantially impair your ability to view the facts impartially? You said no. Do you still agree with, although you have mixed feelings about it, that you would be able to view the facts impartially?
Yeah.
The box you circled, or letter on page 13 that you circled on that bottom set of choices for what most accurately represents the way you feel. You selected choice C, which says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in this case. Do you believe that is an accurate statement of how you feel about the topic?
It's the closest one out of those choices.
Okay. One final question then for the court. Do you believe that you'd be in favor of the death penalty in every case where a murder has been committed? Okay. Regardless of your personal thoughts then, in this case, is there anything that would substantially impair your ability as a juror to perform your duty in accordance with the court's instruction, even if that meant considering the death penalty?
No.
All right, thank you for your responses. That concludes the court's inquiry on that topic. From the state, any questions on board?
The state doesn't have any questions regarding this issue.
Thank you. Mr. Pryor, any questions for the defense?
And sir, you mentioned that under item number 6 on page 13. Well, let me know when you're there, sir. I'll be there. Okay. You circled number C. And if I'm not mistaken, you said, well, that one's the closest to the way I feel. Would it be?
I think if I had to support or not, I would be more towards supporting.
Would it be fair to say that you're neutral?
That's probably close.
And if there was a choice between C and D that said, I am neutral on the death penalty, would that be a fair assessment that you'd be neutral on the death penalty?
That was an option.
You would have circled that one? Okay, thank you. And thank you for your time, sir. Judge, I have nothing further.
Okay. Juror 505, that concludes your individual voir dire. I'll have you return to the jury room with the bailiff to wait for further instructions as we get to the other jurors this afternoon. So next have juror 526. All right, welcome back, juror number 526 for individual voir dire. The court does not see much in the way of any prior case exposure or knowledge. There is some mention of hardship that may be addressed. If the state would like to inquire as to that, then we'll move on to our next topic after hardship's addressed.
Thank you, Your Honor. Ma'am, hi. You indicated that you offered dog boarding in your home. Is that something that you do for income?
Yes.
And so if you were selected as a juror in this case, would a 10-week trial cause you financial hardship?
No. No.
Do you have any pre-existing arrangements or contracts to provide that service with anybody that you would have to cancel or anything of that nature that would provide you hardship? Would be a hardship.
If I were chosen, then I would let the families know that has spoke to me. That's something, and I'm no longer available. It's that kind of thing.
Okay. Thank you.
Sorry, I tried.
It's okay. You also indicated that you have a little boy who has a birthday on June 1st. Is that correct?
Yes.
Is that going to be a local celebration or would it be something out?
It's supposed to be at my house.
Would there be something about throwing that party or having that celebration that would create a hardship for you that would make you unable to serve on this jury?
No.
Okay. Thank you very much. I have no other questions at this time.
No questions.
All right, thank you. The next topic then for juror 526 we're going to discuss is as it relates to the responses you provided in your questionnaire about attitudes regarding the death penalty. So that's a section within the questionnaire starting on page 12. Do you recall reading those questions and providing answers to those questions?
Yes.
And are the responses you provided when you filled this out last week still accurate in the way you feel today?
Yes.
Okay. In the first response, how do you feel about the death penalty? You said, I do not believe in it. Later on the second page, 13, there were some choices there. And you said what most accurately represents the way you feel would be choice D, quote, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. So I'd like to ask if that is still the way you feel about that topic as you sit here today.
Yes, it is.
Okay. And understand here in this case, we're not just dealing with hypothetical questions now. I would advise you in this case that it may well be necessary for you to make a determination in this case if you serve on the jury in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So with response to that, you did state that although you may feel opposed to it, you would still follow the facts, law, and instructions in the case, and if required, would be willing to follow those instructions on the death penalty. Is that the way you feel as you sit here today, knowing you may serve as a juror in this case?
Yes. Kind of like what you were saying earlier, the recipe that you're given. Does that make sense?
It does.
It was the.
So although it's something you may not be in favor of or like or agree with, if that's the law and the court tells you that is the law, you would be willing to follow an instruction in this case to follow that law?
Yes.
All right, that would conclude the court's voir dire as to this particular juror. Counsel for the state, if you'd like any follow-up, I'll allow that as well as the defense.
I don't have any questions, Your Honor. Thank you.
All right, from the defense. All right. That'll conclude our individual voir dire for juror 426. Thank you for coming back and your answers. The bailiff will tell you what happens next, and we'll have juror 536 brought in. All right, juror 536, thank you for returning for some individual questioning here. Reviewing your responses, let me first ask, are all the responses to the best of your recollection still accurate that you provided in this questionnaire?
Yes.
Okay, thank you. There's been some indication of previous knowledge of the case and perhaps an opinion expressed by this juror regarding guilt or innocence. I don't see much in the way of a concern for potential hardship. So for the state, if you'd like to inquire as it relates to any potential bias, I'll begin there and then I'll move to the defense.
Thank you, Your Honor. Excuse me. So, ma'am, do you have a question now with you? I might reference you to some pages just to make this a bit easier. I might call your attention to page 15. Excuse me. My first question, at the bottom of page 15, you did make an indication that you learned some things about this case from local news, and you mentioned perhaps Daylight or some other special. Is that right?
Maybe, yeah. I watch a lot of shows.
Okay. So then I would just draw your attention down to the next question. It says, I have an opinion that he was involved. That's referencing Chad Daybell. Can you explain that more? What did you mean by your opinion that he was involved? What do you believe as you sit there?
If we could mute the on-table mic while we use the handheld, I think. Okay, thanks.
You're my mouse, so perhaps. Sorry, ma'am, did you get that question?
Yeah, so when it was first in the news with the kids missing, it just seemed like a really long time went by and seemed like there were claims of no knowledge at all you know, or that they were with someone else or. So it just seemed like there was a lot of time that passed where there was no voluntary knowledge of what might have happened.
So without wanting to put words in your mouth, I don't. Is it accurate then to say that you're not sure exactly what you believe he was involved with, just that there was involvement? Is that a safe way to say it?
Yeah.
Now, you understand that, as Mr. Daybell sits here today, until the state completes our job and proves he's guilty, he's got the benefit of a presumption of innocence. You understand that? Yeah. When you make the comment in the questionnaire about you believe he's involved, do you think that's going to impact you and your ability to presume his innocence until you believe he's been proven to be guilty?
No, I know that I need to go by the evidence that we are given.
You're prepared to do that?
Yes.
Okay. I next like to direct your attention back, excuse me, to page 19. On page 19, the very last handwritten response that you made, it says, I can't think of any specifics to specific involvement or specific actions. And that was in response to a question about an opinion. Did you have any other opinion about Mr. Daybell or this case besides that you believe he was involved in some way?
No.
You, on the bias portion, Your Honor, I don't have any more questions for this juror, but I may have some others.
Thank you. Mr. Pryor?
Juror number 536. You made the comment that you think he was involved. Was that based on the facts that you had heard some time ago and said, you know, looking at this thing, it seems like he has some involvement in this? Would that be fair? Or is that how you feel at the present time?
Well, I guess both then.
Okay. Okay, so going into forward, if you were to be chosen to stay on the juror, is your mindset that he's guilty right now and I'm going to have to prove that he's innocent?
No.
Okay, and that's really what I'm trying to get at is at the present time, you have information based on what some of these folks in the media have provided to you, right?
Right.
And you recognize that that may not have anything to do with the truth.
Right.
And you may recognize that when media outlets and all of these TV shows that talk about this stuff, they have a tendency to sensationalize things.
Yes.
It's what sells. I mean, newspapers take all sorts of liberties. TV shows take all sorts of liberties because they have to do that gotcha thing.
Right.
You recognize that.
Yes.
And at this point, you don't have any bias or you haven't made a decision that Mr. Daybell is guilty at this point. Is that fair?
Correct.
So you would be agreeable to looking at all the evidence. That includes what the state of Idaho does and those prosecutors and what I put on before you actually make your determination of what you're going to do.
Absolutely.
And you will guarantee to all of us that that's the process you're going to go through. And I appreciate you walking through this. And you understand how important that is, correct?
Yes.
And I'm not trying to talk down or be condescending in any way. I'm just trying to make sure that I, step by step, that we both recognize that it's really important that you look at all the evidence and hear what everybody has to say before you say, this is how I feel about this case. And would you be agreeable to that?
Yes.
Okay, Judge, that's all I have. Thank you very much, Your Honor.
All right, thank you. All right, juror number 536. The next topic I'd like to cover with you, and I'll have some questions and statements, and after that, I'll allow counsel to inquire as well. This relates to attitudes or questions regarding the death penalty, and that's what begins on page 12 of the questionnaire. Do you recall reading those questions and considering and thinking about your thoughts on the death penalty?
Yes.
Are the responses that you provided still the way you feel and accurate today?
Yeah.
Okay. As I stated earlier in the proceedings, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. So remember also, any penalty we're considering or discussing here in this case should be done as if it is absolute and will be carried out in the case. So with that in mind, you've made responses that on part B, you say, do you support or oppose it? You indicated you oppose it. Is that correct?
Yeah.
And when given just that yes or no answer. Okay. You next indicated in the next two questions that would not impair your ability to view the facts impartially. You still agree with that?
I do.
And you still agree with that would not impair in your ability to return a guilty verdict if the state had proven its case beyond a reasonable doubt?
Right.
Okay. If you look over to page 13, when you were given your choices on pre-written summaries of what you think most accurately represents the way you feel, you selected choice D, which reads, I'm generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Do you still think that would accurately represent your feelings about the death penalty?
Yes.
Okay. So knowing here you may potentially serve in a case where that is something you would have to consider as a juror, let me ask you to confirm, would you be willing to follow the court's instructions on the law, even if you may have some opposition to the death penalty, and follow any instructions given to you, even if it required you to consider that in this case?
Yes.
All right, that will conclude the court's questions as it relates to that particular topic. Moving on to the statement, any questions from the state on that?
Yes, just a couple, Judge. Ma'am, I don't recall if the court specifically asked this question, but on page 12 of your questionnaire, the first question about the death penalty, you were asked, how do you feel about it? In response was that fiscally, it seems like it tends to waste money with appeals. Can you first explain your perspective on that? What do you mean by that?
It just seems like there's a lot of money wasted, and with the appeals and everything, it just goes on and on. So, you know, life in prison is a lot of times what they usually end up serving anyway. So yeah, there's just a lot of money spent there.
So is it accurate to say that with that statement, do you feel like a death penalty imposition wastes money because of the appellate process? Is that what you were trying to say or not? I don't want to put words in your mouth.
Yeah, that's what I mean.
So then if that's a feeling that you have, and again, we are just asking you to be brutally honest, would that feeling have any influence on you when you are listening to the facts of the case and then after the verdict you're asked to consider the death penalty? Will that feeling that imposition of the death penalty is largely can be a waste of money, will that influence your willingness to decide to impose it or not?
No, because it's the law here.
Okay. Your Honor, if I may, I had missed one biased statement. May I go back to that topic? It was just one statement.
Go ahead.
Thank you. Ma'am, I do want to go back to the issue of potential bias. On page 15 of your questionnaire, there's a question number 5. It says, could your knowledge of Chad cause you to give either greater or lesser weight to any statements I made? You said yes. Then in your explanation, you wrote, since it seems like he's been untruthful, I would not necessarily believe all statements. In what way have you come to believe that he's been untruthful? What do you mean by that?
Well, I guess first of all, I want to say that I don't necessarily believe everything anyone says. So, yeah, to have the amount of time, like I said before, that it was in the news, you know, where the kids and I'm assuming that there was some untruthfulness going on during that time. But yeah, I don't know for a fact.
Okay. Well, thank you. I'll just leave it with the last question. And so that feeling that or assumption that he was in some way untruthful, is that something that you can set aside and still give him the presumption of innocence until we can prove that he's guilty?
Yeah, but I won't necessarily believe every statement that he makes just because he says the words.
So is it fair to say that you maybe have a bias as to his credibility if he were to take the stand and to testify? Is that what you're saying? And I'll remind you, the judge will likely instruct you that you don't have to believe all of anybody's testimony or none of anybody's testimony. It's entirely up to each juror to decide what portion of any witness's testimony they choose to believe. So with that understanding, do you feel like this assumption that he's been untruthful is going to cause you to be unwilling or unable to presume that he's innocent?
No, I will look at the evidence that would support either way, innocence or not.
Thank you. I don't have any more questions, ma'am.
All right, thank you. Mr. Pryor, either on any follow-up to that bias topic, I'll permit, as well as any questions you have regarding the court's questions on the death.
Okay. And ma'am, part of your job, you understand, is to not just look at Mr. Daybell as anything he may have said, but you're also going to be looking at every single witness. You're going to be looking at police officers. You're going to be looking at witnesses. You're going to be looking at experts. Part of the process is to determine who you believe and what you believe. You agree with that, right?
Yeah.
And part of that is statements made by Mr. Daybell or anybody else. Part of your job is to evaluate and say, listen, I believe this, I don't believe this. And if you're doing the job of a juror, as you seem to be suggesting you will, that analysis will go on throughout the trial, and you making a determination who, what, where, when you believe. That be fair?
Yes.
And then lastly, your comment about death penalty, and this is at the bottom of number 12. And this is going to, I promise this is going to be my last question. Okay. I promise.
Yeah.
You said, do you feel the death penalty is used and you check too often?
Okay.
Yeah. And then you wrote in there, between the fiscal reasoning above, mistakes also happen. So this isn't saying that you're going to vote automatically against the death penalty, but in general, you're leaning that, you know what, I've got to be fair and look at both sides before I really make a fair assessment of this. Would that be a fair statement?
Yes.
Okay. All right. And thank you very much for your time. I really appreciate it. Nothing else, Judge. Thank you.
All right, thanks, counsel. That will conclude the individual voir dire for juror number 536. Thank you for answering those questions. We'll have you return with the bailiff to the jury room. await some further instructions before you're released today. And thank you for your patience. Juror number 617 will talk to next. We'll need a quick break, or should we keep going? I mean, I think we might be another bit here. I'm inquiring for staff too. Are you okay, Mary? Okay,
The state's okay.
thanks.
Sorry,
I just asked if anybody needed a quick break or recess before we got through the rest.
I think we're ready to just push through, Judge.
All right, thanks. Welcome back, juror number 617. This is the time we got you here for some individual questioning on these questionnaires. I'll note there's been a minimal discussion, but some knowledge of the case and not much in the way of hardship. So if the state would like to make any inquiry as to any potential bias, we'll start there and then I'll allow the defense to follow.
Thank you, Your Honor. The only thing I saw on potential bias, so I just wanted to follow up with you. It looked like you had maybe limited media exposure or limited knowledge of the case. You had written a statement on a question regarding your ability to act impartially. You had written, I would try to act impartially. So I was just going to follow up with you as to what you meant by that.
Yeah, because I don't know how you could live in Idaho and not know about the case. And so try to, at least I've tried to, you know, especially I haven't watched it all the news. Any reference comes on since, and actually I stopped watching it because it's sort of beating us up with it a long time ago. Yeah, I mean, it was on Dateline and everything. So I think it's important to try. Like I said, I would do my best and listen to the evidence and stuff because I think a jury, serving on a jury, it's like one of the things of the American that we do. Here, you know, the economy, you're off a trial by a jury of your peers. And so it's to me, it's almost like it's like something you're supposed to do as an American citizen. So you try to, you know, do your best for the person, for everybody. Like you said, both sides, actually talk today.
And when you talk about the media coverage that you saw, and you said that you will try, and I appreciate your honesty. So knowing everything that you've seen and heard, do you feel that you could set that aside and act impartially, or do you still have concerns as to whether or not you'd be able to do that?
You know, I would try to it's like I said, I stopped a long time ago. Like I didn't even watch the Dateline thing. I remember about Dateline, and because it's just been overwhelming. Anyway, yeah, I think I can set it aside. I'll do my best.
I don't have any further questions. Thank you for that.
All right, thank you, Mr. Pryor. All right, next topic then, juror number 617. There is a section of the questionnaire that you filled out, and it's entitled Attitudes Regarding the Death Penalty. Do you recall reading through those questions and answering those?
Yes.
And are your responses contained in your questionnaire still accurate as to the way you feel as you sit here today?
It is.
Okay, I'm going to walk through some of these responses you have here. The first, you made a comment in opposition and also It says, do you support or oppose the death penalty? You indicated to oppose it. Is that accurate?
Yes.
All right. Now, just so you know, that what I'll try to resolve here are your responses on that part C and D with the response you have on the next page. And again, we're just getting information. So I'm on page 12. And kind of right in the middle of that page, there's a question C, 1C on page 12. And it says, if you located it, do you feel that your views on the death penalty would prevent or substantially impair your ability to view the facts impartially? And you said no. And then the next question, do you feel your views on the death penalty would prevent or substantially impair your ability to return a guilty verdict of first-degree murder against the defendant, even if the state had proven its case beyond a reasonable doubt? You said no, that would not impair that ability. At the bottom of the page, you say it should never be used. And then if you just flip over to page 13, and I'll have you finally review your response at the very bottom of the page where you circled G.
Yeah, I strongly believe that.
Okay, so the questions I'm going to have following up. If in this case, the court were to give you instructions indicating that you had to consider the death penalty, and let me go back before I finish that comment and say to you, as we've said, in this case, it may be necessary for you to make a determination. So this is not a hypothetical, and a determination in regard to imposing the death penalty or some other penalty. And also, you have to consider here this, you should consider that this could be done and it would be absolute and would be carried out in this case. So if that's what you are considering, if the court were to instruct you that you were to consider death penalty, would you be willing to do that?
No, sir. If that's the only option, I wouldn't be able to do that. If we couldn't vote for life, all three things like that.
Okay, so if that's the case, do you think your views now on the death penalty would prevent or substantially impair your ability to perform your duty and follow jury instructions if those instructions were included here?
Okay. I have a hard time being with it because I don't know how your instructions will go. I can't imagine you going, go back and sentence this guy to death. If we're given the choice to do the penalty, why couldn't we vote for life in prison without parole? But if the only choice is the death penalty, I couldn't do it. I truly could not do it.
Okay, and again, your personal views are absolutely protected and allowed, and we're just getting to a question of whether or not you are able to serve in this particular case where this is an issue. I guess another way I would ask it then, and just to be clear, it's not necessarily some sort of voting system, but in terms of an instruction you would receive of considering how much proof there is or is not to determine if the death penalty should be imposed. If that's where this case ended up, are you telling me unequivocally that you would not be able to follow an instruction if it required you to consider and or impose the death penalty if the state gave you enough evidence that you had to do that?
Sure.
You would not do it under any circumstance. Okay, thank you so much for your candid responses. Let me ask the state if they have any follow-up for this juror.
Your Honor, the state has no follow-up questions, but would move to excuse this juror.
All right.
Based on those responses.
Mr. Pryor,
Okay, Ms. Blake, please repeat, and then I'll go on to Mr. Pryor's position.
Your Honor, based on the juror's response that he unequivocally could not impose the death penalty, if it came down to that, the state would move to have this juror removed for cause.
All right, there's been a challenge here, Mr. Pryor. What's the response? And you may inquire on voir dire if there's any rehabilitation.
Judge, may I pursue some rehabilitation?
Yes.
And Judge, can I have permission to stand up? We've been sitting for some time.
If you'd
May I
like,
go to the
yeah.
Podium?
You may approach the podium. Just make sure you use the microphone.
And juror number 617, I want to clarify something. If you were chosen as a juror in this case, and the judge gave you an instruction that said you were to consider either life imprisonment as an option or the death penalty as an option, would you follow the court's decision and agree to consider both of those? Would. Okay. And let me finish that, if I could, sir. Would it be fair to say there are circumstances that you would consider the death penalty? No. Okay. Could I give you an example? Would you mind talking about this a little bit with me? Sure. Okay. It sounds like when you made mention that you think that it's a high honor to serve on a jury and it's our obligation as citizens. Would you agree with me in that regard? Okay. And as a high honor, it's also part of our laws of our country to protect our country. Our president's job is to protect our country. So there are very brave military and our police officers and all of the folks that are involved in any aspect of law enforcement. If we were attacked in a foreign country and they started engaging in genocide, do you understand what genocide is? Yes. And they started killing people needlessly. And at some point there was some sort of trial. And it's an egregious act. Children, young people murdered on the streets. Horrendous acts of violence against people that are citizens in this country. And at that point, we have to make a decision. And the options are to consider the death penalty. And if it means we have to take actions in order in the future to protect our country, is that a situation where you would consider, voting to impose the death penalty on a situation like that?
I didn't come by this lightly. It's who I am. And I believed it for years. I believed it from my teens. And once I joined the Catholic Church, my Pope said it would be. It's just reinforcing it. It is part of my makeup. I have it in my family. If I was killed, if I died by another person's hand in a violent act, my family is not to let the prosecutor pursue the death penalty. I understand, and I have, and I think I'm a loyal American. I would defend this country, and stuff, but it's different in a war. You're taking somebody's life, but I don't feel it's right. I don't feel it's justice. I feel it's revenge. I'm sorry. I will not. I cannot vote for the death.
And so there's no apology needed because you know what? I think I spoke with all of you folks earlier and said there's no right or wrong answer here. It's what each of us individually believe in our hearts. So there's no need to apologize because what you believe, what we're trying to establish is, and my questioning is not to get you to change your mind. That's not what my intent is here, sir. What I'm trying to do is find out whether there is a very narrow exception that says, yes, there are exceptions where I would consider the death penalty. And they would be very narrow, but I'm not absolute. I've got some situations where I would consider that. But I think you've answered my question. And I appreciate your candor and I appreciate everything. And I'm not trying to disparage you or in any way. As I stated to all the other jurors, there is no right or wrong answer. It's what each of us honestly believe and to tell the court what we believe in. And I want to thank you for your honesty. Thank you, sir.
All right, the court has considered the motion to strike as to this particular juror number 617. The juror stating unequivocally they would be unable, because of personal views and beliefs, to follow or unwilling to follow an instruction if it involved imposition of the death penalty. The court finds there is cause to strike juror 617. Thank you so much for your candor in expressing your opinions on that issue. You can be excused with the sincere thanks of the court for your service today and for last week filling out the questionnaire. And we will go ahead and discuss this with another juror, and you can be excused. Please drop your questionnaire off with the bailiff. Juror number 631. All right, thanks for returning juror number 631 for individual or dire counsel. There's a bit of a expression of concern on hardship, and there was a request for hardship excuse. Let me just start off by asking for a little more detail. You stated maintenance of medical equipment at a hospital. Can you explain how that issue would be addressed by you if it's still a concern?
At the time, I was the only technician trained at our hospital to work on anesthesia machines. I've spoken with management about that. They will call it an outside company if I do get selected.
Okay, so you no longer have a concern about a possible hardship if you're required to serve in this case?
No.
Okay, thank you for clarifying that. Counsel, I don't see any other grounds of inquiry in terms of bias or hardship, so I would propose we move on to the next topic. Does the state agree?
Your Honor, if I can just ask one question.
Go ahead, Mr. Wood.
Juror 631, would this pose any type of financial hardship?
No.
Okay,
My company pays for it.
that's it. All, Your Honor.
All right, any questions?
Judge.
All right, so the next topic the court wants to discuss with you then, juror 631, is in relation to your attitudes regarding the death penalty. You filled out a section in your questionnaire starting on page 12 there and advised us of your views on the subject. Are the responses you made there still accurate in the way you feel as you sit here today?
Yes, I believe so.
Okay. Let me advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And when you're thinking about that, you should consider that it would be done as if it's absolute and would be carried out in the case if that was your decision. So with that in mind, looking at your questionnaire, you stated on the B section in the middle of page 12 that given a choice of support or oppose the death penalty, you indicated you support it. Is that still the way you feel?
Yes.
Okay, and then just given a choice of selections about what accurately represents the way you feel, on page 13, you circled paragraph C, which reads, quote, "I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions of the case," end quote. Is that still, you think, a accurate representation of your thoughts on the death penalty?
Yes.
Okay, where you've indicated you would follow the instructions if required to do that, one other question I'll have for you then. Would you, pardon me, would you be in favor of the death penalty on every case where a murder's been committed?
It depends on the case.
Okay, so if the instructions were there that you were to consider it, you would be able to consider it? If you were not instructed to consider it or instructed not to consider it, would you be willing to follow those as well? Okay, that concludes the court's voir dire of this juror as it relates to the death penalty. Is the state wishing to have any voir dire on that issue? All right, from the defense, any questions?
Just a few. Sir, I'm looking at your questionnaire and it's on top of page 14. Could you refer to that for me? And I'll read that as best I can. If you were in favor of the death penalty in some cases, do you agree that a sentence of life in prison rather than the death penalty would be appropriate under proper circumstances in some cases? And you marked the no. So I guess I'm just, and this is not a quiz or anything else. Obviously, I think we spoke earlier, and I mentioned that there's no right or wrong answer. It's what each of us personally believe in our hearts. And that's what we were trying to arrive at here. What are your personal beliefs and what are those beliefs? 16 or 20 people, everybody has different beliefs, but there's no right or wrong. You get to say what your beliefs are and let us know so we can do an assessment of where we think whether you fit here or not. Is that fair?
Yeah.
Okay, so when it says that you would not consider life in prison as an option, if for some reason, and this isn't to imply that Mr. Daybell is going to be found guilty, but if we are in front of and the jury makes a decision that it's a guilty verdict, and the court gives you a life sentence as an option, and the death penalty as an option, and you have to decide which of those two you're going to choose. The way I'm reading number 7 there is that you will always choose the death penalty.
I didn't interpret that question that way.
Okay, okay. Okay. So is it fair to say then that under certain circumstances you would not impose it?
Yes, it would depend on the circumstances, yes.
Okay. And you're looking at those items A, B, C, D, E, and F, and G. And that would be on page 13. Could you go to 13 for me? Do you mind? Let me know what you mean. You marked number C. And then right below it is number D. And the only difference between C and D is C says I'm generally in favor of the death penalty, and D says I'm generally opposed. But both of those say I'm going to consider other options. Would you agree with that? With that both of they're relatively close with the exception of one says generally opposed, one says generally agree. Am I confusing you?
A little bit.
Yeah, I'm sorry. In looking at those, you mark number C, and then right below that is number D. Did you see number D?
Yeah.
And it's basically the same writing in D, except the first part says generally opposed. You see how that's written?
Okay.
Would it be fair to say that you're between the generally opposed and generally agreeable, and that you're more neutral on this, and you're going to take time to look at the facts of the case and make a determination how you're going to vote, based on the facts of each individual case?
I suppose so, but I'm not opposed to the death penalty.
And I'm not saying that, but, I'm not necessarily saying you're not opposed to it. But when given that opportunity, if that should happen, you're gonna weigh both of those equally, aren't you?
Yeah.
And you're not gonna rule one way or the other until you have all of the facts and make an informed decision of which way you're gonna go. Would that be fair?
Would that be fair?
Okay, is that how you would feel in this situation? And you would be neutral and weigh the facts one way or the other before you make that final decision? Well, I don't want to put words in your mouth. Is that how you feel? Or do you feel that you really just agree with the death penalty and that's where I tend to be wanting to lean? I guess that's what I'm trying to get established here.
I would say I'm not opposed to the death penalty. It's on the table and, if I feel it's needed, then that's the way I'm going to.
Okay, so you're going to look at both circumstances then?
Yes.
Okay, and Judge, I have nothing else. Thank you very much.
All right. Juror number 631, then that will conclude the individual for Dyer. Have you returned to the jury room. Thank you for your patience. I know it's been a long day for you today. We'll have you instructed further as soon as we can. We've got a few more to get through, and then we'll call you back into the courtroom shortly. Juror 647. All right, Juror 647, thank you for returning. We're going to conduct some additional voir dire here. The court wanted to first address issues of potential bias. I don't believe there were any concerns regarding hardship. Counsel, the court did offer a special instruction, and I would note that this juror has some specific knowledge of the companion case. And so perhaps those are appropriate lines of questions here too. I am going to let the state first inquire as to whether or not there would be a bias to be considered, and then I'll let the defense proceed after that. So who's conducting voir dire here for the state? All right, Ms. Beatty, go ahead.
Hi there. Just a few quick questions. I saw that you had seen a little bit about this case on the news. And I want to specifically talk about on page 15, you indicated that you had seen on the news that Lori Vallow was recently found guilty and sentenced in her case. Knowing that, would you be able to take Mr. Daybell, the defendant, and give him a clean slate and a presumption of innocence going into this case?
Yes.
Fair and impartial. Okay. And there's nothing else that you saw about this case that would influence your decision-making process in any way? And just, if you understand that what you've seen on the news or heard on TV or social media is not evidence. Correct. That's all the questions I have, Your Honor.
All right, thank you, Mr. Pryor.
No questions, Judge.
All right, the next topic then the court will address with you, Juror 647, relates to responses you provided on the questionnaire starting on page 12. And this is on the topic of attitudes regarding the death penalty. Do you recall reading through those questions and answering those in the questionnaire?
Yes.
And are the answers you provided still true and accurate in the way you feel as you sit here today?
Yes.
All right, as I previously stated, in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So considering that, then you were posed a question about do you support or oppose the death penalty? And to summarize, you said it's more complicated than that for me. Is that a good summary of how you answered? You question marked both of those options.
Yes, because I don't think I actually have a strong opinion. And I know when I got maybe over to page 13 and just talking about that there is law and there is rule, I don't know those and I'm not familiar with it. So that is something that kind of swayed my support or oppose. I would need to have more information.
Okay.
To grasp that, like, understanding of the process.
You stated in your questionnaire that your views on the death penalty would not prevent you from being impartial in this case and viewing the facts impartially. Do you still feel that way?
I do feel that way.
You've also stated that your views on the death penalty would not prevent you from the ability to return a guilty verdict of first-degree murder if the state proved its case beyond a reasonable doubt. Do you still feel that way?
Yep, I still feel the same way.
All right, on page 13, you did circle D out of the choices there to say what most accurately represents how you feel. You said the choice you made, not your words, but in the questionnaire. I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if called for by the facts, law, and instructions in the case. You added some additional language on that, but is that still the way you feel at this time?
Given those choices I was given, yes, that was the one that I would say would be closest to my alignment.
Okay, so to be clear, if the court did instruct you that in this particular case you were to consider it, you're telling me that would not impact your ability to return a verdict, is that correct?
Correct.
And if the state proved its case beyond a reasonable doubt, you would be able to return a guilty verdict, is that correct?
Correct.
And likewise, you would be also willing to fully follow any instructions the court gave you, even if it required you to consider the death penalty. Is that accurately how you feel?
Yes, correct.
All right, that will conclude the court's inquiry on voir dire for this topic. I'll let the state proceed if they have any questions.
Your Honor, I don't have any additional questions.
All right, thank you, Ms. Bailey.
No questions, Your Honor. Thank you.
Okay, juror number 647, then that concludes your individual voir dire. Thank you for your candid responses today. We'll go ahead and have you return to the jury room while we go through our remaining jurors and call you back as soon as we can. Thanks for your patience. Juror number 653 will be next. All right, juror 653, thank you for returning for some additional voir dire questioning. There's a bit of previous case knowledge, you do have, in addition, there was a concern of hardship. Let me first ask you some additional questions about the potential hardship here. You did fill out on your questionnaire and you said it could be a financial hardship given 10 weeks and no paycheck. Is that still the position you're at currently?
No, that was before my employer told me that I was covered.
Okay, thank you so much for clarifying that. Given that, then, do you have any concerns about a hardship if you are required to serve in this case?
No.
All right, with that, then, let's have this voir dire limited to any questions on potential bias with some case knowledge, and then we'll move on to the next topic if we get through there, beginning with the state.
Your Honor, the state doesn't have any questions as to bias or case knowledge on this armed juror.
Okay.
No questions, Judge.
All right. So juror number 653, then the next topic we would discuss, is it in relation to your answers about your attitudes regarding the death penalty?
Mm-hmm.
Do you recall reading through those questions and answering those questions on that topic? It starts on page 12 in the questionnaire if you want to refer to your copy.
Yeah, go ahead.
Okay, are the answers you provided in that section of the questionnaire still true and accurate?
Yes, it is.
And that's the way you feel as you sit here today?
Yes, it is.
You indicated that you would support the death penalty and say you agree it's appropriate under Idaho law. Is that correct?
If it's appropriate, yeah.
All right. And on page 13, you were given some options about what best represents how you feel. You circled D, and D says, I am generally opposed to the death penalty, but believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts law and instructions in the case. So do you believe that accurately represents your feelings about the topic?
As far as all of the choices were, that was the closest, I guess. I'm not just straight, like, all for it, and I'm not straight against it. It's just.
Okay, in this case, I will advise you that it may be necessary for you to, in fact, make a determination here on the topic of death penalty and make a decision in regard to the imposition of the death penalty or some other penalty. And you need to consider that as if it would be done and would be absolute and carried out in the case. So knowing that, then where you've indicated maybe some opposition to it, would you be willing to follow the court's instructions in this case, even as it relates to any instructions on the death penalty?
Correct. I would.
Okay, is there anything about your personal views or opinions or beliefs which would make you be unable to or unwilling to follow any jury instructions provided to you?
No, not at all.
Do you have a feeling that, or a belief that it would be appropriate for the death penalty to be imposed in every case where a murder has been committed?
No.
Okay, so you'd be willing to consider each case independently based on a court's instruction?
Independently on the facts of the case.
All right, that will conclude the court's inquiry as it relates to this juror. Does the state have any questions for juror 653 on that issue?
We have no questions, Your Honor.
No questions, Your Honor.
Okay, thank you for returning juror 653. We'll have you go back to the jury room and we should be getting to you pretty quick here to release you for the evening. We'll next bring in juror 686. All right, welcome back, juror number 686. This is the time we have for some individual questioning. I'd note that you didn't indicate any previous knowledge of the case. So in terms of bias, I'll just inquire of the state. Will the state waive any further voir dire on bias?
Your Honor, I have no questions regarding bias or hardship.
All right.
I don't either, Judge.
Okay, I've actually got one I do want to follow up on hardship, just to be clear here, juror 686. So you said the length of the trial wouldn't be a problem. You did make one comment on page 20, and you said that with the court's trial schedule of finishing each day at 3:30, it said that time would allow me to continue to fulfill work obligations. So I wanted to sort of clarify what may be happening here. Is it your proposal to us or yourself that would you believe you're going to be working full time or maintaining whatever current job you have while this trial is going for those 10 weeks?
Not full time, part time. I'm a resident for my clinic, and so I would either need to contact the residency board and my company and kind of let them know that I'm going to be completely off for 10 weeks, or work, a few hours every day just to kind of maintain my residency position.
Okay. The reason I bring that up is I believe you may find between the time to get here, leave and listen to trial through a day, that you might be mentally exhausted and done working. So I just want to dispel any sense that maybe somebody could work full-time and do this full-time. I think it'd be very difficult. So I appreciate your response. The court raised that. Any further questions on his work obligations from the state?
I guess just briefly with that additional information, does anything about that in your mind impact your ability to sit on a jury in this matter?
No, if I'm here, I'm committed.
Thank you. I have no additional questions.
Okay.
No questions, Judge. Thank you.
All right. The next topic then we'll get to is on your attitudes regarding the death penalty. That was addressed in the questionnaire starting on page 12. Do you recall reading through those questions and answering those questions?
I do.
As you sit here today, do you think your responses are still accurate in the way you feel?
I do.
All right, let me just advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be considered as if it is absolute and will be carried out in this case. So with that in mind, I'll note you had a choice first on page 12 on the question, do you support or oppose the death penalty? You said you support the death penalty. Is that still your position here today?
It is.
You next stated you didn't think any opinion you held on that would prevent you from being an impartial juror. Is that still the way you feel?
Correct.
And do you believe you'd be able to follow all of the court's instructions relating to the death penalty if they were provided in this case?
I do.
All right, on your selections on page 13, where we gave you some options about what most accurately represents the way you feel, you selected choice D that said, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that the way you feel about it?
Yes.
Okay, so with that general opposition, I'll just ask you to cover this. Does that mean you're not in favor of the death penalty in every case?
So I guess to clarify, I support the death penalty as an option. I personally feel that I generally oppose it just because I feel that death might be considered an easy way out for some people. And so part of that goes along with argument against it, which is the life imprisonment in a small cell would be, I consider, a far worse punishment than killing someone.
Okay. given all of your thoughts on this then and your responses, is it correct for me to say that you would be willing to follow any court's instructions, even if it required you to consider the death penalty on proof of evidence by the state?
Yes.
All right, that will conclude the court's voir dire on that topic for this juror 686. Does the state have any questions?
The state does not have any additional questions.
All right, thank you from the defense. Okay, juror 686, thank you for returning for individual voir dire. We're going to talk to one more juror individually, and then we'll bring you back in.
Oh, thank you.
You're welcome. Our final juror of this group will be juror 740. All right, juror 740, thank you for returning. We've got some additional individual questions for you. Do you recall filling out and completing the questionnaire last week?
Yes,
And is everything you provided in there still true and accurate as well as you remember?
yes.
Okay, counsel, there are some indications here both of potential hardship and also a knowledge of the case we need to discuss. Let me first indicate you said, and we don't need to discuss terms, you can if you would like. You've got a medical procedure that would need to be rescheduled. You did indicate you thought that would be a hardship. If you were required to serve here for 10 weeks, let me just confirm, is it still the status, as you mentioned in here, that that procedure would have to be rescheduled?
Yes.
And how, can you just explain to me a little bit about how much of a hardship that would be, or whether you just simply think that shouldn't be rescheduled?
No, I don't think it'll be a hardship. I can just have it rescheduled until August or.
Okay, so it's an elective procedure and it's not on some critical time frame. No. Okay, that was my only question on that. Counsel, you can inquire further on any hardship. In addition, there is some case knowledge, starting with the state. If you'd like a question on bias, we'll begin there.
Your Honor. Juror 740, so reading over your questionnaire, it looks like you have followed this case fairly closely. Is that accurate?
Yes.
And it looks like, and I'm not gonna delve into it, but you know a lot of the facts, or at least the facts as reported by the media.
Correct.
And you're familiar with the defendant's with his wife's case.
Correct.
And you mentioned did you follow that trial?
Just from the news reports.
The news reports, okay. But you did keep current with it?
Yes.
And is there, you have your questionnaire with you?
I do.
Could you open it to page 19 and question 10D?
Yes.
And so is it fair, and I don't want to mischaracterize what you said, but is it fair to say that you feel as though the media has portrayed this defendant as guilty?
Correct.
And You then go on to say you'd be able to put that out of your mind and render an impartial verdict.
I think I.
Okay. Thank you for your honesty. Understanding, you understand that the state has the burden of proof, correct? And this defendant has the benefit of the presumption. He is innocent until proven guilty. And so when you say, I think I can, and there's not a wrong answer. There's nothing wrong with your answer, just to be clear. Can you understand how both the state and the defendant might be concerned that that's not an unqualified yes, I can set it aside?
Yes.
I did want to ask another question, may relate to bias. And I don't want to go into the details of it. It sounds like one of your siblings may have gotten into a little bit of trouble. Correct. Would that affect how you view law enforcement or the court system in any way?
I have a bias against how his court is handled.
Okay. Thank you for your honesty. Do you think, is it possible that that might even unintentionally seep into how you view this case?
It's possible, but I think it would seep in that innocent until guilty.
Okay. So on the benefit of the defense.
Yes.
Your Honor, based on Juror 740's answer, they think they can, but without that unqualified ability to state that she can render an impartial verdict, the state would move to excuse 740 for cause.
Response from the defense.
Judge, I guess given that slightly unclear answer about whether she could or not, I'm sure she tried to do her best. I'm sure she would. I think I have to stipulate agree with the state.
All right, there's been a motion to strike the cause 740 from the state, not opposed by the defense. The court is likewise concerned that too much knowledge and information about this case may have led to a shifting of the burden against the presumption of innocence of the defendant. Again, it's nothing personal. Everybody's certainly entitled to follow the news. Many people do, and oftentimes draw opinions based on what they've seen. In this particular case, that would make it inappropriate for you to continue on as a juror. So you have faithfully concluded your service as a juror in this case. Thank you so much for taking the time you did to come in today, as well as filling out your questionnaire last week. You will be excused for cause, and please leave your copy of your questionnaire with the bailiff on your way out.
Thank you.
Thank you. All right, Mr. Bailiff, we'll have the remaining jurors return, please.
If there's something wrong, I can run.
Okay.
All right.
Thank you. Please be seated. All right, if I correctly organized my stack here, biggest number to smallest, we should have returning here jurors 686, 653, 647, 631, 536, 526, and 505. Did I catch all of your numbers there? Is there anybody here that I didn't call their number? Okay. Thank you for returning then. At this time, I'm going to ask, beginning with the state here, will the state pass these remaining jurors for cause?
Yes, Your Honor, thank you.
Does the defense pass this group for cause?
Yes, Your Honor.
Okay, thank you. I know it's been a long day for you. Ladies and gentlemen of the jury, you have been passed for cause. We'll continue to question additional groups of jurors until we reach the necessary number we need to exercise peremptory challenges. You're going to receive additional instructions through our jury commissioner, Randy Rutland, who will advise you of when you will be requested admonishment not to do anything to develop the bias in this case by investigating the case. Don't do any investigation of the case, look into the case, discuss your jury service with anyone other than to talk about potentially arranging schedules to provide for your jury service. And I'll be asking you to complete an admonishment when you return that you have followed that instruction and not investigated the case. If anybody wants to talk to you about the case, don't allow them to. And if they persist, you can report that to the court. With that in mind, then, I believe this group of jurors can be excused, awaiting further instructions on when you'll return. Anything else before we allow them to be released today from the state?
No, Your Honor, thank you.
From the defense?
No, Your Honor.
Okay, if everyone please rise, we'll let these jurors be excused.
This way, please.
Thank you. Please be seated. Council, we have another group lined up for tomorrow, 9 o'clock. Given the schedule and where we went today, the good news is we did go through a lot of jurors and get some available for peremptory challenge. It took a while, and we still need to get through questionnaires to be releasing jurors that simply aren't going to be able to serve, so we don't have so many being held up. So my proposition is to do that group at 9 and then work through some questionnaires and a few other additional matters the court needs to attend to. Does the state approve of that plan going forward for tomorrow's schedule?
Yes, Your Honor. If I might inquire if the court happens to have an idea of how many groups you'd like us to have ready to do the questionnaires.
Okay, I'll probably address that as an administrative matter off the record, and we can talk about that before we leave today. From the defense, are you okay with that time, Mr. Pryor?
Yes, I am.
Okay, we'll take up that group tomorrow then. We'll go off the record at this point, and I'll talk to counsel about preparation for jury questionnaire reviews tomorrow. That will conclude the proceedings. Thanks everyone for complying with the court's administrative order for the courtroom. We'll be in recess